6:04 a.m. on January 29, 2022, the alarm bell sounded in the Canton Fire Department. Firefighter paramedic Timothy Nuttall knew what that meant. His heart skipped a beat, he raced to his equipment, and he picked up his bag, which was meticulous. There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter paramedic, that means that a person's heart has stopped. He didn't know who it was, he didn't know where it was. He took his bag, he had just gotten to the station, and he rushed to the ambulance. He was one of the most senior paramedics that morning. Another paramedic, Anthony Flamati, would be running this mission. He jumped in the back of the ambulance, the door shut, and they headed off to 34th Fairview Road. As they drove, firefighter Nuttall could not see anything. He couldn't hear anything other than the engine of the ambulance. He could feel it sliding across the road. It was near blizzard conditions. He calmed himself, he steadied himself. This is what the firefighters and paramedics are trained to do, to focus. And he focused on his task. He looked around the back of the ambulance to make sure that all the tools were in place. The ambulance was meticulous as well. This was Anthony Flamati's ambulance, and it was well stocked. He calmed himself, and he thought about what was going to happen. What should he be looking for? What is his next steps? He played the scenarios through his mind, and eerie calm was above him. As the car pulled up to 34 Fairview, the ambulance, he stood at the back door, the doors open, and he stepped out into bedlam. He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around him. You will hear him tell you how he trudged towards those screams in the darkness to snow, and when he got there, he saw 3 women surrounding a man lying, not moving on the ground. He walked up to the man, and he reached down, and he tried to find any signs of life, pulse, anything, and he found nothing. And he got up and he walked over to the woman, and he walked over to that defendant, Karen Reed, and he told her that he thinks that that man is gone. And then he heard the yell from Anthony Flamati, the chief, and he said, "Come back, let's go." Because you'll learn that in the cold, even if somebody's heart stops, even if they're presumed to have passed, sometimes you can still save a life. So you'll see on a dash cam video, you'll hear through testimony, he went back to that man who's John O'Keefe. He went back to him, and that crew, coordinated effort, they did everything they could to save his life. They got on their knees, they began CPR, and firefighter Nuttall will explain as he kneeled over John O'Keefe, he looked up, and the defendant approached him, and you'll see it on the video. Now, he wanted any information, because when you're trying to save someone, you want to know, are they on drugs, medication, do they have a heart condition? And he looked up at Miss Reed, and he said, "What happened?" And you'll hear her words through firefighter Nuttall. She said, "I hit him, I hit him, I hit him." And it was at that time, with the words of the defendant, that she admitted what she had done that night, that she hit John O'Keefe. Now, those words didn't mean anything to firefighter Nuttall. They weren't in context, they didn't reconcile with the injuries, it didn't help him in his treatment, so he ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator, he is not a detective. He's a first responder. And so he takes that information, it was useless to him, he continues to work on John O'Keefe, trying to save his life. You'll see the team put him on a stretcher, and when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard, brown, frozen, and beneath his body lay his cell phone. They bring him to the ambulance, and while they're bringing him to the ambulance, you'll see on the videos that other first responders speak to the defendant. One first responder, Mr. Flamati, she will say, "I hit him, oh my God, I hit him." And then she was interviewed, or asked questions for background information, not a criminal investigation, just background to try to help John. And she was asked questions about his background, and during that conversation, you won't hear her see the defendant with a person by the name of Jen McCabe and a firefighter McLaughlin, and she tells Fire McLaughlin, the third first responder, I hit him. They bring Mr. O'Keefe to the Good Samaritan Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his core. And unfortunately, firefighter Nuttall's first instinct is accurate. John O'Keefe passes. So why are we here today? We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Karen Reed. You will learn through this case, through facts, science, and data, you will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in that dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out and he stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant in her SUV drove away. She drove at least 35 feet away. The argument was over. It had ended. But then she stopped. She stopped. She put the Lexus into neutral, and she waited for 2 seconds. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press, not 25%, not 50%, up to 75% acceleration. There was a light dusting of snow. The Lexus tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull. And there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded. Yet he was. And she simply drove away. Now, before I tell you about the data and the facts and the science, and I walk you through that, I'd like to tell you a little bit about John O'Keefe. John O'Keefe was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Peggy O'Keefe, John O'Keefe Sr., and the brother of Paul O'Keefe. Grew up in Canton, worked hard, he became a police officer. But what you're going to learn, the fact that he worked for the Boston police officer, as a Boston police officer, was just a fraction of his life. It was a small, really unimportant part, because the biggest part of John O'Keefe is he was a family man. Not in the traditional sense. You see, John O'Keefe never had biological children. John O'Keefe was never married. But John O'Keefe had a sister, and she had 2 children. And when the children were 6 and 3 years old, his sister unfortunately died. And shortly after, his sister's husband died. John O'Keefe was a helper. He didn't sit by. He saw these 2 recently orphaned children, and he stepped in and he said he was going to raise them. So he put aside his career, he put aside his job, and he moved in with the children and raised them like they were his own. They were his passions, his love. He was a new parent, successes, failures, like all parents. And he raised the children with the help of people in the community, with the help of his brother, with the help of his family. And they led a good life. Enter Karen Reed. Around COVID, the defendant and Mr. O'Keefe reacquainted, and they started a relationship. And you'll hear that even though the defendant had her own home, she was staying with Mr. O'Keefe a lot, 4, 5, 6 times a week. And to most of the world, it was a pretty good relationship. They spent time together, They did activities with the children together. She helped with driving the children, feeding the children. It was a steady relationship until about the beginning of 2022. And then things began to unravel. There was tension. There was arguments. In fact, just a few days before this incident, you'll hear that Mr. O'Keefe asked her to leave. But she wouldn't. You're going to be able to read text messages of their conversations on January 28, 2022, and you will see the tension and the unraveling of the relationship. You will read about the discord between the defendant and Mr. O'Keefe. You will see that when he would ignore her calls, they would become incessant. When he would try to push away, she would come closer. You will read those text messages and you will realize that this was the beginning of the end of this relationship. That night, they decided they would go out together. I want to tell you something about data and science before we get to that night. I mentioned that underneath John's body was a cell phone. A cell phone is an amazing piece of technology. It is like a computer. It carries extraordinary data. And when they found the cell phone, the only companion to John O'Keefe that night, they studied the cell phone, and there'll be some remarkable data that you will use in this case to find the truth. I want to mention 3 different things you will find in a cell phone that are critical to this case. The first is called location data. Waze we've all heard of, Google Maps. Well, at some point that night, John put his Waze on. And Waze is like a breadcrumb that will show exactly where the phone goes second by second. It is the strongest, most accurate location data that you can have. And that night, John was using Waze. It also will have healthcare data. Healthcare data will show when somebody is moving. Sometimes it's qualified as steps, but it doesn't necessarily mean somebody's stepping. Moving their arms, walking, turning. It doesn't show what direction or how far, but it shows movement of a person. Healthcare data. And the third thing, remarkably, will be an expert in this case who found a data file on the phone, and it tracks the temperature of the cell phone battery. That will be critical to your analysis in this case, the temperature of the cell phone battery. And so with that, I want to take you back to the timeline of that night. After the discord, both the defendant and Mr. O'Keefe decided they would meet at a bar called McCarthy's. Now, McCarthy's is a local bar, a blizzard is pending, and people are getting together in a celebratory mood. They go to McCarthy's, and you'll see a video of McCarthy's, and you will watch both Mr. O'Keefe, friends, and the defendant drinking alcohol. And you will count 8 vodka drinks that the defendant drank. They arrived at 8:50, they stayed till 9:45. She consumed at least 7 of those drinks in less than 2 hours. The last drink, you'll see when they leave the bar, she puts it under her jacket, and they walk out and they go to another bar to meet other friends called the Waterfall. They reach the Waterfall sometime around 10 p.m. And when they go into the Waterfall, you'll see a video. And when I said celebratory mood, you will see a group of friends of John O'Keefe, many who are friends with Karen through John, and you'll see them clapping and happy and joyous that they're there. You'll see many hugs between John O'Keefe and his friends and the defendant and many of the people there. And they spend some time together, there's drinking, and they all do a shot. And that will be at least the 8th drink within 3 hours that you consume. You will see from the data, not just the cell phone data, but there's some other very important data. And the other piece of data that goes hand in glove with the cell phone is information on the defendant's Lexus vehicle chips. You might have heard of black box in an airplane, where there's some type of event that captures a small amount of time. Well, that was captured in the defendant's Lexus. That black box information with the cell phone data will tell you everything you need to know in this case. It will bring us step by step through the entire night to the death of John O'Keefe. And so they leave the Waterfall Bar at 12:12, and you'll see that the ignition goes on. to the defendant's Lexus. And both John O'Keefe and the defendant in the car, and they decide that they're going to go back to 34 Fairview Road, where we talked about earlier. They're going to go there for a get-together for one of the homeowner's sons who's having a birthday party. And so as they drive back, you will be able to follow them with this location data. When they go back to Fairview, they don't know exactly where it is, and they get lost. And so John O'Keefe makes a phone call, has a phone call with one of his friends, Jen McCabe. And during that phone call, which the defendant listens to because she recounts it, in trying to get directions, Jen McCabe tells John O'Keefe, it's near Bella's mom's house. You'll learn that Bella, or her mom, was somebody that John had dated before the school. And so as they make their way through Fairview, you will see there's a road that comes down like a loop and that leads to Fairview. They take a wrong turn on the loop, and then they do a three-point turn in the driveway. You'll see the exact precise driveway they turn into because some type of acceleration movement triggered that black box in the Lexus. And that's important because that's 7 minutes before the collision. And you'll see from the waves exactly where the car was. You'll see from the black box the event of the three-point turn in the driveway, and then a return down to Fairview. But before they get there, at 12:23, a truck is coming the other way. And the witnesses in that truck will say they blinked the lights. One of them saw a man and woman in the car, John and the defendant, and then they followed the Lexus because they were going to the same house. The truck stopped at the driveway, and the Lexus, the defendant's car, will appear because of the waves and be counted second to second, never stops. It rolls very slowly all the way to the end of the yard in the corner where there's a tree line and a flagpole. And they reach that location at 12:34:33. And they're in the car and they stay there. The truck waits, they speak to somebody in the house who comes out, the person goes back in the house and they're there for about 5 minutes. We're now down to 2 minutes before the collision. The truck leaves, and now it's just the defendant and John. And while they're waiting outside at 12:27, John gets a text from Jen McCabe. Park behind us in the driveway. 12:29, she texts again. Are you coming in? You'll hear that Jen McCabe and others look out the window and see the defendant's Lexus in front of the flagpole at the far end. It's snowy, it's dark, it's windy, they're waiting. You will know that John O'Keefe was in that car, that Lexus, and didn't move because his healthcare data is not moving. It's not moving until 12:31:56. At 12:31:56, he begins to move. He will have 20 seconds before he falls. 20 seconds. He gets out of the car, the Lexus, and in that 20 seconds, you'll hear that user initiated. He looks at the phone, at the text message from Jen McCabe. It is now 12:32:09. He closes the phone the last time. It will be the last time he uses that phone. From the waterfall bar, you see that he keeps it in his back pocket. And at that time, 12:32:09, last user, he has 7 more seconds he will move before he lies dormant the rest of the night. We'll also have the information from the defendant's Lexus black box. Now, the clocks run differently. There's a 30-second variance, but it's right in the heart of that time. And you will see through the data at that time, when he makes his last movements with the phone, is when her car leaves 34 feet at least, stops, neutral, and then shoots into reverse with the tires spinning right towards him, right where he got out. You'll know they're arguing because the next morning she tells the firefighter, I'm sad because our last moments were fighting. She drives away. They said she's made later statements that when she left, he didn't look mortally wounded. He lied on the ground on top of his phone, light dusting of snow, the snow now picking up. And he's just there. It's 12:37. Now, when he's in the car, before he gets to Fairview, the battery temperature of that phone is 77 degrees. 77 degrees in the warm car. Navity's been outside the car for 5 minutes. Drops at 12:33 after she's left therapy. She calls again at 12:33 and leaves a message. You'll hear it. And you will hear the anger and rage in her voice. She leaves a message. John, I fucking hate you. You will hear the simmering. Message, he lies. Gets another. Hey, where are you? Also the defendant that night. John alone. At 12:53, cell phone drops to almost 60 degrees. 12:59, the defendant leaves another message. Knew he was there. She did not call 911. She did not go back to him. She did not leave an anonymous. Bears on. It's now 1:07. She calls her mother. No answer. Around that time. You later learn that she admits to falling asleep and passing out. But then she wakes. It's 5 o'clock. She is frantic. She wakes up John's niece, and she is unintelligible. She is yelling, she's screaming. She asks for the niece to call Jen McCabe. She calls Jen McCabe, and you'll hear Jen McCabe recount. Out of a deep sleep, she wakes up and she hears, Jen, Jen, Jen. Screaming Jen's name. John's dead. Hangs up the phone. Jen McCabe calls back. And then she says, what's going on? And she's told, well, I left him at the waterfall. At the beginning of her. She tells Jen McCabe, I left him at the waterfall. Jen calls back and says, you saw him go up front. You did leave him at the waterfall. She hangs up. She then minutes later calls another person, Terry Roberts, a friend of John O'Keefe. Someone who's not friends with the defendant, but they know because they helped raise the kids and they interacted. She had nothing to do with the night before, wasn't at the bars, was home with her family. She calls her and says, I think John got hit by a plow. I think he's dead. Now Terry, with that information, calls 911. She calls hospitals. You can hear her voice. She's concerned. Not him. And then she gets another call from the defendant. And she tells the defendant, come to my house. I will help you look for him. And the defendant says, I was so drunk last night, I don't remember anything. Waiting for her to arrive, she learns she doesn't arrive. Instead, the defendant goes to Jen McCabe's house. Terry Roberts, the other friend, then goes to Jen McCabe's house, pulls behind the car. And when she does, she's on Bluetooth, and she can hear the defendant say, my taillight's broken, my taillight's broken. And she looks, and the snow packed in the right taillight, she can see a piece of the taillight missing. The defendant desperately wants to go to 34th Fairview Road, but Terry Roberts takes over and says, we're going to go back to John's house. Maybe he's in the house and you didn't see him. So both cars, driven by Terry Roberts and then Jen McCabe, with the defendant, go back to John O'Keefe's house. You'll see a ring video where you see them go into the house and they look around, and you'll hear about the woman, Jen and Terry, enlisted into this task. Look for John O'Keefe. They cannot find him. And then when Terry Roberts comes into a room, she sees, rather than looking, the defendant simply standing there, staring at the wall. At that point, the defendant insists they got to go back to Fairview Road. They decide to take one car. Carrie Roberts is taking charge. She's going to drive. They leave Miss Reed's Lexus and John Keith's driveway, and they drive back towards 34 Fairview Road. There, it is blizzard-like conditions. It is dark. They can barely see a thing. And when they get close to the edge of 34 Fairview, you hear the defendant start to scream, "There he is!" Both women look and they can't see anything. She starts kicking the door. The defendant's kicking the door. "Let me out." Carrie Roberts stops the car and lets her out, and she sees the defendant run exactly to where John O'Keefe is in the darkness, just where she left him. Carrie gets out of the car, starts to walk towards where the defendant is, and she sees the defendant lying on a body. She can't tell who it is because the face is still covered with snow. And she comes over and looks, and she wipes off the snow from John O'Keefe's face. She realizes he's one of her best friends in the world is John O'Keefe. And she starts to try to do first aid. They start to move him, and coincidentally at 6:06 when they start to move him, the cold air hits that cell phone battery. It drops from 50 to 43 degrees. And they try, Jen McCabe calls 911. And that's when a police officer arrives, firefighter Nuttall and his crew. And when they lift him, that cell phone battery that is shot down to 37 degrees, Carrie Roberts picks it up and puts it in her pocket, and it immediately starts to warm. As she moves to help get a data, showing movement starts again. At that point, nobody knows what happened. The Canton Police Department come. You can see the police cars and cruisers. They're not sure, so they look in the area where John's body is and find a glass from the bar near his body. They find blood spots. They try to put the blood spots in plastic containers. They don't know what they're looking for at this point. There's no information. They don't believe or know that there's a crime. They just know that John O'Keefe somehow ended up here with the broken glass and the blood. And so that morning, you can see the work of Carrie Roberts goes and picks up Peg O'Keefe, tells her the news, and they go to the hospital. They go to the Good Samaritan Hospital, and Carrie Roberts is walking, and Peggy O'Keefe is going to go see her son from her husband. And as she walks down the hall, Karen Reed is also at the hospital. See, there was some reports of maybe she was upset or suicidal, so they sectioned her. They put her in for evaluation to make sure she was safe. You'll hear Peg O'Keefe tell her she walked down. The defendant was screaming, "Is he dead? Is he dead?" As she walked by Karen Reed, she stopped and she said, "Karen, what happened?" And you'll hear that Karen was excited and yelling, "Is he dead?" She stops her excitement, becomes stoic, doesn't say a word. Peggy pays respects to her son, and then she has to go back home because she has to tell the children. Now, while she's out, the Canton Police Department sent an officer to the house to make sure the children are safe because they're alone if they're home. And when the officer pulls in, he doesn't notice anything, but you'll see in the dash cam video notices something. That tail light has a big missing piece to it. They can't find the children. Ultimately, Peggy comes home, a friend can take it down, and they bring the nephew home, and he is distraught. And then Peggy hears a knock on the door. It is the defendant and her father. They want to come in. They come in, no condolences to Peggy. And they ask, "Can we go upstairs to John's room?" And she's busy consoling her grandson. They go upstairs. They're upstairs for about 15 minutes. They come down, and quickly they leave. Now they got there from the defendant's father, drove his wife and the father to that house. But when they leave, they take two cars. They take the Lexus with the broken tail light with them back to the defendant's father's house. And And you will learn that when police start getting some of the information, they learn about the broken tail light, they learn information that she had told people that she had hit him. They went down to see her. And on their way down, they decided they would get a warrant to take the Lexus. When they get down to Dighton, where the car is, you'll hear from Trooper Buchanan. He took a look and you could see the missing tail light. They went in and spoke briefly to the defendant. They took the car, they brought it back to Canton. And so what you'll learn from the forensic evidence that will help with the science and data is that not only was the cell phone left behind, but also around that area, broken tail light was littered around John Oakey's body. Littered around that area. When they got into the hospital, they noticed there was a shoe missing. As time went by, snow melted, they dug with excavations, they found his shoe on a little berm on the border between the street and the grass. You'll learn days later when they did a plant excavation, they found his hat frozen into the ground. Ultimately, they would find over the course of 10 days that the snow melted almost all, every piece of that broken tail light in that area. His hat, the sneaker, the glass. When the defendant left Mr. O'Keefe behind, took with her something of Mr. O'Keefe called trace evidence. You'll learn on the back of her Lexus, around the taillight area, was John's DNA, and stuck to the side, grasping one last piece of John O'Keefe's hair. Now, John O'Keefe fell backwards and hit his head after he was clipped by the car. And you're going to hear from a very renowned doctor, a neurosurgeon, who has treated thousands and thousands of head injuries. And the wound on the back of the head, when he fell backwards, on the cracked skull, it's called a basal fracture. It created an injury called counter-coup. After he was clipped by a car and fell backwards and hit his head on that hard rock ground, remember there's no snow, it's just a dusting at this point, the back of his brain hits the back of his skull and bounces up. When it bounces up, it leaves marks showing that impact. And this neurosurgeon will tell you, treated thousands of patients, that this injury, to a reasonable degree of medical certainty, is counter-coup caused by falling backwards and hitting your head. When the medical examiner for the state looked at it, they generally said blunt force trauma. They had it as undetermined. So we brought it to the renowned neurosurgeon who does exactly this. You're also going to hear from an accident reconstruction. He was hired to take a look at this case and the data. He will come in and explain to you exactly what I talked about, how the data from that black box coincides with the cell phone and the movements of the car, the moments before, during, and after the defendant struck. Now, just a few more things I want to share with you. There are 3 charges against the defendant in this case. The first one, second-degree murder. When most people hear murder, they instantly think shooting somebody, stabbing somebody, killing, deliberate premeditation. Our Honor will instruct you on the law. I'm not going to trample in that area, but I can tell you clearly we are not going to try to prove that Karen Reed tried to kill John O'Keefe. We're not going to try to prove to you that she intended or wanted him dead. That's not second-degree murder. What we'll prove to you is she engaged in an intentional act, driving back at him at that speed, in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act would cause a plain, strong likelihood of death. That's what we'll prove to you for second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove to you that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused his death. The third charge is being seen after knowingly causing death. Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left him behind. And he died. That's what we'll prove. This case will come down to the science and the data. The science and the data, the cell phone is the best of historians. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't suffer from emotion, pride, or prejudice. It is facts. It is data. And that facts and data will lead you to the truth in this case. But after Ms. Reed was charged, she began what you'll learn as a campaign. A campaign to make public statements. 2020, Nightline, Fox 25, a documentary. And we've had an opportunity to get many of her statements in the footage, and we're going to show much of it to you. And her statements to you will confirm what you already know from the science and the data, what you will already conclude from the facts independent about what she did that night. Her word simply confirmed. And you're going to hear from her own lips in many of her statements, her admissions to extraordinary intoxications, her admissions to driving in the Alexis, her admissions to being angry at dawn that night. And as I say, her admissions that she told I'd like to play for you clip one.
He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth. That on January 29, 2022, a very intoxicated defendant was angry and arguing about the relationship with John O'Keefe. And after the fight was over, she left, but she brought the fight back to him in the form of her SUV. She clipped him, he fell backwards, he broke his head, and then this man who helped, a lifetime of help, was left at the corner of that yard, left to die with no help. The facts, the data, and the evidence will bring you the truth, and the defendant's own words will confirm everything you've already concluded.
All right, thank you, Mr. Jackson.
Could I have just a moment to readjust?
Sure, the court officers will be kind enough to help you.
May I, Your Honor? The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle. Period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up sitting in that chair on trial for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer named Michael Proctor. He was the lead investigator on this case, and he was talking about a fellow officer, a fellow cop, who who owned the property where John O'Keefe's body was found. Text message with a buddy. Question, is the homeowner going to catch any shit? Answer, nope. He's a Boston cop too. That quote defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic and tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. They won't be able to excuse their way out of it. And they can't meet their extreme burden of proof, which the court will tell you is beyond any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on, fire engines, ladder trucks, paramedics, patrol vehicles, patrol cruisers, police officers, first responders, firefighters, all swarming all over Brian Albert's lawn. Literally feet under his bedroom window. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could assist a man in need, never walked outside his house to see if he could help a fallen fellow officer on his own front lawn. More shockingly, you'll learn that lead investigator for the Massachusetts police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood. Michael Proctor never did any of these things, even though fellow officers of Michael Proctor's actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight. You'll have questions about that conduct. During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation, it's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. And his name is Michael Proctor. Now, you didn't hear his name in the prosecution's opening statement. Not once. And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution, you'll learn there's not a single part of this case, folks, not a single part, that he didn't touch, that he didn't direct, that he didn't orchestrate personally. Every single bit of it has his fingerprints on it. You'll learn that Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found him guilty, found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case. The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. Do you have any idea how hard it is for a state trooper to get fired? Well, the evidence is going to show that Michael Proctor earned it. Every bit of it. You'll hear that within hours of a Boston police officer being found dead on Brian Albert's lawn, Michael Proctor, the lead investigator, who had investigated exactly nothing up to this at the beginning, made an early pronouncement that Brian Albert himself was not going to, quote, catch any shit, end quote. And that was for one reason, and one reason only. He's a Boston cop. The evidence will show that Michael Proctor made this statement in a text conversation with his high school buddies. A text he never thought would see the light of day, certainly never thought we would get a hold of. And when he thought no one was looking, he actually said the quiet part out loud. He's a cop too. We'll give him a pass. You'll learn that Michael Proctor's rank has its privileges. And the evidence will show that's privileges that you don't get and I don't get. But apparently a Boston police officer and his friends, they do get. You'll learn that in Michael Proctor's world, he didn't care about finding the truth. In his world, his priority was to protect the brotherhood, to protect that blue wall, to protect his friends who were at the Alberts' house that night. I want to take a step back, if I could, and spend the next few minutes talking a little bit more detail about what the actual facts in this case will show, not based on speculation, not based on surmise, not based on guesswork or conjecture, but the actual true facts that you will learn through the course of this trial. On January 28th, 2022, it was a Friday night. John and Karen had made plans to meet up with friends for drinks. It was a happy and normal night for them. They were affectionate, they were loving, they were in good spirits, nothing out of the ordinary. They started at a local watering hole called C.F. McCarthy's. You've heard that name before and you'll hear it again. And eventually they made their way over to the Waterfall Bar and Grill, another bar where they ended up. When they got to the Waterfall Bar and Grill, the Albert family was already there, already heavily drinking. You'll learn that this was no ordinary family, the Alberts. The Albert family was a well-known Canton family. Some might even describe them as a very powerful Canton family. Brian Albert was there at the waterfall. You'll hear that he's a longtime Boston police officer. His wife, Nicole Albert, was there with him. His brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter, Caitlin Albert, was there. His sister-in-law, Jennifer McCabe, was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man by the name of Brian Higgins, also a law enforcement officer and longtime friend, longtime pal of Brian Albert, he was also there. And the two of them, the two Bryans, had been drinking most of the night together. You'll see video footage from the waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier she had put a stop to it. She had ghosted him, in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the Waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. As the bar was closing around 12 midnight, the Alberts invited everybody back to their house for a get-together to just keep the night going. And you'll learn that Karen and John ultimately pulled up to the house. They got out of the SUV to make sure they had the right address. You see, neither John nor Karen had ever been to 34 Fairview. They weren't even sure they were at the right address. And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally, the data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Eyewitnesses and forensic data will establish that fact. When he didn't come back out, you'll learn that Karen grew increasingly frustrated. She got upset. She was left alone in a car, in the cold, in the middle of the night, with the car idling. John had gone into the house. She expected him to come right back out, and when he didn't, seconds turned into minutes, and minutes started to clock away. She left John a voicemail, then another voicemail, voicemail after voicemail after voicemail, text messages. But he was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. The Commonwealth will intimate, as they already have in their opening statement, that these voicemails are evidence that the two were fighting. The actual evidence in this case, however, will show the exact opposite. You'll hear that Karen was very agitated. You'll hear some voicemails where she's swearing. You'll hear voicemails where she calls him names. There's name calling. But you'll also hear the context of those voicemails. And every single one of them, every single one of those voicemails was left for John after he failed to come back out of the house, after he failed to respond to her voicemails and to her texts. Karen believed John had just left her sitting there, grabbed a beer, was partying with his friends. The evidence will actually show that John and Karen never had a crossword, not a single crossword that entire evening before he left that SUV and went inside the house. And you will learn what Karen had absolutely no way of knowing at the time. It wasn't that he wouldn't respond to her. It's that he couldn't respond to her. And the evidence will show you why. Let's talk about that. We'll introduce you to a doctor named Elizabeth Lopesada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege. His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage. based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence will establish that John O'Keefe had to be injured somewhere else, somewhere warmer, and his body had to have been moved out into the cold. And that's where, ultimately at 6 a.m., Karen found him the next morning. You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car. Not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Dr. LaPosada will tell you with medical certainty that, in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're not the result of being struck by a car or a taillight. You'll take one look at these injuries and you'll agree with Dr. LaPosada. The evidence will show that these injuries are from an animal, like a large dog, like the large dog that was inside the Albert house that night. You'll learn that Brian Albert has actually admitted that his large dog, the family dog, is, quote, not good with strangers. And of course, John, never having been to the house before, was a stranger that night. You'll also learn that oddly, very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her. But she was gone. Dr. LaPosada will also tell you that the injury to John's head was not the result of falling backward onto a flat lawn, cold or otherwise. Rather, Dr. LaPosada will tell you with medical certainty that the injury pattern to his scalp was produced by an impact from a raised or ledged surface, a surface that does not exist on Brian Albert's front lawn where John was found. The medical evidence will establish no hypothermia, no injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brennan mentioned that in his opening statement. The Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone is reasonable doubt, but there's much more. You'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door just feet from where John O'Keefe's body would have ultimately been, had he actually been there, right after 12:30 a.m., which is what the Commonwealth's claim is. There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person, saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house, and still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness, charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, oh, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth, and he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did, and we found, and we'll introduce you to, Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll learn that Brian Loughran passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot precisely where Karen would later find John's body laying at 6 a.m., there was a car parked in front of it, a Ford Edge. You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road? You'll learn that Michael Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge, but again, we did. And the evidence will establish that a Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time. You'll learn that those facts will add to the mounting and the overwhelming evidence that there was no collision and John O'Keefe's body was moved onto that lawn. You'll find that this is yet additional reasonable doubt in the case. You'll be introduced to science and physics, even from the Commonwealth's own experts. That science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. The Commonwealth mentioned triggering events, but what you'll actually learn from the experts, some of them the Commonwealth's own experts, is that a triggering event is not evidence of an accident. It does not evidence a collision. That's why we're here. A collision. And there's no evidence of one. Zero. You'll also find that those exact sort of triggering events that the Commonwealth will rely on are relatively commonplace on Karen's SUV, and none of them are associated with a claim of a collision. Folks, the science will not lie, and the physics cannot lie. And that science will tell you with certainty there was no collision with John O'Keefe. You'll add that to that rising mountain of reasonable doubt. I want to take you back to the night in question, January 29th, for just a few minutes. Remember, Karen had gone home after dropping off John and John walking to the house. While Karen was asleep at home with John's 13-year-old niece, what were the people who had been at Brian Albert's house that night? What were they doing? While she slept, what you'll find and what the evidence will show is that they were extremely busy. You'll learn that after a long night of heavy drinking, Brian Higgins left the Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late-night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that, too, is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins at 2:22 a.m. Shortly after Higgins completed that late-night visit over to Canton PD. You'll wonder, what did they possibly need to talk about at 2:22 a.m. that night? The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds, had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it. Both of them. They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation. A butt dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m.? And why did they both try to cover up that phone call? You'll also learn after this incident and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn Brian Albert got rid of? Shortly after this incident, Brian Albert got rid of his house, the whole thing. Just sold it. His childhood home, a home that had been in the Albert family for generations, he literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you. He pre-selected Karen Reed from the start, and he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe, she was at the waterfall that night, and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence from a forensic software program called Physical Analyzer made by Celebrite, it's considered the gold standard for forensic tools, you'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold. Now, she misspelled the first word. Hos is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Time-stamped 2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees. 1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone, Hoslong to die in cold, hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, that area was obstructed by a Ford Edge like the one the Albert family liked to own. The evidence will show in the meantime, Karen dozed in and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m., and that's when she realized, in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear evidence that Karen's emotions had morphed. It'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear. Fear that something bad had happened. The evidence will establish by this time Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus, and she backed up to leave her garage at One Meadows. You'll hear a lot about that address, One Meadows. That was John's house, where Karen was staying. She backed out of the garage, and during the course of the trial, you'll hear that she actually struck another car with that right rear taillight. During the course of this trial, the Commonwealth is going to desperately claim that Karen Reed's taillight was actually damaged by hitting John O'Keefe. They'll have no evidence of it, mind you, none, but they'll make the claim. We'll show you a video of exactly how that taillight was originally damaged, or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another car in the driveway. This is 5 hours after she dropped John off and he went into the Albert residence. As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered. And you won't have to speculate how that taillight got cracked originally. You'll see it for yourself. It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panic-stricken and grief-stricken. Where was John? Why hadn't he come home? What had happened to him? Is he hurt? Is he passed out somewhere? Her mind was reeling. The evidence will establish she wasn't giving anything away. Everything was on the table. What could have happened to John? You'll learn that when she woke up and he still wasn't home, she was just racking her brain for what could have happened to him, and she was worried about possibly the worst. He had gotten out of the car. He'd walked to the house. She was confused. And later, when she found him at 6 a.m. on the lawn, where she last saw him going toward the house, her mind started reeling, oh my God, did a plow hit him? Did I hit him? Could I have hit him? What could have happened to him? And that video clip that you saw, out of context, when she said the words, he did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him. That's what she was talking about. Your job will be to make sure that the evidence isn't presented to you too cute by half. She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other, a woman desperately trying to piece together what could have happened on this tragic night. John didn't come home. And the evidence will show that Karen Reed never said, I hit him. Never. Not in the background of the 911 recording, not on any dash cam video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that there were at least 13 members of law enforcement or first responders and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Sarath, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Carrie Roberts, Jennifer McCabe. They were all there, watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, "I hit him." Not one. Not one civilian reported having heard Karen Reed say, "I hit him." The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this. In an interview coordinated by a Canton police detective named Kevin Albert. Brian Albert's brother. And remember, Chris Albert, the other brother, is a board selectman to whom the Canton Police Department reports. And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years-long, close personal friends with a young woman named Caitlin Albert. You heard that right. It's Brian Albert's daughter. During the course of this trial, you'll become familiar with and you'll realize that the Alberts are indeed a powerful and indeed an influential family. And that will mean something. You'll learn that there are other major problems with the prosecution's case. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn. That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption. And you'll see how far it went. Michael Proctor was alone with all the critical evidence in this case, alone with Karen Reed's phone, alone with John's phone, alone with video footage, alone with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants. He transported the evidence. He secured it. He submitted it. He did it all. That's Michael Proctor. And he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants, he lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were 2 searches. The first and second search found 0. Nothing. Nothing around John's body. Nothing in the street. Not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up. And not just a few items. 46 pieces of bright red taillight laying in the snow. Supposedly found in the exact same spot that was searched not once, but twice by independent officers. It came up with 0. To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become vitally, vitally important. And what about those shards of plastic, by the way? What about this DNA that the Commonwealth mentioned? They're going to try to dazzle you with talk of DNA because it sounds so scientific. DNA was on the taillight. But you'll learn that there was no DNA on the actual shards that they claim came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. The DNA that was actually found, the actual science will show, was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found, John and 2 unidentified males. So unless the Commonwealth is going to shift their theory that that SUV hit 3 men that night, their entire theory falls apart. And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5, count them, 5 unidentified males. Recall that the evidence will establish independently that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe. You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. But they're nonetheless back again trying to present the exact same theory to you in this trial. Again, the evidence will show that that is reasonable doubt. Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing. But all that smoke and all those mirrors will not ever reach their burden. Because that's what this case is ultimately about. It's about the Commonwealth's burden proof. You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the House and the utter lack of investigation speaks volumes about those who actually have something to hide. By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all 3 of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty. Thank you.
Thank you, Mr. Jackson. Folks, why don't we take our morning recess? We'll see about 15 minutes.
Court order, please. First roll call, name.
You are muted.
Good morning.
Good morning.
Before you take us back to Fairview Road, I want to ask you a couple of questions about John's house at Meadows. Are you familiar with his house?
Yes.
Have you seen the front of his house before?
Yes, I have.
Are you familiar with his driveway?
Yes.
Are you familiar with whether there's any surveillance system at Mr. O'Keefe's house?
Yes.
May I approach, Your Honor?
Yes.
Ms. McCabe, I'm showing you what has been previously marked as Exhibit 6. Do you recognize that photo?
Yes, I do.
And what is it?
That's John O'Keefe's house.
Could we provide Exhibit 6 for the jury, please? On that screen, is that Mr. O'Keefe's home?
Yes.
I'm showing you what's been marked as Exhibit 8. Do you recognize that?
Yes.
And what is it?
That is the side of Mr. O'Keefe's house, the two garage doors.
Is there any indication of surveillance?
Is this a Ring camera right here? Looks,
Is that what John O'Keefe's side of his house looks like?
yes.
I want to show you Exhibit 10. Do you recognize what's in that photo?
Yes.
What is it?
It is the driveway at John O'Keefe's.
You see a car to the left?
Yes.
Do you know whose car that is?
Yes, that's Miss Reed's.
Is that where you left it the night before? Those early morning hours when you drove to Mr. O'Keefe's house?
Yes.
I want to show you what's been marked as Exhibit 11. Do you recognize what's in that photo?
Yes, Miss Reed's vehicle.
Is that the vehicle that Ms. Reed showed you with the broken missing taillight that morning?
Yes, it is.
You mentioned earlier in the night you spoke to John O'Keefe when you called him or he called you about directions to Fairview Road.
Yes.
And you also shared that you had a phone conversation offering directions.
Yes, I did.
Did you tell John that the house at Fairview was near Bella's mom's house?
Sustained is to form, Mr. Brennan.
Okay. What did you tell John as far as directions to Fairview? How did you mark it for him?
I told him to go by, past Bella's house, the Bella's Street, and then to follow it down to the end.
Now I want you to take us back where we were yesterday when we left off. You had brought us to Fairview Road. You had found John.
Yes.
You shared with us that you were trying chest compressions. Before the chest compressions, did you make a phone call?
I called 911.
I'd like to move to introduce a copy of that 911 call.
Okay. Do you have something physically to... Thank you.
Ms. McLaughlin does.
Thank you.
With,
Thank you.
with the court's permission, I'd like to play Exhibit 45.
Yes.
No, this is for what emergency.
Yes, I need someone to come to 34 Fairview Road in Canton, Mass. There's a man passed out in the snow.
You can't hold on, but you can't say so. You connected to no, okay?
Yeah, I don't know why I said that.
You have to tell us, right? Stay on.
I can keep going, like, these are the area in 60, okay?
I'm trying to stay on, I'm trying to stay on.
Okay. I know. Where's the budget? I don't think the light is turning.
911, what's your emergency?
I need someone to come immediately to 34 Fairview Road, Canton, Mass.
What's going on?
There's a guy unresponsive in the snow.
In the snow, 34?
Yes, 34, the Albert resident, yes. I just pulled up behind him.
Okay, 34 Fairview?
34 Fairview, Canton, Mass, yes.
911, that's not your order, where's your emergency?
I don't know.
Hello?
Yes, I'm sorry. Can you come to 34 34 Fairview Road in Houston.
34 Fairview?
Yes, there's a man unresponsive in the snow.
Okay. Did he, what else?
He's got to get here, okay?
Okay, what's going on? Is he face down?
We just flipped him over.
Okay. And who's that in the background? Is that someone related?
That's his girlfriend. His name is John Cleese.
Okay, how old is he?
John is 46 years old.
46. How long has he been outside?
I don't know. I don't know. He got out of the car and it could have been a couple of hours. Is he Carrie? Is he? I don't. I don't know if he's breathing. There are two women trying to use body heat and they're hysterical.
Okay, can you just try to ask him? I know it's tough, but we have the fire department going. They just got to know.
Okay. Is he breathing, you guys? It doesn't seem to be breathing.
Okay, do they know how to do CPR? Do they want to attempt CPR?
Yes, you guys do CPR. No, I guess he's gone.
Okay, they don't feel comfortable doing so?
No, I think he's passed away.
Okay. All right, we have the fire department and the police department on the way. If everyone's declining CPR, then I'll hang up with you, and if anything changes, you can give us a call back. Where are you guys outside?
I'm right up front of the car. I know, I'm on the phone with the Andrews. I know, honey, I know. Just, Carrie, you gotta get off of me. Carrie, you gotta get off of him.
You know if there's any alcohol or drugs involved?
He has been out,
They've been out drinking.
Yes, like I'm talking hours about maybe, and I think he's, I don't know how long he's been in the snow.
Okay, is there any bleeding or anything? Maybe his head out?
Yes, possibly, I think he's bleeding in the face.
Okay, bleeding from the face. All right.
Yes.
And how big's the pool of blood, if there is any?
Something's coming out the nose, and one of the women is doing CPR.
Okay, one of them is doing CPR?
Yes, they're both working on him.
All right, if you want CPR, and just let me, just give us a call back if he becomes responsive, right? But we're on the way.
Okay, thank you.
Ms. McCabe, describe your mental state when you were speaking to 911.
I guess the best way to describe it was I was in shock. My heart was racing. I was trying to be as helpful as I could and get the information to the most important information out as quick as I could to the 911 operators. But also the scene there with Karen and Kerry was a bit chaotic between the two of them. So I was just trying my best to be as calm as I could, to get help there as fast as I could, and to answer their questions the best that I could.
Before you told the 911 operator John O'Keefe's name and his age, you said there's a man in the snow. Do you know why you chose those words?
I think I just wanted to get out the most specific details. So a man in the snow versus, John O'Keefe and into a story. I think I just was get the details to them as fast as possible to get help there to him as fast as possible.
When you told the 911 operator that your friend John O'Keefe was the person lying in the snow, how did you know his age?
We used to joke because he was a couple months older than me. So I would, say, oh, well, you're older than me. It was a silly little thing between friends.
When you called the 911 operator, had Kerry and the defendant already been around or near John?
Yes.
Do you know if they had begun trying CPR before you called 911?
I'm not sure if they had, because Karen had straddled him and lifted her shirt, was warming him up, and then Kerry was yelling at her to get off. And I think when Kerry got the blankets and was trying to put him under John, I think as she started to move him and wipe him, blood started to come out. And then Karen was afraid that he was going to choke on his blood and wanted to move him on his side. But then Kerry was yelling at her, we can't move him. And this was kind of all going on while I was talking to 911.
You described what you saw, and you said at some point he was bleeding from the face area. Was that before or after he was moved?
After.
Before he was moved, did you see any active bleeding?
No.
After you called 911, what do you do next?
I think I called my sister, and she didn't answer. And then, as I think I called her as I was walking over to John, and she didn't answer. And then I immediately got down on the ground, and Kerry Roberts asked me to take over.
How long did you try to help John for?
I'm not sure. I'm not sure.
How long were you and the defendant and Miss Roberts there before someone else arrived?
Police officer was the first to arrive. In the moments, it seemed like a long time, but I think it was fairly quick that they arrived.
Any point during the time when you tried to help Mr. O'Keefe and the first police officer arrived, at any point did you see any signs of life from Mr. O'Keefe?
No.
When the police officer first arrived, do you remember what happened next?
I remember it was very chaotic, but there was talk about a spotlight. And I remember, I think I got up and ran to kind of wave the, to get the police officer's attention so he could see where we were.
And then what happens?
The police officer, not sure specific, I do remember him asking about John. I think he said, is he a drug user? He was just asking some basic questions.
And what's the environment? What's going on around you?
Karen's just running around crazy, like just yelling, screaming, kind of like a ping pong.
What are you trying to do?
I was just trying to talk to the officer. I guess I just went into this like type of mode of, all right, I have to just talk to him, get the information out, figure out like how we can best help John and like what happened to him and try to save him ultimately.
And what happens next?
More officers begin to come, fire and EMT, so the scene becomes active with a lot of different presence. John, I think they lift John onto a board at one point. The officers are asking us questions. Karen's kind of coming over, talking to the questions, and then kind of just running away, and then she just runs back over. She's doing a lot of screaming, a lot of repetitive, is he dead, is he dead, is he dead? Could I have hit him? Did I hit him? Kerry, I think, Kerry's off kind of making phone calls, I believe, to John's family.
Do you know what time the first responders lifted John from the ground and put him on that bed?
I don't know a time, but it was...
Okay, that's the only question.
Okay.
You heard your 911 call. Do you know the time of that 911 call?
Not off the top of my head, no.
At some point, did you talk to a number of different people at the scene?
Yes.
And who were you talking to?
The first officer was Officer Saraf. I know I spoke with him. I spoke with an Officer Lank, an Officer Good. There were other officers, I don't remember their names. There were EMTs, I don't remember their names either.
You have lived in this area for a long time?
Yes.
You're active in the community?
Yes.
Did you know Sergeant Good from before that night?
I knew of him. I didn't know him personally.
Did you know Detective Lank?
Yes, I knew him.
How did you know him?
We were friendly.
Your children ever associate with each other?
Not until recently.
After you had a chance to speak to some of the officers, did you move around at all yourself?
Yes, I the officers would talk to us here and then a little bit over to the side. I tried to comfort Miss Reed. At one point, Miss Reed was very upset, and one of the officers thought it would be best if maybe she went and just sat in one of the cruisers for a little bit, because she was just doing a lot of screaming and yelling, and I think they were just trying to, get, work on John and make the scene a little less chaotic. So I went into the back of the car with her, and Kerry Roberts came over, and then we all were just sat in the back of the, Karen and I kind of were scrunched and sitting in the back, and Kerry was at the door of the cruiser.
Why did you get in the car with the defendant?
She was crying. She asked me to get in. We held hands. We prayed. She did have blood on her hands, and she said, could I have gotten my period? Who's going to take care of the kids? She just kind of was all over the place. And then at one point, we saw them moving John towards the ambulance. And at that point, Miss Reed started yelling to Miss Roberts, go check on him. Are they working on him? Is he dead? Is he dead? And at that point, myself and Miss Reed got out of the car, and she started yelling and pulling on me to Google hypothermia and Google how long it takes for somebody, to die in the cold.
When the defendant first asked you to Google an inquiry about hypothermia, were you still inside the police cruiser, or were you outside?
Outside.
What was the weather? I know it's an obvious question, but how cold was it?
It was very cold, windy. The snow was blowing. As I stated, I have multiple sclerosis, so when I am out in either extremely hot or cold temperatures, I lose the feeling and sensation in my fingers, which obviously made the Googling very hard for me to do because of my, motor skills.
So when you were outside of the car with the defendant and she had asked you to do a search regarding hypothermia, did you try to do that?
Yes, I did.
Do you know the exact time from your memory? Not from reading or learning, but from your memory. Do you remember the exact time you did that?
No.
Was it after the police came that morning?
Yes.
Had you ever attempted to search about hypothermia any time before that moment, that morning?
No.
Or that day?
No.
That week?
No.
Was this the first time that morning after the defendant asked you to search that you searched that phrase?
Yes, it was.
And did you complete your search and get a result?
So I don't know what came up, because I think as I entered it, I think I misspelled things. And so then I think I tried a second search. And again, I don't think I even paid attention to what came up, because we were already on to the next thing. Karen was already moving and screaming about, the next thing to Kerry. Are they working on him? Is he dead?
Did the defendant move somewhere from the point when she first asked you to try to Google about hypothermia to something else?
She was next to me, and then I think she took off. Like, she kept kind of running off.
And what did you do?
I believe as they were I think I stood there, I believe as they were putting John into the ambulance, I went back kind of to the original spot where we had been talking to the police. And at that point, a new officer might have come, because I remember talking to multiple officers there.
At some point, did you go back towards the area of Miss Roberts' car?
Yes, that's where I'm referring to, sorry.
At some point, were you with the defendant when she spoke to an officer and a first responder?
Yes.
Do you remember if the first responder was a man or a woman?
I remember there was a woman right next to us, yes.
Do you remember if that was before or after the defendant asked you to search about hypothermia?
I'd be guessing if I then don't.
Don't guess. When the defendant was speaking to the first responder, the woman, were you near?
Yes.
Did you hear or do you remember the defendant saying anything to the first responder?
Yes.
What did she say?
She told the first responder, I hit him, I hit him, I hit him.
When she told the first responder, I hit him, how did you react?
I was like startled, kind of like, what are you saying? What are you talking about?
Did you say anything to the defendant?
I think after the second or third time she was saying it, I was like, Karen, like, what are you saying?
Why were you trying to interrupt her?
Because I thought she was just talking crazy, and I'm saying, why is she saying she hit him?
Were you trying to look out for her?
Yeah.
Sustained. I'll strike it. You can ask it differently.
What was your motivation for trying to interrupt the defendant making the statements to the first responder?
Karen was hysterical, irrational, kind of.
I'll move on.
Okay, I'm going to see counsel at sidebar for just a minute, please.
Yeah. After you made the search at the defendant's request for an inquiry regarding hypothermia, did you have a chance to speak to the officers further?
Yes.
Did they ask you to do anything or go anywhere?
Yes. Officer Lank asked me to go into my sister's house and to wake them up.
And your sister's name again?
My sister, Nicole.
And that is the house you were in the night before?
Yes.
And after you spoke to the officer, they requested you go in to speak to your sister, did you?
Yes.
Was there any directive on what you should speak to your sister about?
No.
After the officers asked you to go into the house, did you?
Yes, I did.
Do you remember what door you went through?
Yes, I went through the front door.
Was the door locked?
Yes.
How did you get in?
Oh, I'm sorry. I thought you said, was it unlocked?
No, I asked if it was locked.
Oh, sorry. It was unlocked.
As you're approaching the house, were there any lights on?
No.
Was it dark?
Yes.
Any sign of any movement inside the house before you went in?
No.
Take us through walking through the front door. What happens?
So I went in the front door. I opened the door. I walked up the stairs into their hallway, and then I think I knocked on their door.
Bedroom door?
Their bedroom door. And then I opened the door. I went in, and I walked over to the bed, and I was like, Brian, Nicole, because I was in a position where I felt like the world was going on around me, so much was happening, but I also was aware that I was just about to wake up two people that are sound asleep, and they're going to see me standing over their bed and be startled, wondering, what am I doing here?
So what happens?
So it took a minute or two, and then Brian woke up, and he immediately was like startled and was like, Jennifer, what's going on? What are you doing? And then I believe tried the best I could to say what was going on. I think I said, we found John.
You don't need to describe
Okay.
again, but I want to know their reaction and your interaction with your sister and Brian Albert.
They woke up startled and confused.
Did you have a conversation with them?
Yes.
How long was that conversation?
Brief. They got up, got dressed. I spoke to them.
And where did you go and where did they go?
Then all three of us went down the stairs.
The upstairs to the downstairs?
Upstairs to downstairs,
And
yes.
upstairs is the second level, is downstairs the first level?
Yes.
As you come down the stairs, can you see the front door?
Yes.
Is there anybody in the house at that point?
I saw Officer Lank.
In the house?
Yes.
Do you know if he had been invited in?
I have no idea.
When you came down the stairs and saw Officer Lank, where was your sister and Brian Albert?
They were walking with me down the stairs.
And did you see whether or not the officer spoke with your sister and your brother?
He did.
Brother-in-law? I'm sorry.
He did, yes.
Were you there during that conversation?
No,
How long was that conversation, do you know?
not sure.
Where did you go when the officer was speaking to your sister and your brother-in-law inside their home?
I was standing at the front doorway, and then my husband, Matt, had just arrived.
What happened next?
I started talking to Matt, and almost immediately Officer Lang came, got Matt, and asked if he could talk to him outside.
Okay. At this point, I want to go back and show you some video. Have you seen video in this case before?
Yes.
I'd like to ask the court's permission to display Exhibit 4, and I would like to walk through some of the video.
Okay.
Ms. Gilman, if you kindly put on Exhibit 4. Were you in your car when you called the police station and the hospitals looking for John?
Yes, he was.
Do you know at that point whether anybody else had called the police station?
No, I don't know.
Do you know at that point if anybody else had called any hospitals?
I don't know.
How long did you wait in your driveway?
I don't know. I'm sorry.
Okay.
Maybe like 7 minutes, 8 minutes.
What were the conditions like out that morning?
It was bad. It was in the middle of a blizzard.
When you were outside in your car in the driveway waiting, describe the lighting conditions for us.
It was still dark out. It was 5 o'clock in the morning, and it was snowing, so it was not great.
How was the visibility?
Not great. It was coming down really fast at that point.
You said that night when you went to bed, the snow just started. Had snow accumulated at that point?
No, I don't think so. It was just starting to stick.
I'm sorry, that was the night before, but at this point when you were in the driveway, had the snow accumulated?
Oh, yes.
Do you know how many inches it was?
No, I don't.
Okay.
Enough that the plows are out.
As you were waiting for the defendant, did she arrive at your house?
She did not.
What happened?
Again, I don't know if I called her or she called me, but eventually we connected on the phone, and she said, I said, where are you? I'm waiting. And she said, I'm at Jen's house. And I said, Jen who? And she said, McCabe. She's going to drive my car. And I said, okay, well, listen, they don't want cars on the road because it's so bad. I'm already in my car. I'll come there to Jen's house, stay there, and we'll follow each other, and we'll go back and drop your car off. Did you look in the house for John? Could he just be in the house, passed out somewhere? And she said, no, she hadn't looked in the house. So I said, okay, now I'm going to come to Jen's. We're going to take the car home, drop it off. We'll check around the house. And then I don't know what the next step at this point was. I just wanted to check the house.
At the time you directed that you were going to meet at Jen McCabe's house and then drive to John's house, was there any suggestion by the defendant where she wanted to go?
I didn't know where Jen's house was. I knew the street. I had dropping Kaylee off or picked her up a few times. So I said, stay on the phone with me so I don't know which house it is. And so when I got there, I pulled in the driveway, and there was some conversation about...
Can I back you up and just ask you a little bit about the drive there? I don't
Yep.
mean to interrupt. When you left your house, you talked a little bit about the weather conditions. How long did it take you to get from your home to Jen McCabe's?
Oh, it's quick. Probably 4 minutes.
What was the driving like?
It was not good driving. That's why I didn't want two cars on the road.
Did you have any difficulty driving through that storm?
No, I mean, it was treacherous. But I was in four-wheel drive. I have an SUV.
You mentioned you didn't know exactly where Jen McCabe lived. Had you been there to drop off John's niece before?
Yes, but I didn't know which house it was because when I picked her up before, she was either getting out of the car at the driveway or waiting at the end of the driveway. So I didn't know which house it was.
I think I interrupted you, but were you telling us that as you drove to Jen McCabe's house, you were on a Bluetooth, on an open conversation with her to help with directions?
Yes, Jen and Karen were in Karen's car, and I was on the phone essentially with both of them.
Do you know what type of vehicle the defendant was driving at that time?
A Lexus SUV.
As you drove over to Jen McCabe's home and you had some guidance finding it, did you hear any conversations in that open line with, or even any statements by the defendant?
I remember when I pulled in behind her car in Jen's driveway, and at some point Karen said, my taillight, and I looked, and Jen she must have had the brake done because you could see that there was missing taillight.
When you say missing taillight, was it merely cracked?
No, there was a piece missing.
Could you see that as you were parked right behind the defendant's SUV or Lexus?
She must have been applying the brakes because you could see it, but there was a lot of snow.
When you saw that the taillight had a missing piece, did you say anything?
No,
Did you think anything of it?
no.
How long were you parked behind the defendant's Lexus while it was parked in Ms. McCabe's driveway?
Not long. We were just, I pulled in and then we stopped and then the next plan, at some point in that conversation as well, or maybe on the ride, because now we're heading to John's house to drop a car off. I pulled out of the driveway, Jen pulled out, and I followed behind all the way to John's house. And at some point, Karen said, I left him at Waterfall. And I heard Jen say, no, I saw you pull up in front of my sister's.
Was anything else said about the broken taillight?
No.
You followed Ms. McCabe?
Yes.
Where did you go?
To John's house.
Did you arrive?
Yes.
I want to ask you some questions about when you arrived and what you did next.
Okay.
When you arrived at Mr. O'Keefe's home, you were in two separate cars. Who pulled into Mr. O'Keefe's driveway first?
Jen pulled Karen's car in first.
So Ms. McCabe was driving the Lexus,
Correct.
and the defendant was in the passenger seat?
Yes.
After you both pulled in, tell us what happens next.
We went, I wasn't sure if it was, at some point Karen showed us the taillight up close, but I didn't know if it was when we arrived or when we left. But we went into the house to look for John.
When the Lexus was parked by Ms. McCabe in Mr. O'Keefe's driveway, was it facing the street or facing away?
Facing where the basketball hoop is, not facing the street.
I'd like to approach.
Okay.
I'm going to show you a photograph. Do you recognize what's in that photograph?
Yes, that's John's driveway. That's Karen's car on the left and John's car on the right.
Do you recognize both those cars?
Yes, I do.
Do you recognize that photo as a fair depiction of his driveway?
Yes.
Do you recognize it as a fair depiction of the motor vehicles?
Yes.
Now, when you went there that night and you pulled in behind Ms. McCabe and the defendant, is there any differences between how that area looked when you pulled in as opposed to that photo?
Well, it was the early hours of the morning, so it was dark out, and there was much more snow. And there was snow coming down.
I'm so sorry. You want to finish?
Nope.
Other than the snow and the lighting, is there any other differences?
Nope.
I'd like to introduce this as an exhibit, please.
All right. There's no objection, Mr. Jackson?
No objection.
With the court's permission, I'd like to publish.
Okay.
And to help us understand, you see on the left is the house.
Yes.
There's a motor vehicle in the middle of the driveway, but it's the vehicle to the left.
Yes.
And whose vehicle is that?
That's Karen's.
Is that where it was parked that night when you went into the house?
Yes.
In the motor vehicle to the right. You recognize that?
That's John's car, or SUV.
Thank you, you can take that down. I'm showing you a second photo.
Okay?
Do you recognize that photo?
Yes.
What is it?
It's the back of Karen's car.
Does it look like a fair and accurate depiction of her car as it appeared that morning in the early morning hours to you?
Yes.
Do you notice anything that's distinguished in that photo?
The piece that's missing in the taillight.
Which one?
The right passenger rear.
Do you know when, I'm sorry, do you know when this photo was actually taken?
I do not.
Although you don't know when it was taken, is that a similar depiction to your memory of how it appeared that morning at 5?
Yes.
Or a little after 5?
Yes.
I've moved to introduce this exhibit.
Okay.
Objection.
The court's permission, I'd like to publish.
Yes.
We could take that down, please. After you arrived at Mr. O'Keefe's house, what was the plan to go inside? What were you looking to do?
To go inside and look and see if he was passed out somewhere. So we went in through the garage, and I started looking. I think Jen ran upstairs to Kaylee's bedroom, and I just started looking through the living room. Basement door was locked from the inside, so I knew he wasn't in the basement. And then I checked the other living room. He has a big house. Then I went to the top of the stairs to check his bedroom.
As you looked around, what was your mood?
What was my mood?
Yes, were you calm?
I mean, I was worried, so we were... At this point, Jen had already established that they went to her sister's...
Sustained.
Okay.
Jen had already...
Hold on, Ms.
I'll
Roberts.
ask the question better. My apologies. How many rooms did you look through in John's house?
1, 2, 5 or 6.
Did you see Miss McCabe looking in rooms as well, searching?
She went upstairs when I was looking downstairs.
At some point as you were looking, did you see the defendant?
Yes.
Was she looking with you?
She was in John's room.
What was she doing?
She was just standing there when I came up to the top of the stairs.
Did she say anything?
No.
Did she do anything?
No.
Was she searching?
I don't know. She was in the room.
What happened next?
At some point, Jen earlier had said...
Well, let's not talk about what was said. Okay. Let's
Well,
just talk about
the plan
best
at this
you can,
point is
your
to go to
memory of what was
34
done.
Fairview.
Ms. Roberts, I know that I'm just going to ask you to wait for a question
Okay.
because we can only get one person at a time. So next question, Mr. Brennan.
Again, my apologies. And so as you're looking through the house, you don't find John. What happens next?
The plan was to go back to Jen's sister's house.
Who made that plan?
Karen wanted to go back there.
Well, tell us a little bit about that. How did that conversation come up, and share with the jury what was said?
And the car ride to Meadows, Karen said, I left him at Waterfall, and Jen said, no, I saw you pull up in front of my sister's. So then Karen said, we need to go back to your sister's, and I said, no, we're going to go to Meadows, and we're going to drop the car, and we're going to look there, then we'll go there if we don't find him.
When you were at the house, Meadows, John O'Keefe's house, and you didn't find him, was there any further conversation about what the next steps would be?
I said, let's go. He's not here. But I didn't know where Jen's sister lived, so we got into the car. Jen was in the passenger seat. I was driving my car. Karen was in the back seat.
Did you
And Jen
begin?
was giving directions.
Did you begin your way towards Meadows?
Yes.
And it was Miss McCabe who was giving directions?
Yes.
As you began driving to head towards Meadows, in addition to trying to drive, were you doing anything like looking or searching?
Well, yeah. We were looking on both sides of the... I was looking on both sides of the road in case he was walking home.
Did you see Miss McCabe searching?
Yes, she was looking out as well.
Describe a little detail about what you saw Miss McCabe doing.
She was looking out the window as we were driving. So was I, as I was driving.
And where was the defendant during that time?
She was in the back seat.
Was there any conversation, comments, statements?
Well, she would be in the back seat, and then she would be in between Jen and I, in the back seat, and then in between Jen and I. She was just very frantic.
Okay. Was she saying anything?
There was conversation on the way there.
Okay. Was she looking as well? Did you see her looking out the windows like you and Jen?
I don't know if she was because she was in the back seat.
As you drove to Meadows, what was the visibility? The same or better or worse?
No, it was poor.
Did you make your way towards Meadows?
I did.
As you finally got to Meadows, was the house on your left side, your side, or on the other side?
Are you talking about Fairview or Meadows?
I'm sorry, Fairview.
Okay. The Fairview house came up on the left-hand side.
Before you got to the house, is there a tree line between that house and the house before it?
Yes. There's a cluster of trees and bushes.
All right, take us back. I want to talk about that morning. As you're driving and approaching Fairview, tell us what you hear, what you see, what's happening.
Jen's giving directions, and it was really bad driving. I was white-knuckling because it was getting slippery. Karen wouldn't put on her seatbelt because she was in between us again the whole ride and then sitting back, but she was worried because we weren't finding John.
Were you having words?
Yes.
Tell us.
I said to Jen, where are we heading? And she said, my sister lives on Fairview. And I said, where is that? She said, off of Chapman. I said, oh, okay, near Spring Lane. At some point, Bella's mom came up.
Tell me what that means.
I didn't know who it was, but it was one of Kaylee's friends, Bella's mom. Well, the directions, at some point Karen was talking about Bella's mom to Jen, saying she never liked me. I didn't know who this woman was that they were talking about, but apparently Bella's mom lived near where Jen's sister lived on Fairview.
Did you learn any more about the relevance of Bella's mom?
No. Oh, well, I think John had dated her.
I'm going to allow it.
So as you approached Fairview, tell us what happens.
As we approached Fairview, at the house. You mean the house or the street?
Yes, the house.
The house. Jen said, my sister's house is right up here. And I said, okay. And as we approached the house, Karen from the back seat is now screaming, there he is, let me the F out of this car. And she's now kicking the back door to get out.
When you heard the defendant scream, there he is, and started kicking the car door, did you see anything?
I did not.
Did you see anybody?
I did not.
Did you look?
I looked.
Was there anything that impeded your ability to see far?
No. It was just snow.
How far could you see when she was yelling, there he is?
How far could I see?
Yes.
I mean, the visibility wasn't great.
Okay. Was she pointing or giving any direction?
No, she just said, there he is.
Okay. What happens next?
And then I unlocked the car. I looked over, I didn't see anything, and I unlocked it so she could get out of the back seat. I looked at Jen and I said, she's crazy. And then I turned around and watched, and she ran over to a mound of snow.
When she started running, before she got anywhere, did you see anything at that point?
I did not.
Were you looking?
I was looking. She said, there he is, so I'm looking around to see where he is.
And you could see nothing?
I did not.
Did you see her run around or directly?
She ran right over to the mound of snow.
Could you tell what the mound of snow was from the car?
Once she got to it, yes, it was. Once she got to it, you could tell it was a mound of snow that was the length of a body.
Okay.
All right, I'm going to stop you there, Mr. Brennan. I need to see counsel at sidebar for just a minute, please, regarding
Why did you decide then to go get paramedic training?
I wanted to be on the fire department, and it was a prerequisite.
Did you complete paramedic school successfully?
I did.
Were you still working as an EMT at the time?
I was.
And inevitably, did you seek to have a different job? Did you try to be a firefighter?
I wanted to be a firefighter, correct.
Were you successful in doing that?
I was.
Tell us a little bit about that, sir.
On the Canton Fire Department. So I got on the Canton Fire Department, and then they send you to the fire academy, where you train to be a firefighter.
So you had EMT training, paramedic training, and then firefighter training?
That's correct.
On the Canton Police Department, did you serve dual roles as a paramedic and as a firefighter?
Fire department?
Yes.
Yes, sir.
Sorry.
Yes, sir. Firefighter and as a paramedic.
You served as a firefighter and a paramedic.
Correct.
In the Canton Fire Department, does it have more than one station?
There is. There's two.
Is there one station that's larger or smaller than the other?
Station 1 is the headquarters, which is larger.
Had you ever spent time at Station 1 as a firefighter or a paramedic?
I have. We rotate through both stations.
I want you to take us back to January 29th, 2022. Were you working that evening?
I was.
What station were you assigned to?
Canton Station 2.
Canton Fire Station 2?
Correct.
And that's the smaller of the two stations.
It is.
Were you working with anybody at Fire Station 2 that night?
My ambulance partner at the time was firefighter Dan Whitley.
Was there anybody else who was working at Fire Station 2 in addition to you and Dan Whitley?
Correct. There was an engine company with 3 guys on it.
3 people were assigned to
The engine, correct.
Were you and Dan Whitley assigned as partners for the day, the week?
Correct. Yes, we were.
Which was it, the day or the week, sir?
The week.
So for the entire week, you're partners with a person, and does that rotate on other assignments?
It does. It rotates.
So on this particular week, you were assigned as partners with Dan Whitley.
I was.
What were your roles between the two of you?
Well, at the time, he was my preceptor. I was a new paramedic at the time. So I was more or less the lead tech on all the calls as part of my training. And Dan's been a paramedic for a long time, so he was there to teach me.
So would Dan Whitley be the lead on the call, and he would help you?
I would be the lead.
You would be the lead?
Correct.
Did you get a call that early morning hours of January 29, 2022?
We did.
What was the call assigned for?
It was a call for Section 12 psych eval.
Very briefly, can you tell us what a Section 12 is?
Sure. It's a transportation order filled out by police, doctor, basically for us on the ambulance that we have to take the patient, whether voluntarily or involuntarily, because they're a threat to themselves or someone else.
When you received the call for Section 12, were you aware that there were other calls that Fire Station 1 had responded to that morning?
We were aware. You can hear the calls going out each station.
Were you or Dan Whitley any part of that earlier call that Fire Station 1 responded to before you got the call for the Section 12?
We were not.
So your efforts were after?
We were after, correct.
After you got the call to respond to a Section 12, did you head towards Fairview Road?
We did.
Tell us a little bit about the trip to Fairview Road.
It was a little extended because of the weather conditions at the time. Snowing heavily, windy, low visibility.
Okay. How long did it take to get from Fire Station 2 to Fairview Road?
Approximately 8 to 10 minutes.
Who drove?
Firefighter Whitley.
Now, on the way to Fairview Road, do you sit in the front of the ambulance?
We do.
Take us to when you arrived to Fairview Road. What do you see?
You see a bunch of police lights. Canton Engine 3 was already on scene, so we parked behind them.
Did you have it, without talking about what you spoke about, did you have a chance to speak to anybody at the scene?
We briefly spoke to the Canton police, and they briefed us and sent us to where the defendant was at the time.
Why do you have a conversation with other first responders at the scene before you do anything?
They're making sure the scene is safe to begin with, and they're on scene first, so they have a little more info than what our dispatch would have.
After you had that debriefing with colleagues, were you directed to approach any certain person?
I was.
Where did you go?
I went to the defendant, who was sitting in a black SUV type car.
Were there other persons inside the car with the defendant?
From my understanding, there was one person in the driver's seat.
And what seat was the defendant in?
She was in the front passenger seat.
Did you have a chance to speak to her?
I did.
And the person you spoke to who was in the passenger seat of that car, do you see that person in court today?
I do.
Could you point out and describe an article of clothing, please?
Miss Reed right there, she's in the blue, navy blue.
How long was your conversation with the defendant while she was still seated inside the vehicle?
Approximately 5 to 8 minutes.
At some point, did you and the defendant move to another location?
We did.
Where did you go?
So we went back in the ambulance.
after having a conversation with her, was she cooperative going back to the ambulance with you?
She was.
And did you ask her to be seated in the ambulance?
I did.
Was she cooperative with that as well?
She was.
After she was seated in the ambulance, did you close the doors and get in?
We did.
When you say we, who was with you?
Me and firefighter Whitley.
So you and firefighter Whitley were in the back of the ambulance with Miss Reed. Who was going to drive the ambulance?
Firefighter Sam Park.
Where did he come from?
He was on the fire engine that was already on scene.
I want to ask you questions now about what you did in the back of the ambulance and some of the conversations that you had. Tell us what your role is once you have a patient in the back of the ambulance. What do you do next?
I mean, each patient's different. Depends on what the call is for. In this specific situation, it was more a psych eval, because that's what we're called for. Initial triage questions: is the patient cooperative, uncooperative, combative? I asked her name, her mental status, where she was. I asked her if she was suicidal, and if she was, did she have a plan? Did she want to hurt anyone else? Those are kind of the initial triage questions that I would ask.
Why do you ask those questions?
Just to get a kind of a judgment on the patient, reading the patient.
What's your role at that point? Are you an investigator?
I'm not.
Are you in any way law enforcement?
I'm not.
So what's your focus when you're speaking to a patient?
It's basically hearing them speak, hearing their story. In this specific situation, we didn't know circumstances. We just knew that Miss Reed had found her husband, which she was calling dead on the side of the road. So it was a traumatic call.
So when you were there, you knew nothing about what had happened before you got there?
We did not.
And your role had nothing to do with any of that investigation?
We did not.
You were solely focused on caring for the patient?
Correct.
Did you have any other role other than caring for the patient?
Just making sure she got to the hospital safely. She didn't hurt herself.
During those conversations, are you and firefighter Whitley doing the same thing or different things?
Again, it depends on the call. I was the lead tech, so I'm the one documented, giving a report to the nurses, the staff. So I was more kind of getting that information, my initial triage questions, and then just kind of sat and supported Miss Reed. And
were you writing down information, technical information about status and health on a report?
I was, yes.
While you were doing that, was your colleague speaking to Miss Reed?
He was.
Did you have a chance at times to hear what they were speaking about?
Yeah, and no.
At other times, did you speak directly to Miss Reed?
I have.
Can you describe her demeanor or temperament?
Initially, she was agitated because she didn't feel like she needed to go to the hospital. She said the statement she made, she didn't mean. She just kind of said it in jest because of the events that she went through. So but then there'd be periods of which she'd be calm, and then it would fluctuate. She would have like pressured speech, repetitive, but all in all, she was cooperative.
At some point, did you have a chance to speak to her directly about her mood?
About her mood?
About her mood.
I don't know if I understand the question.
Okay. Did she say anything to you about her last interaction with what she referred to as her husband?
Objection.
Sustained.
Did she make any statements to you when you were giving her treatment or speaking to her about her husband?
Objection.
I'll allow that. It came in.
One of the reasons why she was saying suicidal stuff is because the last conversation she had with her husband at the time was an argument. I didn't feel like it was my role to really find out the details on what was said. But that's what she said to me.
That the last thing she said to him was an argument?
Objection.
Yep.
Sustained.
Did she tell you what the argument was about?
She did not.
Inevitably, did you get a chance to bring her to the hospital?
We did.
Did you stay in the back of the ambulance with her?
I did.
Did you continue to have conversations with her?
Yes, I did.
Did you hear conversations or parts of conversations she was having with your colleague?
I had parts.
When you got to the hospital, what happens next?
So we brought Miss Reed into the hospital, registered her, bring her to the psychiatric section. Is it?
Thank you. I have no further questions.
Okay. Mr. Jackson?
Thank you, Your Honor.
After the defendant came over to you and spoke and then left, do you remember hearing her make further statements?
Yes, sir.
And do you remember her making further statements similar
I do.
to the statement to you?
Yes, sir.
Could you share with the jury what you remember her saying, not to you, but after she left you?
I remember hearing I hit him several other times. Again, not directed to me, just kind of off in the background. I'd like to reiterate, we were really focused on the patient at that point. We were trying to provide care.
Thank you, sir.
So now, after Mr. Brennan asks you a few questions, now you remember her saying, I hit him a bunch more times. Correct?
I remember hearing it in the background several other times.
Really?
Yes, sir.
Never mentioned that on direct examination, did you?
I don't remember being asked about it, sir. I remember saying what was asked to me.
You were asked, did you ever hear the defendant, Ms. Reed, say anything about I hit him? And your answer was, she said to me, in answer to my question, I hit him, I hit him, I hit him 3 times, and that's it.
To me.
You didn't clarify that, oh my gosh, she's running around like a chicken with her head cut off, screaming I hit him to everybody else under the sun.
It was, again, it was behind me in the background
right.
as I was providing patient care. Again, that was not my focus.
Okay, so you didn't really hear her say anything in the background, because you weren't focused on that, right?
I remember hearing a generalized commotion in the background, but again, that was not our focus.
So generalized commotion is very different than hearing her say, I hit him to other people. Correct? You'd agree with that?
Yes, sir.
So what you actually heard was the chaos and the commotion of a chaotic scene, correct? In the background.
In the background.
As you focused on your patient care, correct?
Yes, sir.
Okay, not specific words coming out of my client's mouth, correct?
To the question that I posed, do you know him?
You're right. We're off that question.
Okay.
That question, I got it.
Yes, sir.
Triple I hitters.
Correct.
But with regard to what Mr. Brennan just asked you, the generalized commotion, to use your phrase, in the background, you didn't hear any specific words coming out of my client's mouth, did you?
I heard I hit him. But again, it was in the background and it was not my focus.
Well, why didn't you say that on direct? That's kind of an important point. It's why you're here.
Again, if it was neglected on my part, it was not intentional.
Not intentional to neglect that part for the jurors on direct examination.
No, sir.
Certainly not intentional to neglect that part of your testimony on cross-examination.
No, sir.
But you decided to bring it up on recross-examination when Mr. Brennan is asking you questions again, correct?
It was asked of me. Yes,
And
sir.
it was after, of course, that your new statement that you've never testified to before, ever, is this generalized commotion included a bunch of I hit hims in the background, correct?
Sir.
And that comes after you saw the video that clearly shows that when you describe having heard this statement, my client was nowhere around you, correct?
That segment of the video that you showed me?
Yes.
That was not the time frame in which she said that to me.
Well, that was the time frame when Flamati was giving CPR, correct?
He was doing CPR down prior to that as well.
Really?
Yes, sir.
Well, you just testified that you saw him standing up in a big yellow jacket and then kneel down and start giving CPR. We just watched that video. Correct?
But again, the clip of the video that you showed me,
Right.
that was not the segment in which he said that to me.
Well, that's what you're saying now, but what I'm asking is, you described a very distinctive scene, a very, very specific scene.
Yes, sir. I remember it vividly.
She said, the I hit him phrase, when Flamati was down giving CPR, and you were kneeling down giving airway support, and he was doing rhythmic CPR, chest compressions.
Yes, sir. That's what happened.
And then I showed you that very scene, didn't I?
Yes, you showed me that clip prior to that.
I showed you the very scene that you described where Flamani gets down and starts chest compressions and never stops until the gurney is taken off the frame of the camera to the end. Isn't that what I showed you?
That is.
Sure. I don't know if I can do it again. I showed you the scene where firefighter Flamani gets down on his knees, begins chest compressions, and never stops until that gurney is taken off camera, off frame, into the ambulance. That's the clip I showed you, correct?
That is the clip you showed me.
And that's exactly when you described your vivid memory from 3.5 years ago. That's exactly the scene that you described when my client supposedly said, I hit him to you, correct?
Again, the clip that you showed me, that was not when it was said. That segment that you showed, that was not when it was said. It was said prior to that, when the three of us were together.
So Flamani was not giving chest compressions then?
He was. The CPR was a continuous effort throughout the resuscitation.
But we saw him start it. Firefighter Nuttall, we saw him start it. We saw him walk into the frame, kneel down, and begin the chest compressions, didn't we?
We did.
And at no point, at that time or after, did my client even approach you, did she, in that clip?
She did.
What?
Objection.
Just a question.
Sure,
Mr. Jones.
sure. Do you need to see that clip again?
Yes, please.
We're not going to show the video again. We've seen 2 videos. Which one is marked?
The
The
Commonwealth.
one with the timestamp in
Right.
the top?
It's the exact same video. One has a timestamp, one doesn't. Just to be clear, you described a very detailed scene in which firefighter Flamati got down on the ground, on his knees, and began CPR.
Yes, sir.
We saw a clip that it played fully through.
Mm-hmm.
Starts and stops, but it played fully through, correct?
Yes, sir.
That was true and accurate video of what happened that day,
Yes, sir.
that morning, correct?
Correct.
And from the time firefighter Flamati began his CPR, he never stopped. Went all the way through until the gurney was taken off the camera, correct?
Correct.
You also described very clearly, before you saw the video, that the time when my client walked over and you had this dialogue and you heard this statement, it was during the time that firefighter Flamati is given the CPR, correct? You described it.
Yes, sir.
But when we actually see firefighter Flamati giving the CPR, as per your description, at no time did my client walk over and have a conversation with you, did she? In that video?
She did in the video.
In the portion that Mr. Brennan played you, was firefighter Flamati giving CPR at that point?
As I said previously
Was
as well.
he or was he not? Yes or no?
Objection.
I'm going to let the witness answer the question.
Firefighters Kelly and Flamati were trading off CPR. Tony started doing CPR, and it was passed off at one point to Firefighter Kelly. Firefighter Kelly at that time was a BLS EMT. Firefighter Flamati was a paramedic. They're going to move towards Firefighter Kelly performing CPR because at that time his skill set was not as advanced as Firefighter Flamati's, as Tony's. But they did switch off. That is a routine cardiac arrest. We switch off compressions.
But the video that Mr. Brennan showed you was earlier in time, a few seconds or a minute or two earlier.
Yes, sir.
You'd agree with that, correct?
I would.
And firefighter Flamati had not begun CPR, had he?
I don't believe so.
That's right. He hadn't. But that's the time that my client walked over your general area, correct?
Correct.
Before CPR was started, correct?
CPR was started immediately, sir.
Can we wrap this up?
I don't know if we can, Judge.
Give you a couple more minutes.
Do you understand the confusion?
Objection.
Sustained.
All right, a couple more questions on this. The video that Mr. Brennan showed you,
Yes, sir.
and you pointed to and said, oh, that's the time when she walked over and said the statement.
Yes, sir.
Remember that?
I do.
Firefighter Flamati was not even kneeling down giving CPR, was he, at that point?
No,
The answer is yes or no?
no.
Okay, he was not. Later, as the video continues to run, at some point, we see Firefighter Flamati enter the screen, kneel down in that bright, reflective yellow jacket, and begin CPR, correct?
Yes, sir.
You had previously said that when you heard the statement and she walked over to you, it was when Firefighter Flamati was giving CPR, correct?
Yes, sir.
And at no point, you'll agree with me, we just played the video, at no point after he started giving CPR did my client come anywhere near you. Isn't that what the video showed?
That was the segment that you showed me.
You indicated on redirect, that Mr. O'Keefe did not have any injuries to the left side of his body.
Not that I recall.
Isn't it true that in addition to the egg on the right side of his head, he also had a black eye on the left side?
I remember that the swelling had started to, it's referred to kind of as raccoon eyes. It's a bruising of both eyes.
Do you remember
battle signs.
Do you remember saying, in answer to the question, did it look like, in addition to the egg on the right side of his head in the front, did he also have a black eye on the left side? Your answer is, if memory serves correct, yes.
Yes, sir.
So it's not true that he didn't have any injuries on the left side of his body or face, correct?
That swelling kind of migrates over time to both sides. That is a common occurrence for both eyes to be swollen.
Did he have an injury to the left side of his face?
He did not.
Did he have a black left eye?
Yes, he did.
Would you consider a black eye an injury?
Yes, sir.
Let me ask you the question again then. Did he have an injury to the left side of his face?
Yes, sir.
Thank you. One last question. You indicated that it was a chaotic scene outside on that front yard.
Yes, sir.
Fire engines, ambulances, patrol vehicles, engines running, diesel engines, flashing lights, people screaming, people talking over the howling wind, correct?
Yes, sir.
Did you ever see the homeowner come out the front door?
Don't recall.
You don't recall, or you didn't?
I have no idea who the homeowner is.
And you never saw anybody come out the front of the house?
No, sir.
That's all I have.
One issue. Briefly.
I want to see counsel at sidebar. Whenever you're ready, Mr. Allen.
Thank you, Your Honor. Now, Ms. Hanley, when we left off, you were discussing the comparative analysis you did between item 7-18.18, Mr. O'Keefe's clothing, and item 3-1, the taillight housing or the plastic within the taillight housing of the defendant's car, correct?
Correct.
And there were a number of different instruments that you used through the course of your examination and analysis, correct?
That's correct.
And what were those instruments that you used again in that portion of the analysis?
Sure. So I used a polarized light microscope, a comparison microscope, an FTIR, and a microspec.
And Your Honor, may I approach?
Yes.
Showing you 3 documents, if you could review those, look up when you finish, please. And do you recognize those?
Yes, I do.
And starting with the first page of that 3 pages, what do you recognize that?
It is the FTIR comparison data for the clear plastic from item 3-1 and the clear plastic from item 7-18.18.
And if I could direct your attention to the second page within that, what do you recognize that?
So this is also FTIR comparison data from for the red plastic from item 3-1 and item 7-18.18.
And lastly, the third page within that set, what do you recognize that?
So this is the comparison data from the microspec from the red plastic from the item 3-1 and the red plastic from 7-18.18.
Your Honor, the Commonwealth will seek to introduce and admit as the next 3 exhibits individually.
No objection, Your Honor.
All right, thank you.
You want them marked individually, or you get a set?
Individually, please. Thank you.
Exhibits 202, 203, and 204.
Thank you.
And again, Ms. Hanley, when it came to your analysis of the clear plastic material from the debris from John O'Keefe's clothing and the clear plastic material from the defendant's taillight, what were your conclusions from that analysis?
Sure. Upon comparison, the clear plastic from item 7-18.18 was found to be consistent in color and instrumental properties with the clear plastic from item 3-1. Accordingly, the clear plastic from 7-18.18 could have originated from the clear plastic from item 3-1 or from another source with the same characteristics.
Thank you. Your Honor, may I publish, and I'm sorry, I forgot already the exhibit numbers, but
Yes.
Ms. Gilman, if I could have the clear plastic. And Ms. Hanley, can you describe for the jury what we're looking at in this, what's up on the screen right now?
Sure. So this is the FTIR comparison data of the clear plastic from item 3-1 and the clear plastic from item 7-18.18.
And Ms. Hanley, if you could, using the laser pointer before you, if you could direct the jury's attention to which is which as far as the top and bottom here.
Sorry. The top,
I'm sorry, I apologize, Your Honor.
That's okay.
the top spectrum is item 3-1, and the bottom spectrum is item 7-18.18.
And Ms. Hanley, when you're comparing these two as far as the data that you receive, what is it specifically that you're looking at in your comparison as far as the data is concerned?
So when I'm comparing the spectra, I'm looking at the peaks in each sample to determine if they are consistent or not consistent.
Thank you. And if I could turn your attention to the red plastic material from the debris from Mr. O'Keefe's clothing and the red plastic from the passenger side taillight of the defendant's vehicle, what did you conclude in your analysis there?
So upon comparison, the red plastic from 7-18.18 was found to be consistent in color, microscopic appearance, and instrumental properties with the red plastic from item 3-1. So accordingly, the red plastic from 7-18.18 could have originated from the red plastic from item 3-1 or from another source with the same characteristics.
Thank you. And Ms. Gilman, if I could have the red plastic data. And Ms. Hanley, directing your attention to the screen again with the laser pointer, if you could delineate for the jury as far as which set of data is associated with which item.
So the top spectrum is item 3-1, and the bottom spectrum is item 7-18.18.
And again, if you could just direct the jury's attention with that laser pointer to the areas as far as the data, peaks and valleys that you're looking at in comparison of this data.
So when I'm comparing them, I'm comparing the peaks to each other in each of the spectra to determine if they are consistent or not consistent.
And in this case, you found them to be consistent, is that correct?
That's correct.
And Ms. Gilman, lastly, if I could have the microspec data. And Ms. Hanley, if you could describe for the jury, please, what are we looking at in this particular data set?
So this is the comparison data from the microspec of the red plastic from item 3-1 and the red plastic from 7-18.18.
And as far as the data in any microspec, but particularly this one up on the screen, using that laser pointer, could you illustrate to the jury sort of what these individual lines or what this data means?
So these are the samples that I ran, and they samples that I ran from item 3-1 and 7-18.18, and the spectra are overlaid in order to determine, to look at it and to determine whether they have a consistent or not consistent pattern.
And from overlaying the data from the pieces of plastic from Mr. O'Keefe's clothing and the pieces of plastic from the defendant's taillight, what do you observe as far as from overlaying those two sort of data points?
So I determined that they had consistent microspec data.
Again, if you could just remind the jury as far as the microspec data, what type of data is that?
So the microspec, it analyzes samples that have color. So it provides information of a sample's dyes or pigments.
Thank you very much. Ms. Gilman, you can take that down. Thank you, Ms. Hanley. I have no further questions, Your Honor.
Okay.
Good afternoon, Ms. Hanley.
Good afternoon.
Nice to see you again. We met about a year ago. First things first, you were just talking about some plastic pieces in 7-18.8, correct?
It was 7-18.18.
0.18. I left a 1 out. 7-18.18. We're dealing with a lot of numbers. I'm going to see if we can cut through that here in a second.
Sure.
First of all, you indicated that you were doing a comparative analysis in different sort of different categorical ways, using microscopy, using the microspec, using the FTIR. I think you also use the FTIR in that as well.
Yes.
And you indicated that your analysis concluded with those pieces could have come from the same source, from the source in 3-1, the taillight. But you're not conclusively saying they did, correct?
It could have come from, they could have a common origin, or it could have come from another source with the same characteristics.
Right. So in other words, another way to say that, Ms. Hanley, is it may have come from the taillight, may not have.
It's a possibility.
Okay. I also want to ask you real quick about the taillight manufacturer. You were shown an exhibit, I think it's exhibit 200, and I think we have that available. With the court's permission, we don't have to cut the lights. I think the lighting is just fine. This is exhibit, or a photograph of exhibit 200 that you saw just a second ago. Quick question about that. In your inspection of that taillight, it's true, is it not, that that is manufactured entirely of plastic or plasticine pieces. There is no glass in that taillight, correct?
I have to check my notes. I don't think I noted any glass.
Okay. So in other words, you didn't note any glass inherent in the manufacture of that taillight. It's basically plastic.
Yeah, I think most of the parts were plastic. I'm not 100% sure if the entire thing was plastic. There may have been other material, but portions were plastic.
But you certainly didn't see any glass inherent in the manufacture process.
I'd have to double check my notes, but I don't think I did.
Okay.
Do you want her to check her notes?
Why don't you? Are your notes in front of you?
Yes.
With the court's permission.
Yes, sure.
Okay, so I did not make any notation that I noted portions that were glass.
Great. Final point before we get into the actual analysis. On any of the glass, I want to shift gears to just the glass material that you analyzed and that you looked at and you inspected. You saw no blood, no skin, no biological material, no tissue, human tissue or otherwise, on any of those pieces that you inspected, did you?
Upon examination of those items, making observations of those types of material, that's not my area of expertise. I don't think I noted anything that was maybe consistent with that.
So in other words, even though you're not in the bio material expert section of the lab, you certainly would have noted if there was skin or biological material or obvious blood on glass pieces. You were looking at them in many cases through a stereo microscope, correct?
Yes, I would have made note of observations of anything that I would have noted on the surface.
Great, and you did not, because you didn't see anything that was suggestive of that, correct?
I think I just made note, I have to check each item, but I think I did note that there was some dirt debris on some of the items.
But not biological material?
I did not note anything that would be maybe consistent with that.
Great, thank you. I want to talk about the comparisons that you did. And you'll forgive me, I'm a visual learner. So I'd like to talk about it in 4 categories. Okay. Linear categories. Category 1, item 3-2. Category 2, item 3-3. Category 3, item 7-12. Category 4, item 7-14. 3, 2, 3, 3, 7-12, 7-14. Can we talk about them in those particulars?
Sure.
Okay. 3-2 was the cup, correct?
That's correct.
Okay. And I'm going to use the word cup rather than glass for obvious reasons. You could get confused by that. So when I say the cup, do you know what I'm talking about?
Item 3-2.
Great. 3-3 are the 5 items that were found on the bumper, claimed to have been found on the bumper by MSP or crime. Okay?
Yes.
5 items, A, B, C, D, and E, correct?
Correct.
Item 7-12 are 9 items, glass items, that were recovered at 34 Fairview by Trooper Buchanan in an evidence envelope, correct?
So sustained as to who they were recovered from?
Sure. Did you receive the items along with an evidence envelope?
I need to double check if it was an envelope, but I received it packaged.
Okay. And the packaging normally, under normal circumstances, the packaging comes with labels that gives you reference about where things came from. For instance, when Mr. Lally asked you, were you aware or did you become aware that items were claimed to have been found on the bumper? You didn't actually find those items, but that was the description you were given, correct?
That was the description of the item in our limb system.
Okay. And going back to 7-12, that's our third category, was that described as 9 pieces of glass that were found at 34 Fairview by a sergeant by the name of Buchanan? Or do you recall that?
I am not sure who recovered them.
Well, what it said on the evidence envelope, that's what I'm asking.
I would have to check my photos to see if it says that.
We'll get to that in just a second, but fair enough. 7-12, 9 items, A, B, C, D, E, and if my memory serves, I, K, and L?
I'd have to refer to my notes to...
Can you please?
Yes. So the 9 pieces of glass from 7-12 were labeled A, B, C, D, E, F, I, K, and L.
Great. And then finally, what was in 7-14, that's an easy one, 1 piece of glass.
That's correct.
Okay. Your Honor, may I approach?
Yes.
I'm going to hand you photographs. That should be 2 photographs of the exact same thing. Do you recognize what's depicted in that photograph?
I've never seen. I did not take this photo.
Understood.
So I'm not. I haven't seen them, so I don't know.
So I'm asking you to look. I know you haven't seen that photo. Does it look like the cup?
It looks consistent with the cup.
Okay. Take a look at the second photo. Do you recognize what's depicted in that photo?
So I did not take this photo. It appears to be a photo of a container that another analyst took a photo of item 7-12.
And item 7-12, once again, included plastic pieces and 9 glass pieces, correct?
Correct.
Do you see the evidence label on the very top of that evidence envelope?
I'm not sure which label you're talking about.
The one under the red tape.
Yes.
Does that appear to be a label marker that's done to maintain chain of custody?
So I think that label.
Do you have a bumper? Correct.
Yes.
You didn't take that picture.
I did not.
Okay, let's look down beneath it. You indicated that there were 5 items in 3-3, A, B, C, D, and E, correct?
Correct.
Do you see A, B, C, D, and E represented in that category on this chalk?
I do see A, B, C, D, E categorized, yes.
Great. Under A, you previously testified that the bumper glass sub A in 3-3 did not match the cup, correct?
That's correct.
Did not match anything in 7-12?
Sorry, just give me one moment. That's correct.
And did not match anything in 7-14?
That's correct.
And you see those represented by sort of the international symbol for negative, correct? A circle with a line through it, correct?
Yes.
Okay. Under subcategory B, glass B, or item 3-3B, did not match the cup, did not match 7-12, did not match 7-14.
That's correct.
Is that accurately represented on the chalk?
Yes.
Finally, with regard to E as an echo in that same item, 3-3, you see that there is a green indication that glass recovered by Proctor does match, or did match in your analysis, or was consistent with the item in 7-14, correct?
It was consistent microscopically and instrumentally.
Does that accurately reflect that finding on this chalk?
Yes.
Okay, now turning to category 3. There were 9 pieces of glass that you looked at, correct?
Correct.
A through F, I, K, and L. Is that right?
If I could just reference my report to make sure.
Of course.
Yes, those are the correct letters.
And A, B, C, D, F, and K all matched the cup, correct?
Again, I would just need to confirm with my report.
Take your time.
Yes, so A, B, C, D, F, and K
All matched the cup.
had a physical match to 3-2, the cup.
Is that accurately represented on this chart? With green.
Yes.
And E is in Echo, I is in India, and I think that's L is in Lima, did not match the cup, correct?
That's correct.
Okay, is that accurately represented on this chart?
Yes.
And finally, the last category, 7-14, that is the single piece of glass that was recovered by Trooper Proctor. That did not match the cup, and it did not match anything in 7-12, correct? And if you need to check your notes, feel free.
Yes, that's correct.
Is that accurately represented on the chart?
Yes.
Your Honor, I would move for the admission with the amendment that the court indicated at sidebar of triple K.
Okay, I'm going to allow it in.
205.
205?
Yeah.
Your Honor, the court indicated that it would like to see us before anything's published to the jurors.
Okay, come on over for a second. Actually, have those have those been done?
It has been done,
Okay.
and I was going to explain at sidebar.
All right, then come on over. $205.
Thank you. Request permission to publish.
Yes.
Ms. Hanley, you see the chalk that's been, or actually what's been marked as Exhibit 205 in evidence on the screen?
Yes.
Is that consistent with what you and I were just talking about at the witness stand?
Yes.
If you'll direct your attention to the screen on the right, just because it's a little easier and I think the laser pointer shows up a little better. Do you see the 4 categories represented in this exhibit?
Yes.
Okay. So 3-2, I'm going to go over it very quickly one more time, just visually. 3-2 on the left is the cup, correct?
Yes.
3-3 represents the 5 pieces of glass of what we call the bumper glass, A, B, C, D, and E, correct?
Yes.
7-12 is the 9 pieces of glass recovered by Trooper Buchanan at 34 Fairview, correct?
Yes.
And finally, 7-14 is the single piece of glass recovered by Trooper Proctor, correct?
Yes.
Taking these one by one, just so everybody see? Taking these one by one, looking at starting with the bumper glass, category 2. Piece A did not match the cup, anything in 7-12 or anything in 7-14, correct?
That's correct.
Piece B did not match the cup, did not match anything in 7-12, did not match anything in 7-14, correct?
That's correct.
And moving over to category 3, there were some matches in these 9 items, 6 of them, A, B, C, D, F, and K, correct?
Yes.
But what those matched, Ms. Hanley, were the cup, nothing on the bumper, correct?
Correct.
And what didn't match the cup were E, I, and L. Is that right?
That's correct.
Moving back to category 2, however, there was one thing, item E, that did match something in this series of categories. Isn't that right?
Not a physical match, but instrumentally there was consistency.
All right. And this is an item, the only piece of bumper glass, the only piece of bumper glass to match anything else in your analysis. Matched what? What was consistent with what?
So item 3-3, piece E, was consistent in physical and instrumental properties with the sample that I took from item 7-14.
Which is the single piece of glass recovered by microscopy, correct?
Yes.
But not a single piece of glass, nothing that you analyzed coming from that bumper matched the cup, did it? Nothing.
Physical match comparison, there was no physical match comparison to the cup.
Are we done with this, Mr. Jackson?
We can take this down, Your Honor.
Happened?
To the ambulance, correct.
So you went to the ambulance with the defendant?
Yeah.
And was Mr. Becker with you?
Yes.
What happens when you get to the ambulance?
I mean, so it was snowing, and it was more to kind of just get everybody into a nice, warmer location where it wasn't snowing or windy or anything like that. And we were discussing that, we have a Section 12 that states we have, regardless of if you want to go, we have to take you to the hospital. She was arguing that she really didn't need to go to the hospital, and we were trying to convince her to go to the hospital because once the Section 12 is written, it doesn't matter what the patient says, we have to get them there one way or the other, whether it's cooperatively restrained or chemically restrained with sedatives or anything.
It's not a voluntary order?
It is not a voluntary order.
Inevitably, did the defendant agree to go with you to the hospital?
Yes.
When you were going to return to the hospital, was the defendant placed in the back of the ambulance where a patient would be?
Correct. So how we operate for anybody that's a Section 12 or anybody that is under the influence of anything, we always operate with two people in the back of the ambulance. So myself and my partner, Jason Becker, were back there. And then we had to take somebody from the engine company and have them drive to the hospital, and that was Sam Park.
Sam Bach?
Park, P-O-C-H.
Thank you. Before you left, before you started to drive away from Fairview, were you having any conversations with the defendant?
Yes.
Can you share with the jury what those conversations were about?
So we were talking. She was upset. She kept asking if there was any chance her husband could be alive, and even sitting outside in the snow with no coat on for many hours.
Did she indicate what many hours meant? How many?
No.
How often did she raise the issue of whether or not, or how long he could be out for?
I'd say at least 3 to 4, maybe more.
Part of your job is to care for patients?
Correct, yes.
Was part of your job to try to get them to the location safely?
Yes.
And sometimes you treat patients with physical injuries, don't you?
Oftentimes it is physical injuries, yes.
Are you trained when you're trying to transport somebody on how to interact with them?
Yes. Well, sometimes if they're upset, in this instance, she kept asking if there was any chance that he could be alive, and that we really didn't know what was the patient that Ambulance 1 took. We really didn't know what his condition was, and but figuring that it was a hypothermia type case, being the conditions outside, we were trying to give her hope that there is a saying in the medical field, you're not dead until you're warm and dead, and I was basically, there's stories of children falling through ice and falling into rivers and being underwater for multiple hours and coming out, being resuscitated and having no neurological deficits. So I was telling her those stories just kind of to say, look, let's be sure we'll get to the hospital, we'll find out more there. just trying to give her any sort of hope that her husband would be alive.
Can you describe her demeanor when she was in the back of the ambulance with you during your interactions with her?
She would go from pretty upset, crying. One instance where she kept saying, I can't take care of these kids. I can't take care of these kids. They're not my kids, and they're not his kids. And at that point, I understood who Ambulance 1 had taken, because John was pretty well known in the town for taking on the care of his niece and nephew. So I said, listen, it's okay. It looks like you have a very strong support system. And then Miss Reed said, do you know Carrie Roberts? And she had been crying, and she picked her head up and said, do you know Carrie Roberts? And I said, a matter of fact, I do. And she said, anybody who knows Carrie Roberts wouldn't say that about her. And I said, well, she did come to out at early in the morning to look for your husband in a blizzard. And she just rolled her eyes and put her head back down. And I thought it was just bizarre.
Objection. Move to strike.
I'll strike that last sentence.
Would you describe her demeanor as even through that ride?
No.
How long did it take to get to the hospital?
I mean, you can refer to my partner's ambulance trip report. I'm sure it has the...
Do you have it right with you, sir?
I do not, no.
Well, let me ask you. It's
I
okay.
would guess about 15 to 20 minutes, somewhere in there.
You don't have an exact memory?
No.
When you get to the hospital with a patient under these circumstances, do you leave them at the door?
No.
What do you do?
We have to hand off care. So we go in and we have to give a report to a nurse to let them know what their condition is, why they're coming to the hospital, and what we found taking them to the hospital.
When you got to the hospital with Miss Reed, did you interact with the hospital personnel?
Yes.
Do you typically, after you hand off a patient to staff, do you leave?
Typically, yes. This time, Miss Reed was, I'm going to say, not really cooperative with the nurse there. The nurse was asking her to get into a Johnny, give a urine sample. She was not cooperative. The nurse tried to work with her, had an ER tech go and ask the doctor if she had to get into a Johnny. She came back. She said, yes, she's a patient. She has to do all the normal stuff. We really didn't feel comfortable actually leaving the general area. I don't know if it was just shift change or what, but security wasn't there. And with her demeanor, we just didn't feel comfortable leaving the nurse by herself with Miss Reed.
You said that there was some difficult times. Was there some difficulty about the defendant accepting wearing a Johnny?
Yes, she was refusing to get into the Johnny, and the nurse kept saying, well, you got to get into this Johnny. The nurse did try to work with her and you know, asked the doc if...
Objection.
I'll allow that.
And so the ER doc, the ER tech had to come back and say, yes, she has to get into the Johnny. And at that point, she did. She you know, seemed to have calmed down and was getting into the Johnny. Security personnel had shown up, and we felt comfortable being able to kind of leave the nurse and the tech on their own.
Before security came, was there difficulty in her providing a urine sample?
Objection.
Do you know the answer to that?
Can you ask the question again? I'm sorry.
Why don't you ask it a little differently?
Sure. Do you remember whether she was giving the nurses a hard time about a urine sample?
Yes.
Objection.
So break that down, Mr. Brennan. The objection is sustained.
You said that she was giving nurses a hard time.
She didn't want to give a urine sample. And then the nurses kept asking her to, you know, this is the cup, you pee in the cup.
Objection. Not funded.
No, I'm going to allow it.
You were there and saw this, right?
I saw it, yes.
Oh. Thank you. I have no further questions.
May I proceed, Your Honor?
Yes.
Good afternoon, sir.
Good afternoon.
Sir, you knew before you got into Ambulance 2 that you were heading to Fairview Road for what is called a Section 12, correct?
We were dispatched for a Section 12, correct?
Right. And that was not your first call for a Section 12, right?
No.
You had been in that job since 2006?
Yes.
You've handled a number of them over the years, correct?
Correct.
The fact that the call came in as a Section 12 gave you some idea of the nature of the issue that you might be dealing with, correct?
We had an idea that it was for a psychological issue, correct?
Right. It told you that somebody at that location was suspected of being in some type of either psychiatric or emotional distress, correct?
Yes.
And on your crew, or of your crew, I should say, you were the one to drive the ambulance 2 to the residence, correct?
I drove to the address at Fairview.
Now, you've said that when you got to Fairview Road, you don't recall the time, but you do recall that there were still emergency vehicles on scene, correct?
I do.
There was nobody lying in the front lawn of 34 Fairview at that time, correct?
Correct.
And do you know how much later, after 6 a.m., you would have gone there?
You'd have to refer to my partner's report.
You don't know if it was minutes or hours later?
It was minutes. It was within the hour. I don't know.
Within the hour,
Yeah.
okay. And you said that there were, or you testified that there were 2 police vehicles on scene, correct?
At least 2.
At least 2. There could have been more than 2.
It certainly could have been.
And those police vehicles in such a situation, particularly with the snow falling down, would have had their blue lights flashing?
I'm not exactly sure if they did or they didn't. Sometimes the police shut off their lights when they arrive on scene. Sometimes they don't.
Okay, so you don't have a memory one way or the other?
No, nothing sticks out.
But those police vehicles certainly were not hidden. They were in plain view, correct?
I would say so.
Minimum of 2, maybe more. Correct?
Yes.
And there was also a gray SUV parked near that residence?
Correct.
And there was a fire engine there as well, correct?
Correct.
You called it our engine, right? That was from your...
Well, it would be engine 3.
Engine 3, from
or
your
at least
station.
the Station 1 engine.
I'm sorry?
The Station 1 engine. So Canton Fire has 2 fire stations. We were coming from the second station. The Station 1 engine is the one that responded to Fairview.
Okay, and that was a typical large fire engine, correct?
Yeah.
And did the fire engine have its lights on?
I assume it did, only because we rarely shut our lights off on a scene.
Sure. And there were police officers walking about, milling about?
Yes.
Do you know how many?
I know I spoke with Officer Sarif and Officer Mullaney.
Okay. And
so at least 2.
And you know them by name?
Yeah, Canton's a fairly small town, so you run into the police on a regular basis.
Sure, and you work cooperatively with them, correct?
Yes.
Were there other police officers besides Sarif and Mullaney?
I'm sure there could have been, but I don't recall ever speaking with them or interacting with them.
Okay. Were there other EMTs or firefighters there when you got there?
Just my Lieutenant Woodbury, and then Firefighter Sam Pock.
Okay, and they were in charge of Engine 1?
Well, the Station 1 engine.
The Station 1 engine? Okay. And there were also civilians on scene, correct?
Correct.
So you would agree that there was a lot of activity outside 34 Fairview, correct?
There was a fair amount of activity.
I mean, there were people and vehicles and lights surrounding that residence, correct?
I assume so, yes.
In processing the scene at 34 Fairview Road in Canton, Massachusetts.
When you arrived at 34 Fairview Road, was there anybody else there?
Yes.
Who was there?
Lieutenant Tully, members of the Massachusetts State Police CERT team, the Special Emergency Response Team.
Are you part of the CERT team?
I am not.
Did you see what the CERT team was doing?
They were conducting an area search very front of the lawn and the street or road in front of 34 Fairview.
Did you have any role in that actual searching of evidence?
No, I did not.
What was your role, limited role that night?
To process any evidence that was discovered during the search.
When you say process the evidence, can you explain briefly, what does that mean?
Sure, I was had evidence bags, and if a piece of evidence or an item was found, I would place that item into the evidence bag.
And why would you do that?
To secure it.
How would you become aware if there was a piece of evidence found?
The CERT team would alert the supervisor, Lieutenant Tully, or myself that there was an item or a piece of evidence, and Lieutenant Tully would then take a photograph of it, and then I would secure the piece of evidence in a bag, evidence bag.
Do you know if those photographs were time-stamped?
I believe so.
Your role was to put the evidence in the bag and return it to the evidence room?
Correct.
Did you do that?
Yes.
If I could begin, I'd like to show you on the screen a series of exhibits. If we could start with Exhibit 74, please. Trooper, do you recognize that item?
Yes.
What is it?
That is a black Nike shoe.
Did you see that item that night?
Yes.
74A, please. 74B. Thank you. Is that the same sneaker?
Yes, sir.
After you were alerted to that sneaker, did you place that sneaker into an evidence bag?
Yes.
Did you bring that item with you today?
Yes.
Okay. Do you have gloves?
Yes, sir.
Do you want the lights on, Mr. Brennan?
Please, thank you, Your Honor. And Ms. Gilman, you can take the photo down, please. With the court's permission, I'm going to move this piece of evidence, item into evidence.
Okay.
Let me ask you a few questions before you open it. Could you stand and show that bag? There's red tape on it. What's that for?
To secure the bag closed.
If the bag is open, is it then retaped?
Yes.
Do you write on the outside of the bag?
Yes.
Why do you do that?
To memorialize the date, time when the evidence was collected.
Could you open the bag and show us what's in it?
Yes, sir. Sorry.
With the court's permission, can he show the item?
Yes.
Thank you. Trooper, is that the same item that you found that night?
Yes, sir.
If you could place it back in the bag, I'd ask this to be marked as an exhibit.
All right, any objections, Dean Eddy?
There is no objection.
Exhibit 77.
Sir, you mentioned there's writing on the outside of the bag.
Yes.
What type of information do you write on the bag?
Date, time, location, who is collecting it.
The time that you write in the bag, is that the specific time the item was found, or does that represent a different time?
That could represent a different time.
And why would that be?
If you're processing multiple things at once, you're bagging things at different times, then when you seal the bag, that can be the time that is annotated on the bag.
Can the item be found before the time on that bag?
Yes.
Would you ever write a time later than when the item was found?
Yes.
I'd like to move now to Exhibit 75, please. And preferably 75A, please. Do you recognize that item?
Yes.
Is that one of the items you bagged that night?
Yes.
And if we could turn to 76A, please. Do you recognize that item?
Yes.
Is that an item that you bagged that night?
Yes.
Do you have both of those items with you?
Yes, sir.
Could you produce those, please? Ms. Gilman, you could take that down, please. Thank you. 570.
Yes, sir.
With the court's permission, I'd ask the trooper to open the bag and show the jury. Sir, on those items that are stickers, did you put the stickers on them?
I did not.
Do you know where the stickers come from?
I do not.
Do you know if these items are ever sent to anybody other than your evidence locker? Are they ever removed and given to lab personnel and technicians?
Yes.
Do you know if that was done in this case?
Yes, I do.
Inside that bag, is there just two pieces or is there another piece in that bag?
There was another piece in the bag.
When you put the taillight pieces in that bag, how many pieces did you put in the bag?
I put 2.
Do you know if the other piece in the bag is a piece that broke off, or do you know how that arrived there?
I do not.
Could you just pull out that other small piece and show the jury as well? Is that smaller piece consistent with the same color as the two bigger pieces?
Yes.
Is it consistent with the same material?
Yes.
If you could put that back in the bag, please. I'd move this into evidence, please.
Okay.
Okay. So, Mr. Brennan, I leave it to you and the witness how you do that part.
Yes. Sir, on the small chip piece, you don't know how it became chipped?
I do not.
I'd ask you to remove that chip. I'd like you to safely secure it, bring with you, and bag it when you leave.
Yes, sir.
And then I'd like to introduce that exhibit.
So we're going to mark the little chip.
You
Ms.
like to mark
Giannetti
it?
asked to
Okay.
mark that. Yes.
Then we're going to submit that for identification. So the small chip that I
Madam
asked you to
Clerk.
secure.
Madam Court Reporter has an envelope for that.
Thank you very much.
Exhibit 78.
Thank you.
Exhibit BB for identification.
Thank you. Trooper, we have one more bag of items to go through.
Yes.
Could I have Exhibit 73, please? Sir, if you could look at Exhibit 73 on the screen, do you recognize that?
Yes.
And what is it?
A piece of clear plastic.
Is that piece of clear plastic, when you saw it, was it at ground level?
Yes,
Did you bag that item?
I did.
When you bagged that item, was there another item along with it in the same bag?
Yes.
May I approach, Your Honor?
Yes.
I'm showing you a photo. Do you recognize what's in it?
Yes.
What's in it?
The piece of clear plastic.
Is that the second piece in the bag, separate from the last exhibit?
Yes.
Fair and accurate depiction of how you saw it that morning?
Yes, sir.
I'd move this into evidence as an exhibit, please.
Okay. There's no objection, Ms. Giannetti?
There's no objection, Your Honor.
Exhibit 79.
With the court's permission, could we show Exhibit 79 to the jury?
Yes.
Ms. Gilman, would you be able to close? Thank you. You recognize that item, sir?
Yes.
And did you bring those two items with you, the past exhibit and this exhibit?
Yes.
Could you produce those, please?
Yes.
Are these different in color than the last pieces you showed?
Yes.
With the court's permission, could the trooper show these pieces?
Yes.
Thank you, trooper. I'd move these items into evidence.
No objection, Your Honor.
All right.
Exhibit 80.
Thank you.
Thank you, Trooper Keefe.
Thank you, sir.
All right, any questions, Ms. Giannetti?
Please, Your Honor, thank you. Good morning, sir.
Good morning, sir.
Trooper Keefe, you testified that you received the cell phone of Jennifer McCabe and of Kerry Roberts.
Correct.
With regard to the cell phone of Jennifer McCabe in particular, you had her sign what is called a consent form, correct?
That's correct.
What is a consent form?
Did you review any other materials in this case? Did you review any reports?
I did review reports, yes.
Did you write reports in this case?
Yes, I did.
Now, I want to ask you about Michael Proctor. You had told us that you were working on this investigation with him.
Yes, I was.
Are you still working on this investigation with him?
No, I am not.
You were Michael Proctor's supervisor?
Yes, I was.
When you work for the state police, do you have a personal phone and a phone that is provided to you by the state police?
Yes.
The state police phone, is that a work phone?
Yes, it is.
What type of information do you receive on that phone?
You can receive communications via email, text message, cell phone, tower, voice communications.
Okay, and do officers communicate with each other at times on those work phones?
Yes, they do.
And during that time, did you have a work phone that you were using for communications?
Yes, I did.
At some point, did you receive, or were you placed on an email chain that included Michael Proctor and others?
I believe it was a text chain.
I'm sorry, a text chain.
Yes.
Were you included on a text chain involving Michael Proctor and others?
Yes, I was.
Did you receive a text or a text chain from Michael Proctor and other people?
Yes, I did.
And when you received a text, do you remember where you were when you received the text chain?
The specific one you're referring to, I was at the Logan Airport working a traffic detail.
When you received that text-to-text chain, did you respond?
I acknowledged the text. I did not respond through with verbiage.
And then during that text chain, did you look at the entire text chain?
No, the text message came through on my Apple Watch. As I was controlling traffic, I glanced at it, took part of the information that came through, and acknowledged it with a thumbs up emoji, indicating that I read it.
At some point, did you learn everything that was on that text chain?
Yes.
And as a result of that text chain, was there an investigation?
There was.
And during that investigation, you were Michael Proctor's supervisor?
I was.
After the investigation was done, did the state police make any finding against you for that text chain?
Yes, there were 2 sustained findings as a result of that investigation.
Did you initiate that text chain?
No, I don't believe so.
You did react with a thumbs up?
I acknowledged the text message that he sent, or portion of the information that came through on my watch.
And the 2 sustained findings against you, were one of them for failure to adequately supervise?
Yes.
And the other, was it regarding a routine or regular review that it didn't consider that text chain? I'll rephrase.
Okay.
That second sustained finding, was it regarding a review of the performance level of Mr. Proctor?
That's correct.
Sustained is to full.
Was there a second sustained finding?
Yes, there was.
Did it relate to the review process of a subordinate?
Objection. Sustained is to full.
Okay. What was that second sustained finding about?
The accuracy of the review of the quarterly performance evaluation.
You said quarterly. How often would you write reviews for subordinates?
Every 90 days.
Was there any other sustained finding against you?
No.
Was there punishment in light of those 2 sustained findings against you?
There was.
And what was that punishment?
I lost 5 vacation days.
Do you presently work in the Homicide Division of the Norfolk County District Attorney's Office?
I do.
Are you currently a sergeant?
I am.
Have you ever reviewed that entire chain that was at issue?
Only through the documents provided for me during the internal investigation.
May I approach, Your Honor?
Yes.
May I stand here?
Sure.
Sir, I'm going to ask you to take a look at that document. And if you turn the page, does it begin to, one more page, please. Does it begin to reflect the email chain?
Yes, it does.
Do you remember this email chain?
I remember seeing it when I reviewed it. I don't remember the intricate details of these messages.
Do you remember that photograph?
I don't.
Okay, could you turn the page? Is there text?
Yes, there is.
Without citing the phone numbers, I'd like you to cite the author of the text, and I'd like you to read the text to the jury.
Do you want me to date it in time or no?
Sure.
August 17th, 2022, 9:44 p.m., 25 seconds. Funny, I am going through his retarded client's phone.
I'd like you to read all of them, please.
Next one, no nudes so far. I hate that man. I truly hate him.
Hey, can you give the author for each comment? And can you start again, because I want us to understand.
I'm sorry, can you repeat that?
The author, whoever makes the comment, I'd like to have the name of the author.
I'm sorry, this document does not identify who the author is, sir.
Okay.
Yes.
It identifies this as your phone,
That is, yes.
but each comment doesn't identify who sent it.
No, it does not. I assume it's an extraction from one device, but
I see. If you've made any of the comments yourself, would you tell us?
if I made those comments?
No, if you make any of them in here as you read them, will you point out if you...
Absolutely, absolutely, yes.
Okay. And if you don't know who made the comment, could you just identify that for us as you read it so we know?
Okay, do you want me to continue the next page?
Why don't we start over, because I
Okay.
should have been more clear in my direction. Could you begin again?
So in the beginning, it says, funny, I am going through his retarded client's phone.
Is that your comment?
No, it is not.
Okay, next.
It appears to be the same person because of the way that the extraction happens, and it says no nudes so far. Again, this, I believe it's the same person because all of these are identified as sent. It says, I hate that man. I truly hate him.
Do you have any belief that's Michael Proctor who was writing these?
Yes, I believe that is.
Next, please.
There's a blank page, and that's the end. Yes, sir.
Did you say you were suspended 5 days or lost 5 days vacation?
Lost 5 days of vacation.
Okay. And have you continued on your cases?
Yes, I have.
I want to...
Isn't it correct that for hypothermia in the presence of Wisniewski's ulcers or spots, that you have to have a predominance of the stomach covered by the spots for them to be Wisniewski ulcers?
I think there's different levels and different grades.
In hypothermia, particularly death from hypothermia, wouldn't you expect to see a predominance of those ulcers, meaning they take up most of the stomach lining? Isn't that what you would expect to see?
Not always. I have seen that. I have also seen cases with much fewer
spots, as you refer to them.
But isn't the majority of the cases that you have seen where someone has actually died from hypothermia that the ulcers predominate, take up greater than 50% of the stomach?
Yes.
And what percentage of the, and I'm trying to avoid putting it up again, so what percentage of the gastric mucosa of Mr. O'Keefe would you estimate is taken up by the ulcers that you have identified?
I would say somewhere between 10 and 15%.
Just 10 and 15%. Thank you. Now, if we could look to the issue of continuing with hypothermia. Let's go to frostbite. Do you note any evidence of frostbite on the decedent, Mr. O'Keefe?
No, I did not.
Do you know what the weather conditions were in Canton, New York on the early morning? I'm sorry, I keep saying Canton, New York. My apologies. Do you know the weather conditions in Canton, Massachusetts, starting at midnight on January 29, 2022, going through 6 a.m. on January 29, 2022?
It was very cold. There was a blizzard coming.
They called it a nor'easter, right?
Correct.
And when you say very cold, in addition to very cold, do you recall whether there were gusting winds?
I believe so.
And do you understand that when there's a very cold temperature in Fahrenheit and you add gusting winds, that is called, when you apply the two together, that's called wind chill, right?
Correct.
And with wind chill, doesn't the phenomenon of wind chill mean that the wind combined with the temperature brings the actual temperature down, and in addition to bringing it down, temperature in a wind chill calculation, it also has a physical effect on the body, correct? Wind chill. Doesn't wind chill also cause greater effects than if there was no wind?
Correct.
So in medical terms, the wind synergizes with the temperature and exacerbates the effect on a human.
Correct.
And with a wind chill, isn't it correct that you would have a greater chance of frostbite than if there was no wind chill effect at all?
Yes.
So, you saw no signs of frostbite on Mr. O'Keefe, correct?
At the time of my examination and at the time of autopsy, no, I did not.
Did you see frostbite at any other time with regard to Mr. O'Keefe?
I only examined him at the time of autopsy.
So at the only time you examined him, which is at the time of autopsy, you had zero signs of frostbite, correct?
Correct.
Dr. Scordi-Bello, now that you have gone through this part of your examination here today, would you like to amend in any way your opinions as to whether hypothermia was any cause of the death of Mr. O'Keefe?
No, I don't. I still believe that there were hypothermic signs.
Hypothermic signs, correct?
Yes.
I'd like to move to another topic area, please. You did not include in your autopsy in any fashion any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you?
No, I did not.
In fact, there were no injuries consistent with a motor vehicle impact on Mr. O'Keefe, correct?
Sustained.
Did you evaluate it all in your autopsy whether Mr. O'Keefe had any injuries consistent with a motor vehicle accident?
Objection.
I'll allow that.
Yes, I did examine his lower extremities. That is protocol in any case of suspected impact with a motor vehicle. So I did examine his legs, and I did not see any evidence of an impact site.
And could you elaborate to the jury what you mean by no evidence of an impact site? Objection.
I'm going to sustain that objection.
What do you mean in your answer, no evidence of impact injuries?
I'll allow that.
What I look for is some sort of bruise, either on the outside of the leg or bleeding on the inside after the skin is reflected in the soft tissues, or any fracture of the bones of the legs. I did not observe those things.
That was going to be my question. You did not observe any of those things, correct?
Correct.
I'd like to turn to, please, the face of the decedent in your analysis that you discussed on direct examination of that area of the decedent. You talked about ecchymosis, you recall that?
Yes.
In medical literature, there's a synonym for ecchymosis. It's sometimes referred to as raccoon eyes. Is that correct? Ecchymosis doesn't cause a laceration to an eyelid, does it?
No.
Ecchymosis does not cause a laceration to a nose, does it?
There was an abrasion on the nose, but no, the answer is no.
Correct. So ecchymosis doesn't cause a laceration to the nose. Correct?
Correct.
Did your report at all evaluate whether there was any significance of the laceration to the eyelid that you spoke about in your direct testimony?
What do you mean?
Other than just noting that there was a laceration to the eyelid, did your report at all evaluate the potential significance, if any, of that laceration to the eyelid?
I noted it and photographed it, and it was part of the totality of the blunt impact injuries that I noted on both the face and the head.
Do you believe that the laceration to the eyelid could be caused by a blunt impact injury?
A laceration, by definition, is a blunt impact injury.
Do you believe the eyelid laceration was caused by a blunt impact injury from falling backwards and hitting one's head?
Not from falling backwards and hitting one's head, but that area at some point came in contact with a blunt object or surface.
Okay, if I could follow up on that, please. So you agree that if a person falls and hits the back of their head, that they cannot sustain an eyelid injury, is that correct?
Correct.
All right. And if somebody falls backward and hits their head, they can't sustain, from that impacted back of the head, a laceration to the nose, correct?
Correct.
So if we could, Mr. Wolk, and with Your Honor's permission, publish which is already in evidence, which are depictions. Let's start out with, please, the laceration to the right eyelid. And Dr. Scordi-Bello, is this the laceration to the right eyelid that we've been talking about of Mr. O'Keefe?
Yes, it is. Yes, it is.
And that injury could not be caused by a fall backwards and one hitting their head, correct?
No.
I'm sorry, we'll just need, and then I'm going to repeat the question. Can you state your answer again? Let me that injury to the right eyelid, that laceration, could not be caused by someone falling backwards and hitting their head, correct?
Correct.
Bear with me one moment, Your Honor. May I approach, Your Honor?
Yes. Show Mr. Brennan.
Your Honor, I erroneously assumed that that picture was in evidence, and I would like to now properly lay the foundation if I could. Dr. Scordi-Bello, you see what's in front of you. Can we mark this?
So, Mr. Brennan, are you objecting to that coming into evidence? Okay, so let's just put it in evidence.
Exhibit 165.
Thank you.
May I, Your Honor?
Yes.
Thank you. Dr. Scordi-Bello, I place before you what is in evidence now is 165. And Your Honor, may I have Mr. Wolk publish 165? Thank you, Mr. Wolk. So, Dr. Scordi-Bello, that laceration to the right eyelid could not be caused by a fall backwards where someone hits the back of the head, correct?
Correct.
So that injury you've called, what do you label that category? Traumatic, did you use that phraseology?
Blunt
Blunt
impact.
impact. So that's a blunt, in your opinion, that's a blunt impact injury, correct?
Correct.
So is it correct that that injury had to occur in some manner other than falling backwards and hitting one's head?
Yes.
And is that injury consistent or inconsistent with a punch?
I'll allow it.
Could be consistent.
If we could, Mr. Wolk, have the laceration to the nose. I'm sorry, hold off on a moment. Your Honor, Mr. Brennan has agreed to stipulate that this going
Okay,
into
so like we can mark it.
Exhibit 166.
Oh, thank you.
Thank you. May I, Your Honor?
Yes.
Thank you. Dr. Scordi-Bello, I have put before you what is in evidence is 166, and Your Honor may, Mr. Wolk, publish.
Yes.
Thank you. Dr. Scordi-Bello, does that exhibit fairly and accurately depict the laceration to the nose of Mr. O'Keefe?
Yeah, it's an abrasion. I described it as an abrasion, as a scrape.
So you would classify that as a scrape?
Yes.
That scrape could not be caused by someone falling backwards and hitting the back of their head, could it?
Not by a single event, no.
You can take that down, Mr. Wolk. On your direct testimony, you talked about injuries to the right arm of Mr. O'Keefe. Do you recall that?
Yes, I do.
And is it correct that you, in your autopsy report, did not determine the cause of those wounds to Mr. O'Keefe's right arm?
That's correct.
With Your Honor's permission, I would like to Mr. Brennan. Your Honor, Mr. Brennan has agreed to stipulate into evidence these two photographs. May I please have them marked as next in evidence?
Exhibits 167 and 168.
Thank you.
I'm going to do the same thing, if I may, Dr. Shorty-Bello. I'm going to leave these with you, but I'm also going to, with the court's permission, have them published.
Okay.
Use whatever one best allow you to answer the question. Your Honor, may I have Mr. Wolf publish those two? Thank you. With regard to what is on the screen, am I correct that you noted these injuries and these wounds to Mr. O'Keefe in your autopsy report?
Yes.
And am I correct that you noted that there was a pattern to those wounds?
Correct.
And although you noted there was a pattern to the wounds, you were not able to determine the cause of those pattern wounds. Is that correct?
That's correct.
Are those injuries consistent with a dog bite?
Based on our answer to the last question, ask something else.
I'm sorry, couldn't hear you.
Ask another question, sustained.
Can you identify any cause of those injuries that would be consistent with what is depicted on the screen? Objection.
So, can you answer that, Doctor?
I cannot.
You can take that down, Mr. Wolf. Thank you. Do you recall discussing at all on your direct examination? Well, let me ask it this way. Did you evaluate at all in your autopsy a gray hoodie sweatshirt of Mr. O'Keefe?
No, I did not.
So, were you aware that there was clothing associated with Mr. O'Keefe when he came as part of the autopsy?
He did not have any clothing that came to us. The clothing was removed at the hospital and was packaged and I believe submitted as evidence.
So the clothing of Mr. O'Keefe, a t-shirt or a hoodie, didn't make its way to you?
No.
You were unable to reach a determination as to the manner of death of Mr. O'Keefe, correct?
That is correct.
So you had doubts about the manner of death of Mr. O'Keefe, and you consider those doubts reasonable?
Sustained. Sustained.
You were not able to reach a determination as to the manner of death of Mr. O'Keefe, correct?
Correct.
And manner of death, as you've testified, includes the circumstances surrounding death in addition to the medical analysis that you performed.
I'm sustaining it, asked and answered.
Please, Your Honor, could you please again introduce yourself to the jury, spell your last name for the record?
I'm Trooper Nicholas Guarino, Guarino.
You would explain what an extraction report is.
Yes, it's the information in the cell phones. We can create PDFs or portable cases from information, whatever is specified.
An extraction report, can it be general or more narrow?
Yes, it can be.
I want to introduce a few more extraction reports that we didn't get to last time.
Okay.
In this case, did you use Mr. O'Keefe's phone to create an extraction report that included all of his calls from the 28th and the 29th of January 2022?
Yes, I did.
May I approach, Your Honor?
Yes.
And your document, do you recognize that document?
Yes, I do.
And what is it?
It's John O'Keefe's call logs from everyone from the 29th to the 28th. Right.
I move this into evidence, please.
No objection, Your Honor.
Thank you.
65.
Did you create an extraction report that included a text message between the defendant and Jennifer McCabe?
Yes, I did.
May I approach, Your Honor?
Yes.
And in your document, do you recognize that?
Yes, I do.
Can you tell us what that is?
Yes, it's the text chain from the defendant to Jen McCabe.
I move this into evidence, please.
No objection, Your Honor.
Thank you.
Civic 66.
One moment. Thank you. With the court's permission, could Mr. Guarino read this to the jury?
Okay. One quick question.
Could you kindly read that and explain it to the jury?
With all the information on it?
Yes.
This is from the defendant to Jen McCabe, 7:26:52 a.m. on the 29th. It says, can you send me Kerry's number?
Thank you. Did you further create an extraction?
Sorry, Mr. Brennan. In terms of that reading of the document, you just have to check on that, please. Sorry.
No problem.
Yes.
Can you review that again?
Yes.
And do you see who that's from? And who it's to?
I'm sorry, it's from Jen McCabe to the defendant.
And what does it say?
Can you send me Kerry's number?
What time and date?
That is 7:26:52 a.m. on April 29th, 2022.
Thank you. Did you do a further extraction report from John O'Keefe's phone with text messages between him and a person named Kaylee?
Yes, I did.
May I approach?
Yes.
You recognize that?
Yes.
What is it?
It's the text chain between John O'Keefe and Kaylee.
The date?
It goes, sorry, it's kind of faded. January 28th, 2022 to January 29th, 2022.
Thank you. I'd move this into evidence.
No objection, Your Honor.
Okay.
Thank you.
Exhibit 67.
Okay, Trooper Garino, we're done with extraction reports.
Okay.
Did you have an opportunity to obtain phone messages, phone calls, and text messages between the defendant and Mr. O'Keefe?
Hold on. Thank you.
Thank you, Your Honor. Trooper Garino, did you have an opportunity to obtain phone calls, voice messages, and text messages from the defendant to Mr. O'Keefe's phone on the evening of January 29th, 2022?
Yes, I was.
Where did you get the phone call records from?
From John O'Keefe's phone.
Where did you get the voicemails from?
Also from John O'Keefe's phone.
Where did you get the text messages from?
From John O'Keefe's phone.
Did you have an opportunity to take those phone calls, the voice messages, and the text messages and put them in a chronological order?
Yes, I did.
Did you include all of the phone calls, all the text messages, and all of the voicemails?
Between John O'Keefe and the defendant, yes.
Did you create a PowerPoint to put them in a chronological order?
Yes.
May I approach, Your Honor?
Yes. Show Mr. Alessi.
Sorry. Showing you a binder, sir. Could you open it up? Tell us what this is.
Yes, this is the phone calls and text messages between the defendant and John O'Keefe, as well as the voicemails. Well,
Is there a package in the front of that binder?
yes, there is.
And what is that package?
It says defendant's voicemails and on 1/29/2022. The USB thumb drive that should have those files on.
Your Honor, I move this binder as the next exhibit. It would include both the PowerPoint presentation as well as a clip of the phone calls.
No objection, Your Honor.
Should, yes. Do you need the thumb drives?
I don't.
Okay.
Mark this, please.
Exhibit 68.
Thank you.
Thank you.
With the court's permission, I would ask that Trooper Garino take us through the PowerPoint presentation.
Yes.
Thank you.
Is it okay to begin? Okay.
Please.
So these are the phone calls on the 29th. So at 12:33:35 a.m., the defendant calls John. That phone call is not answered. 12:34:09 a.m., the defendant calls John. It's not answered. 12:34:38 a.m., the defendant calls John. It's not answered. 12:35:09 a.m., the defendant calls John. Not answered. 12:35:35, the defendant calls John. It's not answered. 12:36:09 a.m., the defendant calls John. It's not answered.
Trooper Guarino, let me stop you there for a second.
Mm-hmm.
Did you look into any internet connection between the defendant's phone and the router and the internet connection at Meadows Ave, John O'Keefe's home that night?
Yes, at 12:36:39 a.m., the defendant's phone auto connects to the Wi-Fi HATSFAN 123.
Are you familiar with the router at Mr. O'Keefe's home?
I have not done a look at it in person, but that's the known network that's listed under it. There's two, HATSFAN 123 and O'Keefe 74.
Did you learn the range that a connection must be in order to connect to his router?
Yes, so depending on the router, it's either a 2.4 gigahertz or 5 gigahertz radio band or signal band, I should say. Depending on which one it's connecting to, which band, it's either 150-foot indoor range or up to 300 feet outdoor. So again, when you pull into your home, sometimes you can still be connected to your home Wi-Fi in the driveway.
And again, can you give us the time of the connection between the defendant's phone and Mr. O'Keefe's router at Meadows Ave that night?
Yes, 12:36:39 a.m.
Please continue.
At 12:36:40 a.m., the defendant calls John. It's not answered. At 12:37:08 a.m., the defendant calls John, and voicemail number 1 is left with voice.
Ms. Gilman, would you kindly play the voicemail for 12:37:08?
At 12:38:26 a.m., the defendant calls John. It's not answered. 12:39:03 a.m., the defendant calls John. It's not answered. 12:39:37 a.m., the defendant calls John. It's not answered. 12:40:43 a.m., the defendant calls John. It's not answered. At 12:41:35 a.m., the defendant calls John. Voicemail number 2 is left. Some beeping noises, appears to be a butt dial or accidental call.
Ms. Gilman, could you play the voice message at 12:41:35?
The defendant then texts John O'Keefe at 12:55:31 a.m. on the 29th, "I'm going home." The defendant texts John O'Keefe, "See you later," at 12:55:50 a.m. on the 29th. At 12:58:19 a.m., the defendant calls John. It's not answered. 12:58:47 a.m., the defendant calls John. It's not answered. 12:59:24 a.m., the defendant calls John. Voicemail number 3 is left with voice.
Ms. Gilman.
John, I'm here with your kids. Nobody knows what the pervert.
At 1 a.m. and 26 seconds, the defendant calls John. It's not answered. At 1 a.m. 49 seconds, the defendant calls John. Voicemail number 4 is left. It's 1 second called, no sound.
Ms. Gilman.
That was it. The defendant texts John O'Keefe, "Your kids are cucking alone," at 1:02 a.m. on the 29th. The defendant texts John O'Keefe, "I'm back in Mansfield. The kids are home alone," 1:04:14 a.m. on the 29th. At 1:10:17 a.m., the defendant calls John. Voicemail number 5 is left with voice.
Ms. Gilman?
Yeah, it's 1 in the morning. I'm with your nephew. You pervert. You're a pervert.
At 1:10:44 a.m., the defendant calls John. It's not answered. At 1:12:18 a.m., the defendant calls John. It's not answered. 1:12:46 a.m., the defendant calls John. It's not answered. 1:13:13 a.m., the defendant calls John. Not answered. Sorry. At 1:14:11 a.m., the defendant calls John. It's not answered. 1:14:44 a.m., the defendant calls John. Not answered. 1:16:10 a.m., the defendant calls John. Not answered. 1:16:38 a.m., the defendant calls John. Not answered. At 1:17:37 a.m., the defendant calls John. So when voicemail 6 is left with voice.
Ms. Gilman?
John, I'm going home. I cannot babysit your niece. I need to go home. You are using me right now. You're another girl. Kaylee's sleeping next to me. You're a loser. Go.
At 1:18:38 a.m., the defendant calls John. Not answered. At 4:38:14 a.m., the defendant calls John. Not answered. 4:38:49 a.m., the defendant calls John. Not answered. 4:39:39 a.m., the defendant calls John. Not answered. 4:40:05 a.m., the defendant calls John. Not answered. 4:42:05 a.m., the defendant calls John. Not answered. 4:42:54 a.m., the defendant calls John. Not answered. 4:45:10 a.m., the defendant calls John. Not answered. 5:04:27 a.m., the defendant calls John. Not answered. 5:21:28 a.m., the defendant calls John. Not answered. 5:21:58 a.m., the defendant calls John. Not answered. 5:23:26 a.m., the defendant calls John. Voicemail number 7 is left with voice.
Ms. Gilman?
At 5:24:27 a.m., the defendant calls John. Not answered. 5:25:28 a.m., the defendant calls John. Not answered. 5:26:14 a.m., the defendant calls John. Not answered. 5:28:16 a.m., the defendant calls John. Not answered. 5:28:43 a.m., the defendant calls John. Not answered. 5:29:21 a.m., the defendant calls John. Not answered. 5:29:46 a.m., the defendant calls John. Not answered. 5:30:15 a.m., the defendant calls John. Not answered. 5:30:52 a.m., the defendant calls John. Not answered. 5:31:21 a.m., the defendant calls John. Not answered. 5:36:29 a.m., the defendant calls John. Not answered. 6:03:02 a.m., the defendant calls John, and voicemail number 8 is left with some voice and noise and background.
Ms. Gilman, could you play that, please?
Yes, I need someone to report it. 34 beautiful kidnapped living in Pepper's now. Yeah. Okay, I know. Where's the blankets? I don't see blankets, Harry. Yes, I need some.
We have the lights on, please. I have no further questions.
May I, Your Honor?
Yes.
Thank you. Dr. Scorti-Bello, have you, are you aware of an attorney named, or excuse me, a doctor named Azik Wolf?
No, I'm not.
Now I'd like to move on to another category. Based on the information that was presented to you as part of your examination and analysis, is it correct that you presume that because Mr. O'Keefe's body was found in the snow and his body temperature was 80 degrees, that he died from hypothermia as one of the causes?
I reached that conclusion after performing the autopsy and after seeing some findings that were consistent with hypothermia and then combined with the information that was provided to me about Mr. O'Keefe's body being found in the snow, I came to the conclusion that was one of the things that contributed.
Did you consider whether there may have been other reasons as to why his body reached that temperature of 80 degrees? sort of applying the scientific method and seeing if there were other reasons?
Other than being out in the snow, no, I do not.
Do you know whether there are other alternative reasons how his body could reach the temperature of 80 degrees?
People can become hypothermic for other reasons, such as sepsis. But in this particular case, I didn't have any reason to believe that that was part of the circumstances.
You're familiar with the medical phrase differential diagnosis, correct?
Yes.
And a differential diagnosis is a term that's used by doctors to pursue other potential causes of a medical injury. Is that a fair general statement?
Yes.
So, for example, if somebody is having difficulty breathing, a doctor may say, I think it's the heart is their primary hypothesis, but they may want to differentially diagnose this and look at the lungs. Is that an example of a differential diagnosis let's look at the lungs to see if that may be the problem? Is that a good, fair example?
In the example you're giving, yes.
So applying that concept, and do you believe the concept of, applying that concept to this situation, did you perform a differential diagnosis as to the cause of the death and question whether there was hypothermia as any cause of the death of the decedent? Did you make that analysis?
I looked at the anatomic findings that I had at the time of autopsy, the information that was provided to me based on the circumstances and where the body was found, and I came to the conclusion that there were hypothermic changes in Mr. O'Keefe's body.
So you just used the phrase hypothermic changes. Did I hear that correctly?
Yes.
Can there be hypothermic changes without a cause of death being hypothermia?
Yes, of course.
So you can have signs in the body of hypothermia, but you can also conclude that a cause of death is not from hypothermia, correct?
If the person is deceased and I am examining the body and there are multiple things that I believe contribute to the death, then I tend to include all of them. Meaning that if this was a drug intoxication and the body also showed signs of hypothermia, I would include both of them on the death certificate, because there is no scientific way of teasing out whether it was just one or the other or both. In this particular case, I had two processes that were going on. One was the head trauma, and the other one were these hypothermic changes. I put all that together, and again, included or took into account the investigative information of where the body was found, what the temperature was when the body was found, whether the person was still alive or not, and I came to the conclusion that the cause of death was blunt impact injuries of head, and I included the hypothermia because I saw during the autopsy that there were changes consistent with hypothermia.
So I want to break that down a little bit, if I could, with you. So you testified on direct, and I think you alluded to it here, that the primary cause of death, use that phraseology on direct, was blunt force injury. Is that correct?
Blunt impact injuries to the head, yes.
Blunt impact injuries to the head, and that's the primary cause, right?
Correct.
And then there's, and I'm not clear on what you refer to on direct as a secondary cause, of death of hypothermia, but you've used a little different phrase in some of your answers, and I want to make sure I got it right. Hypothermic considerations. Can you repeat what it was?
I said have hypothermic changes.
Hypothermic changes, and we agree that you can have hypothermic changes without a conclusion of hypothermia, correct?
No, hypothermic changes are what I'm referring to are actual things that I can see in the organs that are consistent with hypothermia. They're anatomic findings. They're things I can see with my eyes.
So you can, I'm sorry, did you finish?
And those changes suggest and are consistent with someone being hypothermic.
As you sit here now, with regard to, you used the phraseology consistent with hypothermia, signs of hypothermia, that's what I want to pursue just a little bit with regard to further information. We got started on this by asking whether you used the concept of differential diagnosis and hypotheses to determine the cause and manner of death. And you said in one of your answers that you relied upon law enforcement information, correct? Is that
Yes.
part of it? It was, you brought that up. You're the one who said you relied upon that, correct?
Yes.
And you've brought that up on your direct testimony and earlier in the cross. Is that correct, that you relied upon the investigation of law enforcement? So,
Sustained.
so now what I'd like to do is to ask you whether, using the concepts of differential diagnosis, scientific method, did you consider whether Mr. O'Keefe could have died somewhere other than where the body was found and been moved and placed in the snow? Did you consider that?
Objection. Sustained.
May we approach, Your Honor?
Move along with this. We can approach in a bit.
Thank you. What, if any, alternative diagnoses did you apply to Mr. O'Keefe?
I don't understand your question.
What alternative scenarios did you look at, if any, for the cause or manner of death of Mr. O'Keefe?
I'll allow that question. What, if any?
At the time of the autopsy, I documented injuries and signs of hypothermia. I was provided with a set of circumstances, and at the end of the investigation, or at the end of my timeline, I concluded on the cause, but I did not conclude, or I did not determine a manner. The manner would be the circumstances you are speaking about, whether I considered other causes or circumstances. That's not how it works. I don't come up with hypothetical scenarios on how those injuries occur. I try to state the injuries, describe the injuries, state the cause of death and why that person died, and then I use all kinds of other investigative information that is provided to me to determine if I have enough to make a determination on the manner.
Did anyone provide to you any alternatives as to the finding of the body of Mr. O'Keefe in the snow?
Personally, to me, no.
Did you ask for any alternatives? to the nature and location of the injury or death of Mr. O'Keefe?
I asked for all the information that was available.
Understood, but my question is, did you ask for any alternatives to the information that was provided to you as regards the location of the injuries? Did anyone provide you any alternatives to where the injuries could have occurred?
No.
So
I'm going to let the answer stand. So the answer is no, so there's no evidence of that. So next question.
So you talked about the information you had at the time. What time is that?
The information at the time was a preliminary police report and verbal communications regarding the circumstances of how Mr. O'Keefe's body was found.
And when I asked about the time, I'm not calendar time. Was this January, February, March, April of 2022?
The preliminary police report was on the day of the autopsy, and then information, I don't remember exactly how long, but in the weeks following, information was coming in.
Do you have the ability to amend a death certificate?
Yes, I do.
And you can amend a certificate if you obtain further information with regard to the circumstances surrounding the death. Is that correct?
That's correct.
In your previous answers, you were talking about the information you had at the time. And I'm concluding that the latest that would be is April of 2022. Is that correct?
Correct.
Have you obtained or been provided with further information, in other words, information after April of 2022 regarding the cause or manner of death?
It is not. I would ask that we mark as next in order. Thumb drive.
Are we marking this for identification, or is there an agreement it's going into evidence?
I'd like it into evidence.
We agree with the stipulation that it's authentic.
I'm not going to argue metadata issues or authenticity issues. So,
All right, so is there a stipulation that this is authentic? Okay, so folks, again, a stipulation means the parties agree, and with that, I will allow this into evidence as the next exhibit. Madam Court Reporter?
Mr. Jackson, is this it?
That's it.
Exhibit 118?
Okay, now you may display it.
Thank you. Okay. Could we play beginning? What's the runtime, Mr. Wolk? 5:37:03. This is at 5:37:03. If we could just play this forward for a couple of seconds. A little bit further. Pause. Do you see what's depicted in this video?
Yes, I do.
This is the video that you were shown at a prior proceeding, correct?
Yes, it is.
Does this appear to be the interior of the Sallyport at Canton PD?
Yes, it is.
And this is what you were questioned about regarding the SUV being pulled into the Sallyport, correct?
Yes.
From a time frame standpoint, just the time frame, this is right after the SUV has been driven in from the flatbed after having been seized in Dighton, correct?
Yes, it was driven off of the flatbed after transportation from Dighton to Canton PD and driven into the Sallyport.
All right. You previously have identified individuals in this video, in this still shot, correct?
Yes.
And what you previously said, and then we'll get to subsequent testimony in a second, you previously indicated that the person to the right was you, person to the left, Michael Proctor, correct?
Yes, previously I identified that being Michael Proctor. I was mistaken. That is not me on the right.
That would be the tow truck driver, correct?
That's correct.
Okay. That is, in fact, Michael Proctor, however, in the two-tone jacket, correct?
I believe so.
Okay. And as the video is portrayed, at least as we're looking at it, and I'll get to the next question next, as we're looking at it, it appears that we're looking at the right passenger side of the vehicle, as it appears in this video, correct?
That's correct.
And you see a timestamp and a date stamp on the bottom, correct?
It is present. I don't know what it says.
Okay, can we highlight that just a little bit? Can you see what that says?
I believe it says interior Sally Port back wall.
Okay.
537, maybe.
Okay. When you indicated that this was a fair and accurate depiction of the interior Sally Port when the SUV was brought in, you were specifically asked whether or not you or Michael Proctor approached or manipulated or touched the right rear taillight area of the vehicle, correct?
I don't remember the exact verbiage used, but in something along those lines, that's what was asked.
And you indicated that neither of you did, correct?
That's correct.
Okay. But in point of fact, this video is backward, correct?
Yes, it is a mirror image of what is actually taking place as recorded by the camera.
Can we play this forward?
Yes.
Do you see where Mr. Proctor, let's go ahead and pause it. Do you see where Mr. Proctor went?
Yes, the video depicts him going to that portion of the vehicle, but we can't tell how close he is.
Okay. And the back, from all appearances, importantly, it appears to be the back driver's side, back left of the vehicle, correct?
That's the way it appears, yes.
Great. Let's play this forward for a second. Pause. Can I ask you to pay special note to the far rear side of the vehicle? Do you see what appears to be Mr. Proctor's head?
Yes.
As the tow truck driver walks past the rear of the vehicle, can you watch and tell me if you see Mr. Proctor do anything or move in any way? Let's go ahead and play it forward. Pause. Did you see any volitional movement by Mr. Proctor as the tow truck driver moved past him?
Yes, it appears if that is his head, it shifted weight.
Okay. Let's go ahead and play it forward. Stop. Did you see a person that appeared to morph toward the back of the vehicle? Right there.
There is some anomaly there with the footage, so it could possibly be used to describe that what took place.
Can you recognize that person?
I cannot know.
You indicated previously, does that person look large or small in stature?
I can't tell.
As compared to, for instance, Michael Proctor, whose head you can see above the car. What about this person? Taller, shorter than Michael Proctor?
I can't tell from here. I can't.
You indicated that Chief Berkowitz was a smaller statured person, correct?
I never said that.
I'm sorry?
I didn't know his height.
Larger or smaller? Generally. How about this? Larger or smaller than you?
He's shorter than me.
Okay. Can you tell whether or not that is Chief Berkowitz?
I cannot know.
Okay, let's go ahead and play it for him. And a little bit further. Pause. What does it appear that Mr. Proctor does at this point in the video?
He's walking.
Okay. Do you see anything in his hand?
I cannot tell from the video, but he might be carrying something.
Remember we looked previously at a portfolio, black portfolio. Does it appear that he may have a black portfolio in his hand?
That is very likely, but I don't know exactly what he's carrying.
Okay, let's go ahead and play this forward. Okay, and did it appear that somebody just appeared at the front right, the right-hand side of the screen toward the front of the SUV as well?
Yes, it appears that way, yes.
Okay. Let's take this down. I'd like to mark. I have another electronic device, a thumb drive, that has another video on it, Your Honor. I'd like to have that marked as next in order. Court permission.
All right, so there's no objection, Mr. Brady?
No objection, thank you.
Okay.
Exhibit 119.
With the court's permission.
Yes.
Now, Sergeant, what does this show?
It appears to be the mirror image of the previous footage. I don't know the exact timestamp there, but
Can we increase the date and time? Do you see, can you read the date and timestamp on this Chiron?
I cannot know.
It's because it's backward, correct?
I can't read it. I can't make it out, sir.
Can you make it any bigger, Mr. Wolk? Does that appear to be backward?
Based on me recognizing some of the digits, it does appear to be backwards.
Okay, let's look at the whole screen again. Sergeant, let's play this forward for just a quick second. Pause. Do you see Michael Proctor in this video?
I believe that's him, yes.
And which side, and let's start with this. Do you agree that this is the correct version of the camera angle and the SUV as it pulled into the salad door?
This is the footage, the way that is depicted right now is very accurately very accurately represents what I remember from being there.
In fact, this side of the vehicle that we're looking at that's closest to us, that I'm highlighting on the screen to your right, that is in fact the driver's side of the vehicle, not the passenger side of the vehicle. Is that correct?
That is correct.
The far side over here would be the right rear of the vehicle, correct?
Yes, sir.
Which area is Michael Proctor walking to? The left rear or the right rear in this footage?
It appears if that's him, he's walking to the right rear of the vehicle.
Can we play this forward? And do you see Mr. Proctor's head above the SUV?
Yes.
And watch him as the tow truck driver walks by. Did he appear to move?
He shifted weight, yes.
And it appears that there's another person that showed up in the footage, an anomaly of some sort, walking off screen left to right. Is that right?
That's what it appears, yes.
Is Mr. Proctor still at the right rear taillight area?
He's in that general vicinity, yes.
Let's go ahead and play it forward. little bit further. Pause. Can you see anything in his hand? Let me just ask it closed in. Do you see the portfolio in his hand?
It would not be unlikely that it's there, but I can't tell exactly what it is in his hand.
Let's play it forward. Do you see anything in his hand now as his arm?
Yes, yes.
Does it appear to be consistent with the black portfolio that we saw earlier?
Yes, it is, yes.
Let's move forward. And he is now off screen, correct?
Yes.
So, in point of fact, Sergeant, when you were asked previously whether the prior video fairly and accurately depicted what you recall as it pertains to the SUV and the Sally Port, that was not quite true, correct?
Objection.
I'll allow it.
The way I understood the question is what I'm watching accurately depicts what's taking place. It is. Just because it's a mirror image doesn't mean that it's not recording what the actions and what is transpiring.
But you would agree, at least, that the previous video showed exactly the opposite of what was true and correct, not just a mirror image. What was left is right, and what is right is left, correct?
Stages to that form.
Would you agree that in point of fact, a mirror image video is not a true and accurate depiction of what's depicted in a scene?
I think it just is a mirror image of what's taking place. If you see someone walking in or driving a vehicle and it's depicting the action of the vehicle being pulled in, and if it's mirrored, it's pulling in from left to right or right to left. It's still documenting the activity that's taking place.
Or if someone walks to the left rear of the vehicle versus the right rear of the vehicle, those two things will be switched, correct?
That is correct, yes.
And you'll agree that the prior video that we showed, that you and I just talked about, the inverted video, appeared for all intents and purposes to show Michael Proctor stay away from the from the right rear taillight, walk all the way around, and position himself to the left rear taillight. You'd agree with that, correct?
Objection.
Do you agree with that? I'll allow it.
It appeared that that is what was happening, but he was standing next to the taillight that was already damaged.
But in the corrected video, which is this one, it actually shows unequivocally that Michael Proctor walked directly to the right rear taillight portion of this SUV. Correct?
I'm sorry, can you repeat that?
Sure. In the corrected video, this video here, this unequivocally shows that Michael Proctor walked toward the right rear area of that SUV, where the right taillight is. Correct?
Yes.
And you'll also agree that this video was taken before any taillight material was ever found at 34 Fairview, correct?
Can you zoom in on the time?
Not on this one, this is backwards.
I know that the SUV pulled into the garage, the Sally Port, at 5:35, and we were still on scene at 5:51, almost 52. So, yes, if that's timestamp before 5:51, before we left Canton PD, then yes, taillight pieces had already been found.
So 5:35, 5:37 is before the first taillight pieces were found. Right.
I'd have to see a timestamp of when they were exactly found, but if
Let me
that...
ask it a different way. 5:37, 5:35 is before 5:45.
Yes.
May I have just a moment, Your Honor?
Yes.
Sergeant, Canton PD is about 1.5 miles from 34 Fairview, is that right?
Approximately. I don't know the exact distance. I never measured it, but I would not be shocked if you were accurate in that.
Maybe a 3 or 4 minute drive.
Depending on the traffic conditions and the weather conditions, that could be a possibility, depending on the speed you travel.
I'm sorry. Your Honor, I have a photograph that I'd like to have marked with the court's permission. If I may approach.
Marked for identification.
Marked for identification for the time being.
Okay.
May I approach?
Yes. Let's mark it first, please.
Thank you. You want me to take a look?
Thank you. Let me ask you a couple of other questions. We just looked at the videos of the interior of the Sallyport. Harkening back to what we just looked at, the corrected video, there would also be a camera on the other side of that Sallyport garage pointing down toward the right rear taillight area of the SUV, correct?
Yes.
There's a camera situated on the opposite side. We'd be looking at that camera, correct?
Yes.
Okay, taking a look at that photograph, I know the quality of it, but can you tell if that appears to be a still image from that camera?
Yes, it appears to be a still image from that video camera.
I'd ask that this be moved into evidence, Your Honor.
Is there an objection?
No objection. Thank you. Thank you. If we could display this for the jurors, Your Honor, just the photograph.
Okay.
Do you see what's depicted? I know the photograph that you're holding is very poor quality. It's a little easier with this lighting. Do you recognize what's depicted in this photograph?
I'm sorry, your laser was bouncing off on the ceiling. I
I was trying to
apologize.
make it easier for you.
Yeah.
This photograph here.
That appears to be the seized SUV belonging to the defendant, with it being situated inside the Sallyport.
And what is that vehicle there?
It's an antique police cruiser.
And who is this person?
I do not know who that is.
Does that look like Michael Proctor?
I don't know. I'd have to get a zoom in. I don't know.
Would that be, does he have glasses on?
I don't know.
Would it be Chief Berkowitz?
It could be Chief Berkowitz. I don't know.
Can you tell me the date that's on the the date and time stamp at the bottom?
I cannot. I think I might be able to make it out in the actual photograph you printed out. Could I take a look at that?
Sure.
Need the light?
Yes, please, Your Honor. It appears the time is 11:08 and 59 seconds in the morning of possibly January 30th of 2022.
Okay. Let's go ahead and pull this back out full frame.
Thank you.
I wanted to ask you, do you have a point of reference? Does that appear to be the interior camera facing the other direction where the SUV was depicted in the Sally Port earlier?
It's the opposite of what we had viewed earlier, diagonally across, I believe.
So this would be the right rear of the vehicle, correct?
That is correct.
Now I'd like to ask you to take a look at a video. Now that we have that point of reference, you want to have a final video. I can have that marked as next in order, Your Honor.
As next in order, so there's no objection, Mr. Brennan?
I have no objection to that being entered now.
Exhibit 121.
Your Honor, with the court's permission, could we
Yes.
present this? Go ahead and play it. Pause. Can you make out, now that that's paused, can you make out what's depicted toward the top of the screen?
Yes, it appears to be a distorted image of that antique police cruiser.
Okay. And does the area next to the police cruiser appear to be empty? Some snow on the ground?
Yes, it does. Actually, yes, it does look that way, yes.
Okay. So there's nothing next to the police cruiser, at least at this point, correct?
That's what it appears to be, yes.
Can we take a look at the timestamp on this document, or on this frame? I'd ask you to let the jurors know if you can see what the actual run time is on this.
I could see the timestamp. I don't know the runtime, what it's going to be.
It's 5:07, 10 or 12, something like that?
That's the timestamp, yes.
Okay.
Yes, PM.
Now, if we could just play this forward, go back to full screen. Pause. Now, how many seconds would you estimate, just in your head, just went by in real time?
Approximately 5 seconds.
Okay. Do you see something in the video now?
Yes.
What is that?
It appears to be the seized Lexus SUV.
And now let's look at the timestamp. What time is that?
5:47 p.m.
So in about, according to your testimony, in about 5 seconds, the time jumped from before the SUV was in the Sally Port to about 5:50 p.m. after the SUV had already arrived and is now situated in the Sally Port, correct?
Yes, that is correct.
The time frame that we just saw earlier, of about 5:35, 5:36 or so, with you and, with the tow truck driver and Michael Proctor in the video. That is not in this video. It's not captured in this video, was it?
It did not present itself, no.
That's all I have now.
Mr. Brennan?
Good afternoon, sir.
Good afternoon.
You had just asked questions about some of the video footage from the Canton Police Department Sallyport area. Is that fair to say?
Yes, sir.
I'd like to ask you further questions about that. In your investigation, did you obtain camera footage from a number of different angles from the Canton Police Department Sallyport area?
I did.
And one of those series of footages, did that include the interior Sallyport back wall for January 29, 2022?
Yes, it is.
Is that the video that appears inverted, and then we saw the second where it was present as you would see it?
Yes, sir.
Did you look at that video? Did you invert the video in any way?
No, I did not.
Did you investigate and learn whether or not there was any other video in addition to that interior Sallyport back wall where video was set up by the town of Canton that appears inverted rather than forward?
Objection.
I'll allow it.
Yes, the investigation revealed that multiple cameras had a lens applied to it that was inverted.
In addition to the Canton Police Department Sallyport interior back wall, where else did you learn around town there was video that appears inverted?
I believe it is inside the Canton PD, the hallways, possibly. And if I am not mistaken, the other locations within the town of Canton. And
Objection, Your Honor.
Ask the question. No, is that your answer? Is that your final answer?
I wasn't finished, but yes.
May we approach the
Do you have any involvement there in examining or identifying wounds of deceased individuals?
I did. My office was in the medical building, and it was very close to what was the equivalent of the urgent care center on site. And so when the patients would come in with an extreme injury, a very serious injury, or near death, I would frequently go over right to the urgent care because that was my specialty. That was, my interest. And even though there was a doctor or another practitioner assigned to care for the patient, I would oversee that. And I would also, examine the patients, look for wounds, look for, signs of injuries. There were some, in some of these cases, there were some deaths, and I would examine those bodies very carefully for any kinds of wounds, just like I had done in the coroner's office for those years.
To move this along, before you became the chief medical executive at Corcoran, where did you work and what did you do?
So I worked for 29 years, I worked at what's called the Los Angeles County USC Medical Center. Now, I know that's a lot to say. It was a county hospital that was affiliated with a medical school. It used to be called, prior to that, prior to when I got there, it was called General Hospital. It was a 19-story building, General Hospital, well known. And now it's actually called LA General or something of that nature. So, anyways, that's where I worked for 29 years. And as I said, I had a variety of different roles there.
Can you just briefly name off the roles that you had while at the General Hospital?
So, as I mentioned earlier, there was always a clinical component to what I did. I always had shifts in the emergency department where I had to see patients and supervise interns, residents, physician assistants, nurse practitioners. So in addition to seeing my own patients, I would also supervise them as they were seeing their patients. So that was the clinical role. Then there was an administrative role, and my administrative roles ranged from director of what they called life support training, which provided training to the trauma surgeons and the neurosurgeons regarding things such as advanced trauma life support, and also to ER doctors. So director of life support training, director of QA. For many years I was director of the jail unit, which was a very unique unit at this hospital. For a hospital, it was a very unique unit in that it had 3 components: a dedicated ER, for jail patients or patients in custody, a dedicated clinic for in custody patients, and a dedicated inpatient. So it's three sections dedicated to in custody services. I was medical director of that for a while.
In addition to all that, were you also a professor?
I was an assistant professor.
Assistant professor. And what did you teach? Just a brief summary of what you taught.
Well, most of my teaching was clinical, bedside teaching, rather than in lecture halls. I would occasionally give lectures to the residents, the residency group, which was about 50 doctors.
And those residents are medical doctors, correct?
Yes, they are. Yes,
Yep.
they are medical doctors. So I would occasionally give lectures to them, but a lot of the teaching was actual bedside teaching.
Switching gears just a little bit and segueing, over your course of your career as an emergency department physician and otherwise, did you treat individuals with animal-inflicted injuries?
Yes.
And did any of those animal-inflicted injuries involve dogs?
Yes.
And generally, is it correct to say that in terms of dogs, there's sort of the canine police dogs, and then there's the civilian dogs with which most people have experience?
Yes.
Are those two categories that you're familiar with, you're comfortable, as we discuss dogs, to have canine versus civilian?
Yes, because the injury patterns are a little different.
Okay. So what is the difference between a canine dog on the one hand and a civilian dog on the other?
Well, generally, civilian dog bites are rather minor, generally. Puncture wounds, maybe, some slight avulsions, skin defects, slight skin defects, usually not major. Whereas in the canine or trained police dog bites, the wounds the wounds I saw, were extensive wounds where there was extensive ripping, tearing, crushing of tissue, and many times even injuries to the muscles and blood vessels underneath.
From your experience, do you know why the injuries from a canine dog are as you describe them, as opposed to injuries from a civilian dog?
Well, in the LA area at that time, the dogs were taught to bite and hold. So they would, the canine dogs would get a grip on the individual that they were pursuing, and then hold on, even if the individual was trying to pull away. And so there were oftentimes tearing injuries to those, because that's how the dogs were trained at that time.
Even with canine dogs, did you ever see injuries from canine dogs on humans that were not a complete bite, that were an incomplete bite?
Yes. So if the dog missed on the first attempt at a grab, the teeth might only scratch the surface of the, usually extremity, by the way. And so you'd get what I consider an incomplete dog bite, because it was just scratch marks from the teeth. But the dog would then, try a second time and third time.
Now let's go to civilian dogs, a term used for more dogs of household pets that people have. Can you describe from your experience the type of wounds from those civilian dogs that you would see, and contrast it with what you just described for a canine dog?
Generally, they were minor. So a scratch, a puncture wound, maybe a little tearing of the skin, a little skin flap, but generally much, much different.
In your did you say about over 30 years experience in the emergency medicine department?
Mm-hmm.
What did you see more of? Civilian dog wounds on humans or canine wounds?
Actually, it depended on where I was assigned at the time. So in the very beginning, because the jail unit was one of my first assignments, I saw these terrific, horrific wounds, many of them. I learned that what was in the textbooks about how to treat them was so wrong because these patients many of them needed hospital admission, intravenous antibiotics, and many of them needed surgery. And what I was reading in the textbook was, that you could patch them up and clean up the wound and send them home with, sometimes with antibiotics, sometimes without. But anyway, so initially what I was seeing a lot of in the very beginning was the law enforcement dog bites, because I was assigned to jail ward. And also I was very interested in this because I used to be a police officer. And before going to medical school, I was a full-time police officer here in Massachusetts for 7 years. And so I had this interest in law enforcement type injuries sustained during the arrest process, et cetera, et cetera.
So you had an early interest in with regard to dog-inflicted wounds on humans and a police officer. Where were you a police officer in Massachusetts and when?
In the city of Malden. I was appointed as the first woman police officer in 1977 to 1984, full-time.
And while you were a police officer, were you doing that full-time and anything else while you were a police officer? Were you pursuing school while you were a police officer, your college education, or was it separate?
No, I was a full-time police officer working the night shift. And I was attending Northeastern University part-time during the daytime to pursue my degree.
Were you a sworn duty police officer?
Yes.
Full member of the police force?
Yes.
Did you attend academy?
Yes, I attended the Boston Police Academy.
And how many years were you a Boston police officer?
No,
I'm not Boston, the Malden.
I was a Malden police officer for 7 years, full-time.
Now let's go back to your emergency department and other experience. Can you approximate how many dog bite injuries you provided treatment for while an emergency department physician?
Overall?
Overall.
Well, I don't know the exact answer, but I estimated it at a very conservative number of 500 dog bites, because, would you like my methodology?
Oh, please.
Oh, okay. So I considered that even though I worked there for 29 years, I would take 25 years and 40 weeks out of the year, because the other weeks I might be assigned something special, a special rotation or a special assignment or vacation or some kind of course. So 25 years, 40 weeks per year, that's 1,000 weeks. So even if I only saw one dog bite at this busy trauma center, that would be 1,000 dog bites in my career. But I just took it in half. I cut it in half and said I think at least 500.
In addition to the 500, did you oversee other physicians or healthcare professionals like physicians' assistants, nurse practitioners, who themselves were treating and observing dog-inflicted wounds on humans?
Yes.
And approximately, just the number, approximately how many of those, in addition to the 500 you just calculated?
Well, I generally supervised about 3 to 4 people per shift. Med students and interns, residents, whatever, all those people. And so I would say very conservatively another 500.
In terms of other work, I want to shift just a little bit in the emergency department. Did you encounter injuries from persons involved in motor vehicle accidents?
Many.
And you mentioned you were in Los Angeles. And in terms of those, can you approximate how many humans you saw and treated and diagnosed in the emergency medicine department from motor vehicle accidents?
Well, it was a very busy level 1 trauma center.
All the way back to 2:30.
2:30 is when he first called me and said that they were coming to Dighton to retrieve a vehicle that that occurred in a homicide in Canton.
And you understood that to mean what? Retrieve a vehicle.
Seize.
Thank you. What was your role once you arrived at the scene at the Reed household?
My role was Trooper Michael Proctor asked me to facilitate a tow to tow that vehicle.
Was that a private tow company?
Yes.
And when you say facilitate a tow, what does that mean?
He asked who we used for towing vehicles, and during that period of time, it was Diamond Towing.
Did Diamond Towing ultimately show up, a representative of that
They did.
tow company, with a tow truck?
Correct.
A flatbed?
Yes.
Who was with Trooper Proctor when you arrived at the scene?
Sergeant Buchanan.
Had you ever met Sergeant Buchanan before?
Never.
Did you know him?
Nope.
Did you know him professionally or personally?
Never.
Had you ever spoken to him?
Never.
Ever? I'm so sorry. It's getting late in the day, and I guess I'm going too fast. Sorry, my fault. Let's start that just a little bit slower. Did you know him?
No.
Had you ever spoken to him before?
No.
Had you ever heard his name before?
No.
No relationship whatsoever?
None.
Same with Trooper Proctor?
Correct.
Once you arrived at the residence, did you have an opportunity to see the vehicle that was the focus of Trooper Proctor and Sergeant Buchanan's attention?
Yes, once I arrived and I parked my cruiser at the end of the driveway, I observed a black Lexus SUV in the driveway.
What were you driving?
I was driving a Ford F-150 police cruiser.
A police cruiser that's a Ford F-150?
Correct.
They have those?
Yes.
Cool. Were you in full uniform?
Full uniform.
Gun, badge, the whole works?
The whole works.
Did you ever go inside the house?
Briefly.
What was the circumstance of going inside the house?
I went inside to let the troopers know that the tow truck operator was there, and I also went in to ask how we're going to get the tow truck into the driveway because there was about a foot of snow.
Okay. That sort of answers my next question. Did you see whether or not Trooper Proctor and Sergeant Buchanan actually did go inside the residence?
Yes, they did.
For the bulk of the time that they were in the residence, where were you?
Outside the residence.
Were you with the black SUV?
I was in the garage speaking to the defendant's mother.
The defendant's mom?
Yes.
Janet? Okay.
Yes.
Where was the SUV at this point?
In the driveway.
Did you have an opportunity to see the SUV?
I did.
Did you walk all the way around it?
Not all the way around.
Did you see the rear end of it?
I did.
Did you make note of the rear end of it?
Yes.
How long would you say you were at the location in a position to observe the rear end of that SUV? 2 minutes, 20 minutes, something in between? Longer?
I would say not the entire time that I was there, but a good amount of time.
More than a glance?
Yes.
This is the afternoon of January 29th, 2022, correct?
Correct.
Before the vehicle had been seized formally by Trooper Proctor and Sergeant Buchanan, correct?
Correct.
Did you observe anything of note about the rear end of that black SUV?
Yes, I noted in a report that there was damage to the taillight.
Can you describe for the juror, by the way, which taillight are we talking about?
The right rear taillight.
Can you describe for the jurors what you noted in terms of the damage to the right rear taillight?
I noted that the report said that there was right rear damage to that taillight.
When you say damage, have you ever described that damage previously?
I have.
Can you tell us what that description is?
There was, it was damaged, the taillight was damaged, but there was a crack missing, but it was not completely damaged.
When you say there was a crack, do you mean there was a piece missing?
A piece was missing.
Can you describe for the jurors kind of what that piece looked like, how big it was, how small, the shape, as you call it?
The piece was about maybe this big.
Is that maybe the size of a dollar bill, maybe 6 inches?
6 inches.
And how wide?
Maybe that wide, maybe 3 inches, 2 inches, somewhere in there.
I want to show you a photo. Your Honor, with the court's permission, I would like to show Exhibit 13. It's been previously marked. Do you see what's depicted in this photograph?
I do.
What does that appear to be, just generally?
The right rear tail light.
Of what?
The Lexus SUV.
Is that consistent with the black Lexus SUV that you saw at the Reed residence?
That was the black Lexus. That was not the tail light the day I was there.
Can you do me a favor, Mr. Wolk? With the court's permission, could we zoom in on the right rear tail light, please?
Okay.
Do you see the condition of that tail light as it's depicted in this photo?
I do.
Sergeant Barrows, is this the condition of the right rear tail light when you showed up at the Reed household at around 3:15 in the afternoon on January 29th, 2022?
Absolutely not.
What's different about this photo, sir?
That tail light is completely smashed out.
Does it appear that there are additional pieces of taillight that are removed from this taillight condition than when you saw it at the Reed residence? Objection.
Sustained. Ask it differently, Mr. Jackson.
Of course. Describe specifically, other than the fact that it's different, describe in detail for the jurors what is different about this taillight as it's photographed here.
That middle section was intact when I was there. Towards that right side where that large chunk is, that's what was missing.
I'm going to hand you a green laser pointer. If you can, there's two displays, one monitor directly in front of you and one to your right. If you could use the one to your right, it's a little easier on the jurors. Describe what's different about that taillight.
Can you see that? So this area was intact. This is what I saw was missing here.
May I approach?
Yes.
If the entire taillight had been broken out as it's depicted in this photograph, would you have made note of that?
Sustained.
Do you believe you would remember if the taillight, well, let me ask it a different way. The piece that you saw missing, but not completely damaged, is the reason that you use the phrase not completely damaged to highlight the fact that there was still more taillight attached to the vehicle than is depicted in this photo.
Sustained.
We can take this down. As you sit here and recall back to that, your observations, and you observed this for over the course of how long would you say? How many minutes?
Probably 20 minutes or so.
You actually wrote a report about this, correct?
Correct.
And you documented your observations, correct?
Correct.
In your documented observations, did you use the phrase cracked but not completely damaged?
I did not.
Sustained.
You've testified previously?
I have.
About a year ago?
Yes.
Did you use the phrase cracked but not completely damaged then?
The objection sustained, Mr. Jackson.
Ultimately, was the black Lexus SUV towed and cleared from the scene?
It was.
Is it your responsibility or part of your responsibility to log the time that things like this happen, like, for instance, the SUV is taken away?
When I clear from the scene, yes.
What time was that when you cleared the scene?
I believe it was 4:17 p.m.
Suffice it to say that SUV was not seized at a later time, correct?
Correct.
It was not seized at 5:30 p.m.?
No.
I'd like to show you another exhibit, if I could. This is Exhibit 105. Do you recognize this scene generally?
I do.
Do you recognize it as being, what do you recognize as being?
This is the Reed residence.
Do you see some vehicles in that still shot of the video?
I do.
Describe what you see.
That tow truck is Diamond Towing, and that other vehicle that's at the rear of that tow truck is the Lexus SUV.
If we could, with the court's permission, zoom in. It's high on the screen, correct?
What's that?
The vehicles are high on the screen as we're
Correct.
looking at it. Could we zoom in to the top left portion of the screen?
Okay.
Can we play this video?
Yes.
Thank you, Your Honor. Can you see what's depicted in the still image of that video right now?
I can.
I'm going to ask you if you'll turn to your right, concentrate on this area here. Do you see what's depicted in that still image?
I do.
Does that appear to be a taillight?
Yes.
Does it look clear? Does it look like it's shining red?
Looks clear.
The portion that is intact, does that appear to be brighter red?
Correct.
And the photograph that I just showed you a second ago, is that red portion there?
Can you rephrase that?
Sure. Let's go back. You see the red?
Yes.
All right. Is that the condition of the taillight as you saw it on January 29th around 3:15 or 3:30 when you got to the location?
It was.
Let's go back to the other exhibit, please. Exhibit 13. Can we zoom in, please? Can you see that this entire area is now missing?
I can.
Sustained. Just ask it differently.
Sure. The area that I'm circling here, do you see any red lens in that area?
No.
Is that consistent, this photograph consistent with the condition of the taillight as you saw it on January 29th, 2022, at just after 3 o'clock in the afternoon?
Absolutely not.
Thank you.
Lights, please. Thank you.
Thank you. Good afternoon, sir.
Good afternoon.
Have we met before?
We have not.
Do you still work in Dighton?
I do.
At the time you went to the Reed residence, you did not know the occupants?
I did not.
Since then, have you ever met or spoke to William Reed?
Nope.
Or the defendant?
Nope.
When you went there that day, it was at the request of the state police?
Correct.
When they asked you to come, it's a typical procedure for one law enforcement agency to contact local law enforcement agency?
Correct.
And part of the reason they do that is to bring in separate and independent law enforcement officer to the scene?
Yes.
Because it's your jurisdiction?
Correct.
And they called you before they got to Mr. Reed's house, didn't they?
Yes.
They told you what they were going to do and when they were going to do it?
Yes.
They didn't just show up at the Reed house and then you found out later. They invited you and informed you what the process was going to be.
I wouldn't say that they told me what the process was going to be.
When you got there, were the troopers already there or did they arrive after you?
The troopers were there.
Were they in the house or outside of the house when you got there?
They were outside in a pickup truck.
Did you see them get out of the pickup truck after you got there?
They got out after I identified themselves.
Did you ever see them approach and touch the rear taillight of the defendant's Lexus?
I did not.
Did you ever see them manipulate in any way that rear taillight of the defendant's Lexus?
I did not.
Did you see them do anything that was suspicious, inordinary, or unfairly remarkable relative to that car?
I did not.
When they spoke to you, they then went inside the house?
What do you mean by spoke to me?
After they introduced you introduced yourself to them, they went into the Reed house?
Yes.
And then they came out?
They came out much later.
And that vehicle was towed?
Correct.
At no time from when you got there until you left did you see anybody from the state police in any way tamper with that vehicle, did you?
I did not.
When the vehicle was towed, do you know how long it took to take the vehicle from Dighton back to Canton?
How long?
Yes.
I do not.
You didn't escort it back.
I did not.
You had an opportunity to write a report in this case, didn't you?
I did.
And when you did, you had an opportunity to describe the damage to that taillight in any way you wanted to.
I did.
You could have gone into detail about size of the damage.
I could have.
You could have gone into detail about the shape of the damage.
I could have.
You could have gone into detail about the width of the damage.
I could have.
You could have taken photographs of the damage if you wanted to.
I could have.
In fact, there was no limitation on what you could have written in your report regarding the damage, was there?
No.
You write reports regularly, don't you?
I do.
You're trained at the academy. It's the best way to memorialize events.
Correct.
Because in time, your memory is not always as good later on than it is at the moment.
Correct.
What might be important or remarkable later might not be remarkable at the time you're making the observation.
Correct.
So you're taught at the academy to use as much detail as you can so that you can have an accurate memory later on.
Correct.
Because oftentimes, well, you respond to a number of different events and incidents, don't you?
I do.
You write a lot of reports.
Not necessarily now in this position that I'm in, but
there was no collision. There was no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality, and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable, that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton board selectman, he was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well? He got no response. And then we see this. That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look. sparring, practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor in his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him. He tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John, a gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look. Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house. About 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. You coming here? Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car, out in the cold, in the middle of the night, she got frustrated and she drove home. She arrived back at home, and her Wi-Fi connected to John's, her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home, At about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learned through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert, think about this, not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scortibello's words. Question. You did not include in your autopsy, in any fashion, any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you? Answer. No, I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scortibello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own expert said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scortibello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data.
John O'Keefe was 46 years old. 46 years old. He spent his life helping people. He's described as a good man, kind, generous, thoughtful. He was a Boston police officer. He worked to help the community. Everything you've heard about this man, he was a good man. He helped people. When his niece and nephew had nobody, he took them in. He took them in. John O'Keefe seemed to be the type of person who would help anybody at any time. And on January 29, 2022, John O'Keefe needed some help. He needed help from somebody else. You see, John O'Keefe had just been hit by Karen Reed in front of 34 Fairview Road, and he lay on the ground dying. And he needed help. Someone to reach out a hand, someone to knock on a door, someone to make a phone call to 911, even anonymously. Not take responsibility, just to help. And there was only one person in this entire planet who could help him that morning, to give him a chance. Maybe it was a 33% chance if he met the Isaac Wolf of the world. But to give him a chance. And that one person who could help him that morning was this defendant right here, Karen Reed. And she made a decision. In her Lexus with the shattered taillight, debris field all over the front yard, and John O'Keefe lying helpless like a child on the front yard, she made a choice. She didn't call 911. She didn't run to his aid. She didn't knock on a door. She made a decision about herself. In her Lexus, she drove away. She was drunk. She hit him, and she left him to die. She was drunk. She hit him, and she left him to die. Before I go through and detail the evidence, let's talk a little bit about the evidence as a whole. She was drunk. She was drinking that night. She was drinking at McCarthy's with John. She was drinking at the waterfall. Her blood was taken with samples of a retrograde analysis, almost 2 to 3 times the legal limit. She was drunk. She hit him. The timeline in this case is beyond dispute. You can accuse, assault, characterize, malign, twist. The timeline doesn't change. It is data. Data is data. The black box, the forensics from the SD card, we know exactly step by step where they were. We know in that window she hits him because he never moves again. His healthcare data. The temperature on the battery of the cell phone. The physical evidence, the debris field, the DNA, the hair. And then she left him to die. He had a basal skull fracture, countercoup. You heard all about it when the back of your head hits the ground and the brain comes forward. Dr. Wolf told us the reason why they have level 1 trauma centers around the country is because people can survive this injury if they get help. That's why they have this care. That's why they have these hospitals. But you gotta get help. You gotta get help. And if you don't, you develop symptoms, ecchymosis, raccoon eyes, your brain swells, and you die. She was drunk. And that night was a recipe for disaster. But before we get to the drinking, in some ways, the fate of this night was sealed well before that night, because John O'Keefe and Karen Reed were in a toxic relationship. This relationship was crumbling. We hear lovey-dovey, and it was crumbling, and we know it. And we know it because a month before, his niece Kaylee talks about when they went to Aruba. It should have been a wonderful event. It was discord. It was fighting. It was aggravation. And when they got back, the discontent was palpable. Miss Reed reaches out to Brian Higgins, text messaging. John O'Keefe, the relationship is crumbling. And you heard a little bit about what that relationship was like. Kaylee, his niece, told you, when there was an argument, John would do what John does. He would walk away. She described for you one time, to get away from the scene, he walked into his bedroom. But the defendant wouldn't let it go, pounding on his door, having to get the last word, never letting go of the fight. Kind of mirrors what happens on January 29, 2022. And maybe outward appearance, they got along. Maybe sometimes quietly they got along. But behind closed doors, relationships have up and downs. We have a bird's eye view into the relationship on January 28, 2022, because we have the text messages. Not so lovey-dovey. The relationship is almost over. The tensions are simmering beneath the surface. They are not getting along. She believes Mr. Keefe is already halfway out of the relationship and he's not into it anymore. You will read them, you saw them. This relationship was unstable and at its end. And so fast forward that night. That night, after this discord, after the arguing, they go out and what do? They drink. And they drink a lot. So O'Keefe drinks a lot, and Karen Reed drinks a lot. You've seen the McCarthy videos. You can call it 6, 7, 8, whatever you want to call it. You can see the shots into the mixed drinks. More shots into mixed drinks. Count them yourself. Over a half dozen mixed drinks in just a few hours. Sober? And then at the waterfall, a shot, a mixed drink. Now, it was brought up the waterfall that there was some type of discord between Brian Higgins and John O'Keefe. They knew each other. They were friends. Brian Higgins' conduct of speaking to Karen Reed is not honorable. It's not. But they were friendly. There was no adversarial relationship. There was no anger between them. What we heard is they barely greeted each other. Could we have slide 1, please? At the waterfall bar, when you see John O'Keefe come in, here's him barely greeting him. That's him and Mr. Higgins. Barely greeting each other. Reality sometimes is different than argument. This is a celebratory mood. Take that down, please. Celebratory mood. A bunch of friends. They're playing around. They're hugging. They're grappling. This is a fighting technique for a murder 2 hours later. Is that the story? They're practicing their moves to murder John O'Keefe. In this celebratory mood, you don't see any aggravation or animus between Brian Higgins and John O'Keefe. Inevitably, the next morning, Karen Reed is brought to the hospital and they take her blood. Now, the government doesn't have to prove that she was drunk. It is either that she's over the legal limit, 0.08, or she had enough alcohol to affect her ability to operate a motor vehicle safely, but you will know that she was far beyond the legal limit. After the retrograde analysis, almost 2 to 3 times the legal limit. Almost 2 to 3 times the legal limit. Now, it's been intimated, not come out and said, that maybe she went home and started drinking after she got home. No evidence, mind you, no evidence. And that somehow that is why she had a high blood alcohol level. It's not appropriate for me to comment on the credibility of another attorney's argument, so I won't do that. But Karen Reed will do that for her. So if we listen to slide 2, she'll tell you exactly what she thinks about that claim.
My alcohol intake's probably about 5 or 6 or 4. The drinks that they were pouring me at McCarthy's, which is where I consumed most of the alcohol, was the weakest vodka tonic. It tasted just like old soda water with lime.
Slide 3, please.
I wouldn't have gotten on the expressway. I wouldn't have gotten on the expressway at 12:15 on January 29th. I mean, it was quiet. The roads were very quiet. You can see it on the videos. And I was going, when I've had a few drinks and I drive, I always drive extra slow. So I know my alerts aren't as sharp as they should be. But I shouldn't be driving.
Thank you. Do you think she drank when she got home? When they leave the Waterfall Bar at 12:12, you see a video, you have it in evidence, there's a still photo of John O'Keefe holding a glass. Not from the Albert's home. He didn't sneak into the house in the cupboards and grab a glass. From the waterfall, you see him with a glass, and in it is a straw. Take a look at that picture. And now from 12:12 on, we virtually have a historian in the data that tells us exactly where he went, exactly step by step where he went. And how do we have that? Well, we know the defendant's car had like a black box, and Judd Welcher, Dr. Judd Welcher, took the data from the black box and downloaded it so you can see the movements and the triggering events. And then Shannon Burgess, well, you don't like what he says, don't attack the data, attack the man. He can be mocked for his LinkedIn profile or his unupdated CV. But what he did is he found a key, critical piece of this case that did not exist before. He found it recently. And it was that SD card. The SD card that everybody missed, including the defense expert. Everybody missed it. So as much as you want to make fun of him, Shannon Welcher found the key so that we could have the time and date and location coordinated for an impenetrable timeline that can't be broken. That's what Shannon Burgess did. And so we know on the way from the waterfall to 34 Fairview, Ms. Reed is driving drunk. Mr. O'Keefe is in the passenger side of the car, and they're heading their way to 34 Fairview, and they get lost. And now we have more data because John O'Keefe has a cell phone. And I said it in the beginning, it is a historian. It doesn't suffer from bias, it doesn't suffer from prejudice, it doesn't suffer from memory loss. It has data on it. And he puts on Waze, high location data, as Ian Whiff would say. And it tells you second by second the speed, the location, the movement. That's what it does. And he has healthcare data on that phone. The healthcare data separately shows his movement. And that is critical. It is critical because it not only shows his movement, it shows when he does not move. That healthcare data is critical. And it's not subject to bias. It's not in dispute. There's no other contrary evidence. It is data. On the way to 34 Fairview, alcohol fuels tension. We know that. And we know from those text messages the tension in that relationship, and then there's a trigger. There is a trigger on the way because they're lost, and when John O'Keefe calls Jen McCabe for directions. Jen McCabe says something that triggers what's going to happen next. Could I have slide 4, please?
Very close to the outlets. In fact, when Jen was navigating John to the outlets when I was driving, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating.
And so as they travel to 34 Fairview, under the duress of this crumbling relationship, fueled by intoxication, we have triggers. Now, we know on their way there, we know from the data, where they went, how they moved. If we look at slide 5, Ian Whiffen showed you a guide. You could enlarge that just a little, please. And it shows you, with the healthcare data, it registers as flights climbed, but it doesn't mean someone's climbing upstairs. What it means is there's an elevation, and he breaks down the data, the red, the green, if you could move down, please, Ms. Gomez. And then the bottom left, that's 34 Fairview. You can see, second by second, the circles of their route, even the 3-point turn on Cedar Crest. That's what you see. At that point, they've left the bar. Remember, the battery temperature was 82 degrees. They're now in a car. It's now 77 degrees. Think about how accurate the battery temperature is, that it reflects the difference between being in a bar and being in a car. They take a 3-point turn at Cedar Crest. And because of Shannon Burgess and because of Judd Welcher, we have the data, and it's a triggering event. Remember, if there's an acceleration past 30%, it registers data on the car, and that's exactly what happens. Is a 3-point turn, and it all lines up with the cell phone after you synchronize the times. It's that simple. It's nothing complicated. There's nothing tricky. There's nothing devious about it. It's data. They do the 3-point turn, and you can match the cell phone clock with the Lexus clock, and when you do, you can reconcile the difference. Now, there's been a lot of talk, a lot of argument, a lot of fights. Shannon Burgess says 21 to 29 seconds. Mr. DeSorga comes in. Unfortunately, he wasn't able to actually do anything. He wasn't given the invitation to test the data. He just looked at the report and made criticisms like a Monday morning quarterback. But even he, looking at the data, says, well, it's 3 seconds off or 2 seconds. Same window, same time. We can have all the arguments we want. They're there. They're together. The data matches up perfectly. Perfectly. And so they make their way down to 34 Fairview Road. They don't stop. They don't stop at the driveway. They don't stop. And John O'Keefe gets out of the car. They go to the flagpole, and we know for 2 reasons. One, the data. And secondly, Mr. Nagel and Ms. Mason at Cedar Crest, at that intersection before it goes down to the right, they meet. They let Karen Reed go first. They fall behind in the truck. Now, at this point, Mr. O'Keefe has about 8 more minutes before the beginning of the end of his life. And he's in that car. He's in that car for most of it. Because Ms. Mason and Mr. Nagel don't see anybody get out of the truck. Nobody crosses the lawn. Nobody goes to a garage. Not just because they didn't see it. They didn't. Not because they didn't see it. Because the healthcare data on the phone shows that John O'Keefe is not moving. The car is stopped at the flagpole. The healthcare data stops. The battery stays at 77 degrees. The data is the data. You can't change it as much as you want to. It's data. And they sit at that flagpole for minutes. It's 12, 24, 33 when they get there. They're there past 12:30. Remember, Ms. Mason and Mr. Nagel said they were there about 5 minutes and then they go. It's not exact, but about 5 minutes, they said. So there's about 2 minutes left for John O'Keefe. And what are they doing in those 2 minutes? What are the last 2 minutes of his life that he can remember that would be open to him? They're arguing. They're arguing. They're arguing. And we know they're arguing because Ms. Reed tells us through first responder Becker. She was sad. Remember, he sees her in the back of the ambulance and he's trying to calm her down? She was sad because her last moments were arguing. They're in an argument. That's why they're not going in the house. But John O'Keefe decides to get out of the car, and we know because the dome light goes on. That's what happens when you open a door. Whether he's bent down, he's standing outside, or on the other side, the dome light is on. And then you see the data. John O'Keefe begins to move. 12:31:56. It's the first time he has moved since they got to the flagpole, and it will be the last time he moves in his life. And he moves for 20 seconds. Ian Whiffen said that the satellites, they move, they reconnect, they pull information. He's no longer on high-frequency data because waves are shut off. Now it's more random. It's low-frequency. We would never suggest, and Mr. Whiffen did not claim, based on location data alone at that point, you can tell exactly where John O'Keefe is. What he said is it was readings all night. The bullet is always near the flagpole. That doesn't mean he was always near the flagpole. He could have moved. He could have moved in the circles and come back. Location data is consistent with him never leaving the flagpole, but that in itself is not enough. But there's more. There is more. There is the healthcare data. There is the temperature of the cell phone battery. And so he moves for 20 seconds. It turns west. It does not say he walks to the house. That's not what the data says. It doesn't say that he goes straight line and he walks over to the door. In fact, could he even get to the door in 75 feet? Could he get there? Because when the investigator for the defense testified, he measures from the driveway. He never stopped at the driveway. He never measures from the flagpole. He never measures from the flagpole to the garage door. So this is of his life. And he moves. And healthcare data registers his steps. It could be pacing. It could be a straight line. It could be shaking the phone. We don't know. We don't know. We don't know everything. We don't know every little detail in every little second. We don't have to. That's not doubt. That's not reasonable doubt. We know for that 20 seconds he's moving. And in that 20-second window, when he moves, he has his phone and he looks down, 12:32:09, he sees a text message from his friend, John McCabe. And he looks at the text message and he closes it. And then it happens. We know from the uncontroverted data from that black box, we know that Karen Reed, after he gets out of the car, drives away. She drives for at least 33 feet away from him. He's back near the flagpole. She's gone. It's over. Whatever argument is over. Whatever anger and flame has been dispassioned, she's moved on. He's separate from her. He's safe. And then she makes a decision. That's what this case is about. Then she makes a decision. She could have driven home. She could have broken up with him. They could have talked about it the next day. Or like knocking on the door, like Kaylee said, getting the last word. She doesn't drive away. She takes that 6,000-pound Lexus and she makes a decision. And the decision is that she steps on the gas after banging it into reverse. Before we talk about what happens next, I want to talk to you a little bit about the charges in this case. And I hate to digress, but it's important so we really understand what we're talking about here. I have no authority to talk about the law in this case. The Honorable Judge Cannoni will do that. But I want to talk to you a little bit about the charges. Don't rely on my interpretation of the law. It's the judge who has that special power. But I want to explain to you a couple things so when you think about what happens next, you can really assess the facts of this case with the charges against Miss Reed. She is charged with second-degree murder. It sounds ominous, it is. It's a serious charge, second-degree murder. When most people think murder, they think shooting or stabbing somebody. It's natural to think that. Second-degree murder is different. It's not first-degree murder. I told you at the beginning of this case, I told you that we were not going to suggest or try to prove that Miss Reed intended to kill John O'Keefe. That was never part of this case. We're not claiming that. I told you that we were not ever going to try to prove that she even intended to hit him. We never suggested we would try to prove that, and we're not trying to prove that she intended to hit him. We're not. What we are obligated to prove, and what we have proven from the evidence in this case for second-degree murder, is that she intended an act, and that is putting the car into reverse and heading back towards John O'Keefe. She intended that act. The question then becomes, did her conduct create a clear, plain, strong likelihood of death? Late at night, dark, beginning to snow, under the influence of alcohol, knowing where she stopped and left him after an argument, heading back in reverse to the exact spot or right near where she left him at over 24 miles per hour, accelerating at over 75%. You need to ask yourself, are you convinced if somebody does that, does that create a plain and strong likelihood of death? And if there's no doubt in your mind that she intended to hit that accelerator in reverse, and that that conduct will create a clear and plain likelihood of death, then she is guilty of that crime. Whatever the label is, she would be guilty of that crime. Now think about this. Let me give you an analogy. If somebody, maybe a teenager, someone young, impulsive, is on a bridge, and they see cars going by, and they have a boulder, and they want to throw the boulder off, they're not looking to hurt anybody. They're not meaning to kill anybody, but they throw the boulder off the bridge because they want to see the car break, the thrill. And when they throw that boulder off the bridge, and it comes down and lands on the car, and there's somebody, passenger, child, anybody in that car, and it then goes through the roof and kills the person in the car, did they intend to kill that person? No, they were trying to have a thrill throwing the rock. Did they have the malice to want that person dead? No, they didn't. But that would be an example of second-degree murder. When you take a boulder and throw it off a bridge, there's a plain and strong likelihood of death. When Karen Reed, in the midst of that tension and fight, after she drove away and was gone, disengaged, when she came back for the last word, in the darkness, the beginning of the snow, under the influence of alcohol, and decided to stop her Lexus, decided to put it in reverse, decided to accelerate 75% in the exact same direction of where she left him, and then hit him, and he died. I suggest to you that is second-degree murder. The other charge, operating under the influence of alcohol, manslaughter. It's different. It's a totally different and separate charge. Was she under the influence of alcohol? And then secondly, did she operate her Lexus wantonly and recklessly in a way that would very likely result in serious injury? When you're under the influence of alcohol and you drive a 6,000-pound Lexus in the heat of the moment at the direction of where somebody is, whether you intend to hit them or not, I submit to you that is wanton, it is reckless. And any reasonable person would think it's very likely that serious injury would result. It's not a matter of intending to kill. It's not a matter of intending to hit. It is the conduct of the operation and the risk that is created. And so those two charges are two of the three. The three is leaving the scene, knowingly causing death. And we'll get to that. So now, sadly, we need to get back to 34 Fairview Road where we left. We know from the tech stream data that she drove 33 feet at least, because it only picks up a 10-second window. And when it starts to pick up the data, we know she's driving at a speed. So it's more than 33 feet. We just don't know. And then when she comes back, she covers it to 33 feet and 50 more. 80 feet. 80 feet. Over 80 feet. Now, nobody has ever suggested, even Dr. Welcher, when she collided with them. This data doesn't tell you collision. It's a 6,000-pound Lexus. It's a 216-pound man. It's not going to show a blip. It could have been in that 10-second window. It could have been 2 seconds after. It could have been 4 seconds after. But it's in that pocket of time, and we know it. We know it because when you reconcile the data with the phone, that 20 seconds is in the same window of that 10-second window coming back. So even if it's a couple seconds later, 4 seconds later, whatever Mr. DeSorgo wants, he stops moving. John O'Keefe stops moving. Forever. Forever. Next slide 6, please. You'll get to see this more closely, and you can't probably see it where you're sitting, but there's important data. Data doesn't lie. And you will see acceleration, 75%. You will see speed, 24 miles per hour backwards. You will see distance, over 80 feet. That's what you're going to see in this data on that night. Anger, although not necessary in any of these charges, anger can be inferred. For somebody to come back that hard, that fast, that reckless, that obvious, likely to create a plain and strong likelihood of death. That data tells a story that can't be changed. Can't be attacked. ARCA, they did some crash test dummies. You know what else they do? Text string data. There's nothing about that data that is uncertain. Nothing. Can you take that down, please? When Miss Reed hits John O'Keefe, collides with John O'Keefe, we don't know if he went in the air a foot. We don't know if it was how much of a clip it was. We don't know if he stumbled back. But we know there's a collision. There's no doubt there's a collision because her taillight's all over the yard. It's all over the yard. And when he falls back and he hits the back of his head, his basal fracture, he's then lying there helpless. When Miss Reed leaves, she leaves behind tons of her taillight all over the yard. All over the yard. It's called the debris field. And you've seen videos. You can't replicate the exact contact. You can't because you would need where the person was hit, how fast the person was going, but you know what happened because when you look at the debris field, when a light is broken, it's no different than what was on the front yard. It's no different. She leaves him behind. She leaves her taillight behind. She goes home. And on her way home, you know she's still angry. You know she's still angry because she starts leaving him voicemails. Slide 7, please. Healthcare starts at 12:31:56. 12:32:04 to 12:32:12 is the data which is adjusted when you reconcile the Fox and the Lexus. 12:32:09 is when Mr. O'Keefe closes his phone after looking at Jen McCabe's text. 12:32:16 is his last steps. Mr. DeSorgo says that red range should move a little bit, 2 or 3 seconds. They can move it 4 seconds, 5 seconds. It doesn't matter. It's all in the same window. It doesn't change. We could have slide 10, please. Can you play that, please? Thank you. Each one of those pegs represents 10 feet. You can't place that car where it was in front of Fairview. You just can't. The data doesn't tell you that, but that tells you the movements of that car. Now, as John O'Keefe sadly lays on the ground, abandoned, you're going to have to ask yourself a question for charge number 3, leaving scene knowing somebody was injured and then died. You're going to have to ask yourself, is there evidence that Miss Reed knew that she had hit him? Don't need to prove it for murder 2. Don't need to prove it for OUI manslaughter. But for the third charge, Commonwealth has to prove beyond a reasonable doubt she knew she hit him. We weren't there, but there was an eyewitness. There was a guide. And that eyewitness tells us that she knew. And that eyewitness is Karen Reed herself. She tells you that she knew. Could we have slide 8, please?
Could I have hit him? Did I hit him?
How could that have been? I mean,
I don't know what that could have been. It was howling wind. I had YouTube blasting on the stereo, and I thought, did he somehow try to flag me down, which was the reaction I was hoping to garner as I slowly pulled away from the house. Did he come out and maybe trip or bend over to pick up his cell phone, and I ran over his foot, and then he passed out drunk? I mean, I didn't think I hit him, but could I have clipped him?
When she left Fairview and left John behind, she didn't think he was mortally wounded. But she knew she hit him. She knew she hit him. And so when she made her way back home, not only did she leave debris field all over the front lawn, but she took evidence with her too. Hair, DNA on the taillight, and she drove back to John's house. And she started calling on the way back, 12:33, just a minute and a half later. And then her messages show her anger. You see, this was John's fault. This was John's fault. And her phone calls tell you about the tone and the destruction of that relationship. 53 phone calls that night. 53 phone calls. Not one to 911. Not one to Jen McCabe, please go outside and try to help. Not one to a hospital. Not one to anybody but him. 53 calls. Slide 12, please. Can you play voicemail 1, please? The calls keep coming. Cell phone temperature, 72 degrees. He's been outside now, not moving, on that cold, hard ground with his cell phone under him. The warmth of his body, the cold ground, 72 degrees. It tells you the story. As this temperature plummets and that cell phone battery is compromised, so is John O'Keefe. And him and his cell phone alone on that yard. 66 degrees at 12:45. It is plummeting. Ian Whiffen's taking a phone and putting it in a freezer, not a same analogy. The idea that means that John O'Keefe went in the house, absurd. 66 turns to 61 at 12:53. 48 unanswered calls from the defendant. He's not in at a party. He's not wrestling with Brian Higgins. He's not in a fight. If he's in a fight, his cell phone would be moving. There would be healthcare data. There'd be steps. If he got into the house in 20 seconds and his cell phone is found under his body the next day, and how would he get back outside? There would be more steps because this phone is working. The data is the data. There's nothing wrong with it. It's registering everything. The temperature, the movement. He doesn't go in any house. He can't go in any house. His phone never moves again. Voicemail number 3, please. Listen to this.
John, I'm feeling a fucking kid. Nobody knows what the fuck you are, you fucking pervert.
Did you hear that? Nobody knows where you are. It is 12:59. John O'Keefe has been on that lawn for about 27 minutes. She hasn't called anybody else, hasn't spoken, has no information. Nobody's called her. You'll see her phone records. And she says, nobody knows where you are? She knows. She knows. Nobody does know where he is. Except her. Except her. Why is she asking nobody knows who you are? She is starting to get panicked because she knows she hit him. I'm not suggesting she meant to kill him or for him to die, but she knows she hit him, and now he's not responding, and she's getting nervous, and she's getting anxious, and she's leaving call after call after call. He's not answering. He's not calling back. He's not even picking up the phone. And we know what's happening at this point. Panic, drunken denial, it's setting in. And so then we see the healthcare data from Miss Reed's phone. She doesn't move after a little after 1 o'clock. She could be sitting, she could have fallen asleep, but she doesn't move for a while. But she wakes up. She wakes up early the next morning. You can take that down, please. And when she wakes up, she doesn't call Jen McCabe and say, "Where's John?" She doesn't call Brian Higgins. Has his number, has been texting with him. "Hey, was John at a party with you? Did you see John tonight?" She knows exactly where she is, and she's frantic. So she wakes up Kaylee, that young girl at the time, and she says, she's panicked, she can't understand what she's saying. "Call Jen McCabe. Call Jen McCabe." Why is she calling Jen McCabe? She calls Jen McCabe. You know what she doesn't say when she calls Jen McCabe? "When did he leave the house? What happened last night?" No. She calls and says, "I left him at the waterfall. I left him at the waterfall." See, now it's gone from panicked to self-preservation. "I left him at the waterfall." And Jen says, "Left him at the waterfall? We saw you in front of the house." Click. Hangs up. Hangs up. So then she calls someone that she doesn't know very well. She calls Carrie Roberts. But now she has to pivot because someone has seen her in the exact spot that John will be found soon. Whether she's the first one there or somebody else, John will be found. Maybe Lucky missed him. It's a snowstorm. You can't see. But someone's going to find him at some point. So she calls Carrie Roberts. It's no longer she left him at the waterfall. She pivots. And she calls, "Carrie, Carrie, Carrie. John's dead. I think he got hit by a plow." Why do you think she chose those words? Why did she choose those words? Because she knew that there was a collision with a large motor vehicle, and she had to substitute her 6,000-pound Lexus for another big vehicle. "I think he got hit by a plow." And so now we have the introduction of Jen McCabe and Carrie Roberts. Phone calls that they probably never, ever wanted. A worse nightmare to get a call like that. For what's going to happen, what they're going to see, what they'll never be able to forget. But because the defendant is John O'Keefe's girlfriend, they wake up in the middle of the night, in a blizzard, out of their kindness, their loyalty, their devotion to John O'Keefe. And when she calls them and tells them that she wants them to come out, this soccer mom was a perfectly normal life, gets drawn into this whole farce, and she answers that call. She gets out of bed. The spirit and kindness she displays to put herself in that position because someone asked for help, because that's what good people do. Carrie Roberts didn't know Jen McCabe. They both knew John. They met each other once years before. Carrie Roberts, separately at that time, answers the call, gets out of bed, drives to go help, because they have a common denominator, a common bond. John O'Keefe. And so you hear and see at 5:07, the defendant leaves Meadows. She leaves. And Kaylee is behind waiting. And you see her back up, and Judd Welch just showed you all of those demonstrations where you could see the unsettled snow in the back, and after the bump, you can see the pieces missing. No taillight. There's no taillight on the ground, all the white snow. There's no crack, there's no break. It's a nudge. It's a nudge. But the taillight has already been broken, because when you look at the video, not one little piece, it's still framed, little angle with the light, the brakes are up. You take a look, you'll be able to slow it down.
you'll see the exact same piece is missing. Because it's back at Fairview. That's why it's missing. It's not there. It's back at Fairview. And then she leaves at 5:07. She gets to Jen McCabe's about, 5:35. 28 minutes. It's about a 10-minute ride. Where did she go in 28 minutes? Where did she go? We don't know. We don't have data for that. But we know when she gets to Jen McCabe's house, she is panicked, frantic, out of her mind, screaming, waking everybody up. Jen McCabe comes down, can't understand her, going out to the car to try to console her. Why is she so frantic? Why can't she speak? Why can't she say a word? Because John went out and had a drink and fell asleep on a couch? Because John would maybe be cheating on her? What is causing this extraordinary duress? Did she stop somewhere on the way by? Did she just see death? Kerry Roberts comes, take charge kind of person. She pulls him behind. She sees the broken taillight in Jen McCabe's driveway, and she decides she's going to commandeer this. We're going to back to Meadows. You're going to follow me. Leave the car. I'll drive. At this point, Jen and Kerry don't know each other. They've only met once. And they go back to Meadows. They obviously don't find John because he's back at 34 Fairview. And then they start their way towards 34 Fairview. They start driving towards 34 Fairview, and they're looking. And you heard from Kerry Roberts, Jen McCabe, they're looking out the window. They can't see a thing. The snow, the blizzard, the weather, the darkness, they can't see anything. And they're driving, and they decide they're going back to 34 Fairview. And this is remarkable. This is remarkable. When they start their way past towards 34 Fairview, they get close. And when they get close, they can see nothing. But the defendant screams, "Stop! Let me out!" And they look around and they say, "What? Let me out! Let me out!" She does not see John O'Keefe. She knows where he is. She knows exactly where he is. She knows where to find him. She knows where to expect to find them because she knows where she left him. She tells us. Slide 13, please.
Driving Jen's in the passenger seat. And I described this to everyone. So you've probably heard this before, but John looked like a buffalo on the prairie. It was just a lawn and a heat that it wasn't a bush or a hydrant or a dog. It was a weird shaped lump at that time in those elements. And I was looking to find him on the side of the road. I was expecting I'd find him.
Thank you. A weird shaped lump in a blizzard, and you equate that to John O'Keefe? A weird shaped lump, not like a bush, and that is John O'Keefe? She tells us she knows where she left John O'Keefe. And so they go over to Mr. O'Keefe, Kerry, and Karen. And she's upset, there's no doubt. I am not for a second trying to deprive her of the unrest and the trauma that is happening at this scene. Doesn't change what happened before, but I appreciate the trauma. And they're trying to help him. And guess what happens when they first move him around 603, 604? Ian Whiffen, data. The cell phone battery gets the cool air, presses on the battery, the cell phone battery drops. Healthcare data, he has not moved since that 22nd, hasn't moved. They start shaking him. You're going to see, when you look at the records, that healthcare data starts to move. He's been there all night. All night. Nobody else. Her. And so when they try to help him, she says something that is remarkable. She says, there's a piece of glass stuck in his nose. And she plucks it out. And she says when she plucks it out, blood spurts out. We'll talk about that in a couple minutes. Remember that. Piece of glass, pulls it out, blood spurts out. That's what she says. As they try to help John, Jen is calling 911. They would like you to believe there's a conspiracy. That the glass that's found in Mr. O'Keefe's body is somehow from inside the Albert House. The glass, well, you will hear in the clips, if we don't play it, you'll have all the clips with you. She talks about the fact that he took her walker. He took the glass. She says it. So the Albert House, they don't need to give a glass. He already has the glass with the straw that's later found on the street, by the way. That's what happens on an impact. Things move. The glass comes with him, lands near his body. Debris field moves past him. Shoe, hat, straw. Jen McCabe makes a call to her sister, and they say because it registers 29 seconds, a cell record is not the same as a call detail record. There's no evidence there was a conversation. No lights go on. There's no conspiracy. You can call somebody. It can ring. It can go to voicemail. They have no evidence, none, that there's a conversation between Jen McCabe, the person who was ripped out of her sleep to come help, and her sister for some grand conspiracy. And so what happens next is traumatic. Kerry Roberts and Jen McCabe see their best friend prone, lifeless, frozen, on the ground. And they're living this torment because somebody brought them into this. When they're trying to help John, there is not one suggestion from anybody that John ever went into that house. There's no reason to go into that house because John was never in the house. Not one time does anybody say, what time did he leave? I thought he went in there. Not even a whisper of it because it never, ever happened. When they find their friend John, he's not 20 feet off the side of the road like Mr. Rentschler or Mr. Wolf thinks. He's right there by the side of the road, close by the curb. Could we have slide 14, please? You can see there's Kerry Roberts' vehicle, and then on the left, you can see where they're working. Right off the road, that's not 20 feet. That is a clip, a stumble, and a fall. And remember, when John O'Keefe fell, there wasn't snow. It was just the beginning of a dusting. It was the cold, hard ground. Remember what Dr. Isaac Wolf told us about cold, hard ground? It causes this type of injury all the time. All the time. If we could go to slide 16, please. Remember the glass in the nose? The glass in the nose. See on the bottom left, that's where the Canton Police Department found the glass that he took from the car, from the waterfall. And then Exhibit 195, matching glass. On February 3rd, the matching piece of glass was found on the street. The matching piece of glass, the glass that was found with Mr. O'Keefe, was found on the street. He didn't fall back 8-10 feet from the road. It broke, and then it shattered and went to the street. I would suggest to you it broke at the time of the collision, and he carried the glass with him, leaving the evidence behind, a trail to memorialize what happened to him that night. Remember the straw I asked you to take a look at that picture when we're leaving the waterfall at 12:12, the black straw in the drink on the street. Collision, glass, nose, straw, back, hits his head. Could you play the clip on the left, please? 59.
So when John got out of the car at Brian Albert's house, he took my full vodka soda, which is sitting in the cup holder.
169, please.
So John's laying there, his left and his right, and I approached John from the left. That's where the street is. And he had a piece of glass, like, perched on his nose, like, just wedged like a splinter would be. And I just pulled it, and as soon as I pulled it, it just gushed blood down his face.
Thank you. 911's called by Jen McCabe. She's not hiding from anybody. She's trying to help. She's bringing attention to the situation. And when 911 comes, we have first responders.
These people are heroes. Some of them, you've heard from some of them, they were born to help people. That's what their life is about. The detail on all their mechanics of getting to work 2 hours early in the middle of a blizzard so that you're there on time so you can help people. These are the core of our community. Mr. Nuttall, this is what he does. He rushes to go help. He's the first person on his knees. He doesn't know this person from anybody. But to him, it's another human being. This is his passion. Katie McLaughlin, first responder, this is not just a profession, it's her life. Yes, she knows Caitlin Albert. Do you think she went there that night at a party and set up a murder and came back? And so they tell you what happens at the scene. Some things hard to remember, some things people will never forget. When you're in a traumatic incident, sometimes it's something you'll never, ever, ever forget. And Timothy Nuttall remembers speaking to the defendant. I hit him. Remember, he's on his knees. What happened? I hit him. I hit him. She is now coming to terms with the moment. Her fear is realized. She hit him. She clipped him. She didn't think he was mortally wounded. She panicked. She can't come to terms with it, so she has to bring people with her to face it, and now she's facing the reality of what she had done. And her emotion is overwhelming. I hit him. I hit him. She speaks to Miss McLaughlin. I hit him. Not did I hit him, could I hit him, perhaps I hit him. That was earlier. Now she's recognizing what she did. I hit him. And these people are making it up. Anybody that says anything adverse or inconsistent or inconvenient is a liar or a perjurer or in on a conspiracy. Or is it that these good people who went there for a total stranger to do their duty to help happen to remember that she admitted what she had done? I know that doesn't reconcile with the boogeyman Proctor and the bad government. I know it doesn't reconcile with no DNA on this piece or that piece. I know it doesn't reconcile with everybody setting up the girl. I know that doesn't reconcile. But the reality is you have independent, core people who hear her say, I hit him. I hit him. And the attempt is to betray everybody. That's a liar. But you don't have to rely just on these good people, although you should. You should. You don't have to, because we have a guide, and it's Karen Reed. Slide 17.
So I must have said was, did I hit him? I always said I hit him, but did I really say this many times as law enforcement's claiming I said it?
Thank you. I know it doesn't fit the theme, the theory, the story, but she tells you herself. She endorses those good people exactly what they had heard. She tells you herself she hit him. It's undeniable, it's unmistakable, it's inconvenient. But the truth has a way of seeping up to the daylight. It can be oppressed and suppressed and pushed down and covered and twisted, but it rises. It rises. And it is not a coincidence. There's no coincidence that Mr. Nuttall and Miss McLaughlin hear exactly that. She tells you. And Jen McCabe, when she's sitting next to or standing next to Miss McLaughlin, she tells you that she saw or heard the same thing. Remember what happened to her in the stand when she had the audacity to say, I heard her say it? What happened to her? This woman who never even wanted to leave her home that day, pulled out into a storm to see her best friend dead. What happened when she had the audacity to say that? And now we know that the defendant herself said the same thing. And the funny thing, the ironic thing is, you will see in a photo when Miss McLaughlin, the firefighter, was speaking to the defendant, Miss McCabe was next to her. Miss McCabe was trying to protect her, trying to shut her up. Don't talk, you're upset, stop saying crazy things. The villain of this story was trying to help the defendant from incriminating herself. The irony. Could we have slide 9, please? This is the battery temperature. You're going to have a chance to look at it. If it wasn't so tragic, it is interesting. It is interesting if you like data.
The 29, 12, 13. They're leaving the waterfall, 82 degrees, 12:22. In the car, 77 degrees, 12:37. About 3.5 minutes after the defendant collides with John O'Keefe, it's starting to go down, 72, 12:45, 66, 12:53, 61, and you see it drop and steady off at 1:36. Remember, cell phone battery under him. John O'Keefe either struggling for life or he's passed. And the blood's still warm, either way, under him. Doesn't move again until 6:06. It drops down 7 degrees because the women are pulling on him. The cold air is hitting the battery. What happens at 6:15? You're going to see the video. You've seen it. Still photos. Kerry Roberts goes over, picks up the phone. Not only does she pick up the phone, she puts it in her pocket, and then 20 minutes later, the next reading, the temperature rises. That's not convenient. That's not a coincidence. That's fact. That's data. And then the phone is passed, put in a warm environment, and it raises up. 6:15. How can someone conspire to pick up a phone on the side of the yard that was under Mr. O'Keefe's body at 6:15 and know the battery temperature was then going to rise? Not only did the battery temperature rise, when you look at the healthcare data, at 6:15 when she picks up the phone, you know what happens to the healthcare data, right? It starts to move. It's data. It's data. So, while they're going through this duress, the defendant asked Jen McCabe for yet another favor. Look up hypothermia. Find out how long it takes for someone to die in a cold. And there's Miss McCabe in her winter jacket, soccer mom, trying to help. She has MS. Her hands aren't working. She's trying to type in what's happening during that time. It's a frantic scene. She tells you that. The defendant then wants to run back to the ambulance, so she goes with her, never finishes or completes the input. And then she tries it again. At 6:23, at 6:24. That's what this woman did that night, that morning. Not only for her friend, for her. For her. That's what she did. And what happens to her after? Because the timestamp, when you open the timestamp, it's at the time it's open, and she's in bed at 2:27 looking up Hockomock Sports because she is so interested in the kids' sports, and that timestamp stays open. And she goes to that tab the next morning when she puts in how long to die in cold. And that is being portrayed that she's in a conspiracy. She gets vilified as a murderer, a soccer mom who came to help. It took Ian Whiffen 5 minutes to show you a live demonstration on how simple that works. That she's not deleting anything. Jessica Hyde told you it's automatic deletions over time. You usually can't delete that information. That's not a click and swipe like the good Dr. Wolf from Arca knows how to do. This can't be erased. But they still hold on to this. As they argue to you and all the injustices that have been done, they tell you, they want you to believe, or take a flyer on the fact that she looked up how long to die in the cold at 2:27. It is an absolute contrary to the science. There's no basis to support it, but they stand here in front of you. Why? Because every time they say something like that, you look the other way. Don't look at her. Look the other way. 2:27, look the other way. Don't look at what she did. Former Trooper Proctor, look the other way. Don't look at her. Every time they make those, oh, she got the glass from inside the Alberts, maybe in the basement. Look the other way. Don't look the other way. Look at the facts. Look at the data. And it all leads to one person. There's no grand conspiracy. It leads to one person, the defendant. And it's not just the data and facts. It's her herself. Let's talk about Mr. Proctor. You were invoked with this emotion early in the opening that this is a cancer. That's a tough word. Try to evoke that primal reaction, disgust. I'm not saying you shouldn't be disgusted by the text messages. You should. You should. They're not defensible. I don't stand here and defend impropriety. I don't. But that doesn't change the physical evidence, the scientific evidence, and the data. He was terminated. He paid a penalty. He was held responsible for what he did. He should have been. He should have been. But that doesn't give a free pass. That doesn't change the facts. It doesn't change the physical evidence. It doesn't change the science. It's unfortunate. It's distasteful. It's dishonorable. Remember, Trooper Buchanan was asked, was the investigation with honor and integrity? And he said it was. Was Trooper Proctor's effort honor and integrity? And he said it was integrity. But he never said honor. That's a man of honor. Military service, dedicated to his country, highest level of clearances to the President of the United States, now a state trooper. He would not say that Trooper Proctor was honorable. Because he wasn't. He wasn't. But that does not change. It doesn't create a conspiracy. Doesn't invent a dog. It doesn't make somebody in a house something they're not. It just doesn't. When you read those text messages, they're hard to look at. It's unfair. It's unfair. And if there's a penalty more than being fired, well, maybe that penalty would be deserved. But it has nothing to do with the justice in this case. It just doesn't. There's not one piece of evidence, not one, that we can look at and say, this was tampered with. This was planted. This was distorted. Remember when we introduced the taillights at the beginning? I didn't introduce 3 of the taillights, but then the defense did, so I put them in. Those were taillights that were only found by Trooper Proctor. I did not put that evidence in. Understanding those text messages and appreciating the disdain one might have for his comments. Not that there was any evidence of tampering, not that there was any evidence that it was not true, but I didn't put that evidence before you because we didn't need Trooper Proctor in this case. We don't need Trooper Proctor to prove this case beyond a reasonable doubt. That's why I didn't introduce that evidence to you. Now, there's been a lot of talk about planting of taillight. We know the taillight wasn't planted because Trooper Buchanan and Mr. Proctor did not go down to Dighton to see Miss Reed until later in the afternoon. We know from the 507 video, we've seen that. We know the taillight was already missing when she's leaving the driveway. When the good Canton police detectives went to do a wellness check to care for those young children, and they went to the house, inadvertently, they didn't even know it, the dash cam captured the back of the car. The taillight packed with snow is missing. It's already gone. It can't be planted. At this point, Trooper Proctor's still in his pajamas. He's not even on the case. He's not even on the scene. He hasn't been near the car. And then the Dighton videos themselves, when you close it, you can take it at an angle and it moves, but if you get the right angle, you can see it's missing. It's gone. Can we have slide 18, please? .507. You can play any angle you want, but if you look at this angle, it's gone. You don't plant. It's already gone. You know where it is? 34 Fairview Road, on a debris field. January 29, 2022, 823. Look at the right-hand side. Look at the left-hand side. It's packed with snow. It's gone. It's gone. And the same thing when you do the videos, it's a different angle, a little smaller, but if you play that and watch the lights go up and down and slow it down, you'll see it expands. It's gone. So when you have Dighton Officer Barrows come in here and try to tell you what he saw in the salad port, couldn't have been it. You got to ask yourself, what interest does he have coming in here in this case? A lot of attention on this case, a lot of people watching. Comes in after, of course, driving all the way out to the defense attorney's hotel to meet in a conference room so he can get a subpoena. He spends 2 hours driving up and back so that he can conveniently get a subpoena that tells him to appear, which he could have got by fax or in the mail. And so when he comes in, what he says is, that's absolutely not what I saw. Absolutely not. And then he claims at the last time he testified, he had made the same statement. I showed him his transcript. And did you see the redness creep over his face? He never said this before. In fact, he testified to the opposite. And so he sits on the stand with a new story after a meeting. We don't know why. But then I show him that bottom right photo with the snow, with it missing, and I say, is this the way it looked? It's, of course, before the snow melts out in the salad port so that you can see it unexposed. And he says, yes, he had to agree. This taillight was gone. There's no boogeyman. There's no plant. There's no Higgins at the salad port. There's no one tearing out pieces. In fact, Remember I played you a clip, and you'll have it, where the defendant says, I was picking out pieces, it was crashed in, the bulb was showing, when I was showing Kerry and Jen, when they went back to Meadows. If you don't remember, listen to that clip, you'll hear it. Unfortunately, there's no ring video when they go back to Meadows. There's a ring video when she leaves, there's no ring video when she gets back. And so now when we're trying to look the other way, we want to find a dog bite. So enter Dr. Russell. Dr. Russell, according to her, nice woman, nice doctor, very accomplished. I respect that. She's the only dog expert in the world. The thing is, we know no idea what that expertise means. She volunteers for the job. She wants to be here, her profile, but she can't explain methodology. What are you looking for in a dog bite? She can't tell us. It starts a year ago that it's claws, it's teeth, and then it's claws, then it's teeth, then it's I don't know. And then when you look at each of the different parts of the abrasions, she says, well, I can't tell if I look at each one of them, but all together it's a dog bite. It's a dog attack. That is the masterful expertise that the defense has bragged about bringing in. Dr. Russell telling you, because she says this is a dog bite. She has never been in a forensic situation where she's looked at a wound and identified it as a dog bite before. This is the first time, the only time she's ever done it. And what she says is these are not punctures. Punctures means it goes into the skin, a wound. There's no punctures. And she's sure because she's an expert, so you should rely on her because she's coming in saying she's an expert and she's being presented. Yet, after saying there's no punctures, Dr. La Posada comes in and she sees punctures everywhere. It's an animal attack. It's a dog. How is it? No method, no methodology, no history of this, no prior testimony that we know of other than arbitrarily what she says. And she says the exact opposite of Dr. Russell. Why is that? How does that happen? So obviously there is no science to looking at an abrasion and saying where it came from. They give us no detail. They give us nothing that we should rely on. They contradict each other. It's just to get you to look the other way. And so we have now the issue of the defense has said over and over again, there's no collision. There's no collision. There's no collision. And they had a number of witnesses come in to try to say that. And they point to Dr. Scotty Bello, who works at the medical examiner's office. She tells you that she doesn't see injuries consistent with a collision. She's looking at this case for 90 days. 90 days. The evidence in this case did not stop. It continued for 2 years. She knows nothing about the data, nothing about the black box, nothing about the interviews of Miss Reed. She doesn't know about the DNA. She doesn't know about the shards in the arm or in the clothes. Strike that in the clothes. She knows nothing about that. So in 90 days, she didn't see any lower body injuries. She didn't see any lower extremity injuries, which are very common in car collisions. But that doesn't mean it didn't happen because she, in 90 days, saw a fraction of the information. A fraction. And we know now, argument back and forth for days about lower body injuries, the suggestion is a car accident can affect everybody differently depending on the angle, the scope, the speed. Some people can get plowed over by a car, have no injuries. Some people can get touched lightly and have more injuries. And there was the debate about no lower body injuries. Well, ARCA dispelled that in their dummy test that you can have a collision with no lower body injuries. They did that for us. Thank you. And so the idea that at the time in 90 days that she doesn't have enough information to say consistent with a car accident doesn't mean there was no car accident. Let me talk a little bit about ARCA. I don't want to waste too much time with them. What expert who's supposed to come to you, they're not the arbiter of truth. Their opinions weigh no more than yours. Your common sense has more value than an expert's opinion. Their job is to assist you, to explain what their expertise is so that it's a tool for you so that you can make a decision. That's objectivity. We've heard words like confirmation bias, objectivity. Mr. Wolf got on the stand, and before we even started, you have to ask yourself, what expert has a court order for text messages and then deletes the text messages? What expert, what objective expert uses Signal, an encrypted app, to communicate about the case. Never used it before, hasn't used it since. And so when he did his tests, he used a lower weight arm. Wasn't trying to bash him, wasn't trying to insult him, tried to get him just to recognize that a 9.38 pound arm is less weight than John O'Keefe's metric, which would be 11.8. That's all, and because it's a lighter arm, it takes more speed to create the same damage. I don't know science, I don't know math very well, but that's basic. It's basic. And he fought me over and over again. Did he seem objective that he was trying to help you? Because Dr. Renshaw came in the next day and said, well, you have to adjust for that. That's all I asked him for an hour about adjusting, just like Judge Welcher adjusted. Do you adjust it? And he tried to talk to me like I was making something up. His own colleague had to admit it. Now, it's funny, he admitted it before he got through his credentials. No sequestration order violations. Nobody was coaching him, but he knew enough to come in at the beginning and get right on that point. And speaking of sequestration, remember Dr. Russell on her limo ride over? If Brendan asks you a question, make sure you ask for a transcript. Impede the progress. Slow down the questioning. Interfere. Sequestration orders is so there's fundamental fairness for all witnesses, not just some. And so what happens with Dr. Renshaw, we don't know, but we do know he comes in here and he tells you that he was not getting information that was helping him the last time he testified. He insisted. I asked him 5 times, was he getting information that would help him in his testimony? Not from the defense, from his former employer. And he said, no, no, no. And at the end of the examination, he reads his transcript and it's yes, yes, yes. And he tells us that he's independent and objective. I asked him about a luncheon, not a big deal, just asking him about it. And he says, I have a sandwich and I stand in the corner until I remind him that we got video footage from a documentarian and he's in one of the scenes. And then things change. So when you talk about objectivity and who to trust, they can come in and say, Judge Welcher said this and that. It doesn't make it so. Judge Welcher, Dr. Welcher, never in any report, in any presentation, in any testimony to you, ever suggested this is how it happened. This was how his arm was. This is how his feet was. He was trying to show whether or not the orientation. Could this happen with the angle, with the height? That's all that test was. It was no more. But what they do is they reposture it, repackage it, and say it means this when it doesn't, and we're going to show you why it's not that, therefore we win. That's all that is. It's semantics. Judge Welcher, Dr. Welcher, never suggested that. And his work on text stream data, unassailable. And so what we have, inevitably, is we have a timeline that never moves, data that never changes, physical evidence that can't be put in that spot without a collision. We have, inevitably, proof, without any doubt, that on January 29, 2022, Ms. Reed was with Mr. O'Keefe, and she got drunk. She drank. She was 2 to 3 times over the legal limit. And they went to a party, an after party, and they were fighting. They were fighting. It was a relationship in decline, and he got out of the car, and he had a brief window of life left. And when he got out, and she drove away, she couldn't let it go. She got drunk, she hit him, she left him to die. It's that simple. We don't know exactly how this collision happened, but we have a good idea from the physical evidence, and we know that it happened. Can someone have a collision without lower body injuries? Could I have slide 19, please? You bet they can. We don't know if this is the body position. We don't know if this is the exact speed, but what it tells us, this is viable. Look at the debris field. Look at his turn. Remember his sneaker on that curb that got lodged against the sneaker? Mr. O'Keefe then falls back, hits his head, counter coup, left to die. Thank you. Ladies and gentlemen, there is no doubt what happened that night. There is no doubt who did it. You have a very difficult task ahead of you when you consider the evidence and you consider the law. Very difficult.
There are 3 charges. There is second-degree murder. Ms. Reed, when she chose to drive back at Mr. O'Keefe in that night with a 6,000-pound Lexus, in that anger, 75%, whether she meant to hit him or not, didn't mean to kill him, she hit him. Strengths, it is a plain and strong likelihood of death. You would never back down your driveway if your kids were at the end of the driveway. You'd say, well, you're going to kill somebody? You would never do it because you would expect, if you drove at them at that speed, that someone would die. That's second-degree murder. OUI manslaughter, she's drunk, she was reckless. She doesn't have to know she hit him. She doesn't even have to know she hit him. But she did. She did. And she left a man who was kind and generous and thoughtful. She left him alone. She left him alone to die. Could I have slide 22, please? He is not an it. John O'Keefe is not a body. John O'Keefe was not a buffalo on a prairie. John O'Keefe was a person, and he was murdered by Karen Reed.
There was no collision. There was no collision. There was no collision. I want to take a minute to start off with thanking you. I want to thank you for your attention. I want to thank you for your patience. I want to thank you for your diligence. This is not an easy undertaking. Most of all, I want to thank you for your courage, because courage is what this moment demands. Not just to listen, but to stare directly at injustice and say, not here, not now, not on our watch. That's what you're being asked to do. Stare down injustice. I want to start with a simple truth. You folks, not us, nobody else in the courtroom, you folks are the last line of defense. The last line of defense between an innocent woman and a system that has tried to break her, that falsely accused her, that tried mightily to bury the truth. This case was corrupted from the start. It was corrupted by biases and conflicts and personal loyalties that you heard about. And most fatally, it was corrupted by a lead investigator whose misconduct infected every single part of this case from the top to the bottom. In our opening comments to you a few weeks ago, we told you what to watch for. We warned you what to watch for. We begged you what to watch for. Watch for the physical evidence. Pay attention to the medical facts. Pay attention to the science and the physics. But also pay attention to the integrity, the very essence, the integrity of the investigation. But you also saw something during the course of the trial that none of us might have expected, something that should sadden us, something that maybe would anger us. On full display, you saw the lengths to which some police officers will go to protect their own at the expense of the rest of us, at the expense of Karen Reed, an innocent woman. Before we examine the evidence in the case, which we will do, we need to understand the very foundation of the entire system of justice in which we operate. It's the bedrock on which this entire system is built. Reasonable doubt. This isn't just a technicality, and it's not a slogan. It's a constitutional shield that protects the innocent and prevents the government from punishing without proof. The Commonwealth has the high burden to prove every single element of every single charge beyond a reasonable doubt and to a moral certainty. As I said, those powerful words are not just some legal jargon. They're your mandate, they're your obligation, they're your community's protection against injustice. In our system of justice, Karen Reed sits here today presumed innocent, cloaked in the presumption of innocence. That presumption is not fragile. It doesn't just disappear because there's a charge or a badge or a theory. That presumption stands firm unless and until the Commonwealth clears that high bar, the highest bar the law provides, proof beyond a reasonable doubt and to a moral certainty. That means at the end of this case, at the end of the trial, you think about one or more of the charges, you think, you know what, maybe that's true. It might be true. Then you vote not guilty. If you think it's possibly true or probably true, your vote must be not guilty. If someone among you thinks it's likely true or even very likely to be true, your vote is not guilty. It's because none of those standards, maybe, might be, possibly, probably, likely, very likely, none of those meets the extraordinary burden of beyond a reasonable doubt and to a moral certainty. A moral certainty means a level of confidence so strong, so incredibly unshakable, that you could go home, you would go home, look your loved ones in the eye and say, I am certain. Not probably, not likely. I'm morally certain, and my certainty remains unshakable. The law defines moral certainty as the highest level of certainty known in all human affairs. Think about that. You must be that certain about the entirety, not part of, the entirety of the Commonwealth's case. As we discuss this case, you'll see that the Commonwealth comes nowhere near, nowhere close to reaching that extreme burden of proof. Ladies and gentlemen, on January 28th, 2022, it was a Friday night. John O'Keefe and Karen Reed made plans to meet up with friends, go out for drinks. You saw through video evidence and eyewitnesses that they were affectionate, they were loving, they were in good spirits throughout that evening. They started off at C.F. McCarthy's, which you've heard about, and eventually made their way over to the Waterfall Bar and Grill. When they got there, the Albert family, they were already there, and they were already drinking. The Albert family, it's been established as a very well-known family in Canton. They've got quite the reputation. Brian Albert was at the Waterfall, a longtime Boston police officer. His wife, Nicole Albert, was there. She was with him. His brother, Chris Albert, who was a Canton board selectman, he was there. His wife, Julie Albert, their daughter, Caitlin, and his sister-in-law, Jennifer McCabe, whom you met, and her husband, Matthew McCabe, whom you did not meet. They were all there drinking before John and before Karen ever arrived. But also present at the Waterfall that night was Brian Albert's friend, Brian Higgins. We know that he had a romantic design on Karen. That becomes an incredibly important fact as we discuss the facts of this case. As the bar was closing around midnight, the Alberts invited everybody back to their house. They wanted to keep the night going. But the evidence revealed something interesting, that the invitation to John O'Keefe appears to have been for a different reason, an alternate reason. Think about the video of Brian Higgins and what Michael Proctor in his investigation completely and utterly ignored. Higgins was agitated after a day of drinking, agitated that it was John and not Karen, John with Karen, not him. Recall that ominous text that he sent to Karen with her and John standing just feet away. Well? He got no response. And then we see this. That's what Brian Higgins was confronted with following his well text. What of all things starts going through Brian Higgins' mind? Where does his mind go? What is he thinking about after seeing this, after witnessing this? He shows you. And if Michael Proctor had been the least bit interested, this video would have shown him too. Take a look. sparring, practicing, fighting techniques. Where was Brian Higgins' mind? What was he thinking about? And then what happens? Before you look at the next video, think about what you're going to see. This next video is after he sees John kiss Karen on the forehead, after he sends that aggressive text to Karen with her standing just feet away. Watch closely, and this is what you're going to see. This is what Michael Proctor and his investigation completely ignored. Higgins is very clearly upset. He's agitated. Chris Albert tries to control him, tries to talk to him, calm him down perhaps. Chris forcefully grabs Higgins' arm. You'll see that in the video that you're about to watch. It appears that Chris is trying to calm him down from something. Brian Albert's standing right there with the other two men, but Brian Higgins is having none of it. He appears to be hyper-focused on one person and one person only, John O'Keefe. In an instant, Higgins angrily jerks his arm away from Chris. Higgins rubs his brow, and he directly gestures at John. A gesture that looks a lot like, let's step outside. Let's go outside. But John looks at him, takes a swig of beer, completely ignores him. Take a look. Michael Proctor, the lead investigator in this case, had all this footage, but he did nothing. He had access to the exact same thing that you saw. Why did he do nothing? A few minutes later, Higgins then texts John directly. You coming here? 3 question marks. It's now 12:20 a.m. These guys are not good friends. They barely spoke or even acknowledged each other when they walked into the bar together, other than a quick greeting. So why was Higgins coaxing John over to 34 Fairview? You coming here after this? And why not text Karen? Because at that moment, he wasn't interested in Karen. He was interested in John O'Keefe. This is about 5 minutes before John gets out of the SUV and walks toward the house. About 5 minutes before Karen sees him alive for the last time. So what happened inside that house, or that basement, or that garage? What evidence was there for the investigators to look into? What did they ignore? Laceration over John's right eyelid, black eyes, a large dog at the home, an obvious dog bite on John O'Keefe's right arm, a head injury from falling backward onto a hard surface, alleged surface, a text from Higgins, one of the last people to ever communicate with John O'Keefe. You coming here? Those words now echo in the wake of John's death. But Michael Proctor, he didn't listen. When John didn't come back outside, Karen, very oblivious to what had happened, thinking she was just left alone in the car, out in the cold, in the middle of the night, she got frustrated and she drove home. She arrived back at home, and her Wi-Fi connected to her car or phone connected to John's Wi-Fi at 12:36 a.m. It's an important time, 12:36 a.m. She left John voicemail after voicemail after voicemail. He was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. Her voicemails reflect that frustration after the fact. That's the frustration that you hear in her angry voicemails. She uses harsh words and foul language. She's obviously upset. She's obviously irritated because he didn't come back out of the house and he wasn't responding. But Karen did not know what you know. She didn't know what the investigators should have known. She didn't know what was happening with Higgins and Albert and with her boyfriend, John O'Keefe. When he didn't come home, At about 5 a.m., Karen went looking for him in a panic. As you know, her worst fears were realized when she found John beaten, battered, bloody, and left in the snow in Brian Albert's front lawn. At 6 a.m., when Karen found John, you heard about the scene. It was described in detail. It was chaos. To use Mr. Brennan's word in his opening statement, it was bedlam. The screams for help by Karen, the yelling and the hollering, ambulances, emergency lights, fire engines, ladder trucks, paramedics, patrol vehicles, patrol officers, all of them swarming all over the lawn just under Brian Albert's bedroom window. And of course, as you learned during the course of this trial, Brian Albert, a sworn peace officer, a first responder trained in being a first responder, never came out of the house. Never went outside to help a fallen fellow officer who was laying on his own property. Never came out. And you learned through the undisputed evidence that the lead investigator, Michael Proctor, for his part, never went into the house. The Commonwealth has struggled to try to prove that John O'Keefe ended up in Brian Albert's front lawn because he was struck by a vehicle. They have failed. They cannot and they will not ever be able to prove that John was struck by a vehicle beyond a reasonable doubt and to a moral certainty, because the science does not lie, the medical evidence does not lie, the physics do not lie. Their investigation was flawed from the start because their investigator was corrupted from the start by bias, personal loyalties. Folks, they cannot prove a collision. John O'Keefe was not hit by a car. There was no collision. So let's start there. I want to take a minute to discuss the actual science, the actual physics, and the actual medical evidence that was presented in this case. The science, it's an old saying, is known as the silent witness. It doesn't lie, it doesn't forget, and notably, it doesn't take sides. If there was no collision, what are we doing here? In order for there to be a collision, there has to have been an impact site. The vehicle had to have struck John, period. I want to remind you of some of the most important testimony in the entire case, and it comes from the Commonwealth's own medical expert, Dr. Irini Scortibello, the Commonwealth's medical examiner, someone governed by law to make these decisions. We know that a person struck by a vehicle suffers massive trauma, broken bones, fractures, soft tissue damage, torn ligaments, contusions, soft tissue injury, severe tissue injury, crushing blows. None of that was present with John. None of it. Not anywhere on his body, including his right arm. Not one bruise. Nothing. The fact is, the injuries are not from a vehicle impact. Not his head injury, not those scratch and bite wounds. Not a single medical expert, think about this, not a single medical expert called by the defense or called by the Commonwealth has testified that John was hit by a car. Not one. Think about the irony. Not one. That's not just significant. It's literally the most important point in the entire trial. Listen again to Dr. Scortibello's words. Question. You did not include in your autopsy, in any fashion, any discussion of whether Mr. O'Keefe's injuries were consistent with a motor vehicle accident, did you? Answer. No, I did not. She told you, quote, I did not see any evidence of an impact site, end quote. She was talking about John's body. The Commonwealth's own medical examiner, Dr. Scortibello, performed the autopsy. She did it personally. She's the only one to have personally examined John's body, and she found no evidence of an impact site on his entire body. That in and of itself is reasonable doubt. You don't need anything more. The Commonwealth's case is done. It's cooked. Their own expert said there is no evidence of a collision, no evidence of an impact. If you want to know what an impact looks like, take a look at this. This is what a body looks like after being struck by a car at 25 miles an hour. And this is what a car looks like after hitting a person at 25 miles an hour. These are exhibits from Dr. Welcher, the Commonwealth's expert. John didn't even have a bruise. Make no mistake, Dr. Scortibello was presented with the Commonwealth's theory of the case, the same case that you've been presented with, and she refused to conclude that John's death was a homicide. She flatly refused to conclude that there was a collision. And you know who agrees with that? That silent witness, the science, the physics, the data. Dr. Wolf and Dr. Rentschler, you just met them recently. They explained they were not initially hired by the defense. They were asked by another agency to conduct their analysis. They looked at the evidence from both sides, not taking a side for the defense or the Commonwealth, completely independent. They looked at the damage to the SUV on the one side of the coin. They looked at the injuries to John O'Keefe on the other side of the coin. Both PhDs, both engineers determined there was no collision. I'm not saying it. The science says it. That SUV's taillight was not damaged by striking an arm, and John was not struck by a 6,000-pound SUV. Period. Full stop. Dr. Dan Wolf did the testing on the taillight. Actual testing, not some ridiculous blue paint kindergarten project. He did lab testing. He did field testing. He did data testing. Actual impact force analyses. In every single test at every single speed, the taillight damage was inconsistent with striking an arm. In every test, the taillight damage was inconsistent with damaging the shirt, the sweatshirt. Remember that severe internal damage to Karen Reed's taillight. Not just the outer lens. The internal diffusers were completely smashed, completely shattered. ARCA testing established that all the internal components of every single test taillight, especially the diffusers, remained completely intact. Conversely, on Karen's taillight, the diffusers were almost completely gone. Folks, understand something. If any part of that diffuser portion of the taillight is broken, there is no light. It doesn't illuminate at all. It's just black. Let's take a look at a couple of photos. At 5:07 a.m. at One Meadows, that's the photograph on the left. What do you notice about the right taillight? It's completely illuminated. Later, at 4:12 in the afternoon, photograph on the right, it's lit up. How can that be? How can that be if the Commonwealth claims that those diffusers, the portion that lights up the light, were already scattered all over 34 Fairview? That's their theory. But don't believe your lying eyes. The taillight's completely lit up. That would be impossible. Dr. Andrew Rentschler, a PhD, a biomechanist, explained that at those speeds, the other side of that coin, John's arm would be basically destroyed. Contusions, swelling, torn ligaments, hyperextensions, dislocation of joints and bones, fractured, broken, and shattered. But as you know, John's arm was pristine, save those dog and claw bites. He didn't even have a bruise. Think about this. Think about that photo of those x-rays as you deliberate. You can manipulate a taillight fragment. That's not that hard. You can't manipulate a bruise. If they claim the car was going fast enough to shatter the taillight and shatter the diffusers, then it was also going fast enough to destroy and shatter John's arm, and it simply did not. How do they square that? They don't, and they can't. So they spent nearly $400,000 of taxpayer money to hire someone to dress up and look like John and paint his arm blue, which told you exactly nothing. The ARCA testing, conversely, also established that it is impossible for John's sweatshirt sleeve to be damaged by an impact with the taillight. The Commonwealth's theory is that the sleeve of John's hoodie sweatshirt was damaged by flying shards of taillight slicing through the shirt and through John's arm. I have 3 questions. Number 1, John's arm had about 36 abrasions. How did 36 shards of acrylic go through 9 tiny little puncture holes? How'd that happen? Somebody needs to answer that. Number 2, why are there no slices or cuts in the hoodie? All the defects are punctures. Punctures that you might get from, say, I don't know, canine teeth. And number 3, if the shards cut bloody gouges into John's arm, that's their theory, why is there no blood, no skin, no tissue on a single shard of taillight that they claim came in contact with John's arm? The Commonwealth cannot answer a single one of those questions because John's arm was not impacted by the taillight. It doesn't make sense simply because it didn't happen. Compare and contrast the ARCA experts and their actual testing to Judd Welcher. He came to you in the Commonwealth's case in chief, and he told you that for the better part of $500,000, he'd come in and testify that John was tall enough to touch the taillight with his elbow. That's it. And even in that basic demonstration, he had to lean in to manipulate it, to get the results that he wanted. Dr. Welcher then claimed that the reason he didn't do the reconstruction, the actual testing, think about what he said. There isn't enough evidence to determine what happened. I beg your pardon? What happens when there isn't enough evidence, in his words? You vote not guilty. That's what happens. That's out of his mouth, not mine. The Commonwealth also used the same company, Aperture, to try to establish a time of a collision that never occurred. The Commonwealth called Shannon Burgess, the supposed expert from Aperture. There is a cardinal sin for experts, folks, a cardinal sin. It's called confirmation bias. It's when you decide to change your opinion to fit a theory. The most important takeaway from Shannon Burgess' testimony was how brazen, how shameless he was in trying to change the data to try to suit the Commonwealth. Remember Mr. Brennan's opening statement. He made some promises to you. He said, this case is about the data. He stressed it over and over again. They've had 3.5 years to get this right. The Commonwealth has had this case for 3.5 years to get it right. So his top expert, Dr. Welcher, prepares a report. And that report says that John O'Keefe was struck by Karen Reed's SUV at 12:31:38. Note that time, 12:31:38. He was struck, he was immediately incapacitated, he was immediately unconscious. So says Judd Welcher and the Commonwealth's theory. But there was a huge, huge problem with that. And somewhere in the middle of trial, somebody must have realized it. They must have realized that the very data they produced unequivocally establishes that they are wrong about a collision. It could not have happened. Why? Because John was interacting with his phone after 12:31:38. Remember, the collision immediately incapacitating. How could he be interacting with his phone afterward? He was on his phone, opening his phone, checking his phone, reading texts on his phone, and locking his phone, all of it after 12:31:38, which is the time Welcher clocked for the moment of the impact. And he was taking steps and walking with that phone after 12:31:38 also. That's what their own data showed, and it devastated their case, and it devastated that false theory. There must have been panic, I'm guessing, in the room. What do we do now? The data shows John wasn't struck by the car. What do we do? Enter Shannon Burgess. Question. Can you believe him? Can you believe Mr. Burgess? He came up with a brand new story right in the middle of trial. You might ask yourself, would an expert actually say something he knows not to be true? Would an expert actually say something he knows is not supported by fact? Would an expert shade the truth? You don't have to look any further than Shannon Burgess's CV to answer that question. That was a shame. Even with the pull and push and stretch and manipulation of the time data that Mr. Burgess came in here and told you about, it still shows that John O'Keefe was very much alive and walking around after they claim he was hit and incapacitated. Think about that. Matt DeSogra looked at Burgess's report and told you that in 30 out of 30 scenarios of the possible time skews that Shannon Burgess identified. He came in the middle of trial and identified all these other time skews that he called it. In every single scenario, John was alive and walking after they said he was hit. And that's a problem for them because there was no collision. Just look at Mr. Whiffin's data, Ian Whiffin. John O'Keefe took 31 steps at a steady rate, about 83 feet, and then think about this, in a westerly direction. That would be right toward the house. Remember, it's 78 feet to that garage door. That's not a coincidence. The Commonwealth's witnesses, or the Commonwealth's witness, Mr. Ian Whiffin himself conceded that he has reasonable doubts about the accuracy of John's location data. You remember that question and answer on cross-examination by Mr. Alessi. Do you have doubts? I do. Are those doubts reasonable? They are. And remember, it's still the Commonwealth's burden. If their own cell phone expert has a reasonable doubt about John's location, so should you. John O'Keefe was inside, and the phone battery temperature further proves it. This is not speculation, this is science, and it's irrefutable. It tells us that he was not laying outside in the cold, he was inside somewhere a little bit warmer. Ian Whiffin told you that when the iPhone is exposed to freezing temperatures, think about these numbers. When the iPhone is exposed to freezing temperatures, it will drop from 81 to 21 degrees in 15 minutes. 15 minutes. That's a 60-degree drop in 15 minutes. Now look at John's phone. It was laying, according to the Commonwealth, it was laying directly on frozen ground. He arrived at 34 Fairview and his phone dropped only 20 degrees over the course of an hour. Then inexplicably, it stayed steady, never dropping below 50 degrees for the next 4.5 hours. Never dropping below 50 degrees for the next 4.5 hours, basically through the entire night. He was not outside. He was someplace warmer, like a basement or a garage. Dr. LaPosada confirmed that John O'Keefe did not have hypothermia. No telltale signs, no telltale Wisniewski spots, no frostbite on any extremity. He did not die of hypothermia because he wasn't outside. Dr. Isaac Wolf, Dan Wolf, Elizabeth LaPosada, Judson Welsher, Andrew Rinchler, all agreed. Every expert agreed. This is how John O'Keefe died. A rearward fall from a standing position. What could make you fall straight back like that? Let's just think about that for a second. What could make you fall from a standing position as Judd Welcher just showed us? Standing up, falling straight back. Add a laceration to the right eye consistent with a fist or a punch, and you've got your answer. He certainly didn't sustain that wound on the back of his head by falling backwards onto a lawn. Dr. LaPosada told you that the patterned injury on the back of John's head could only be produced by hitting a hard, ridged, or ledged surface, like a concrete stair or step. What's just through that garage door? Michael Proctor never stepped down in that garage to find out. What a shame. And look at the arm. Just look at John's arm. You don't need the top experts in the country, but you had them. You don't need the top medical minds on the planet on this issue, but you had them. These are dog bites and scratches. These are animal wounds. Not one witness has been called in their trial. Not one. 8 weeks and counting. Not one witness who actually disputes that John O'Keefe's arm injuries are from a dog. The Commonwealth could not find a single medical expert, a single medical witness who would come in here and tell you those are inconsistent with a dog bite or a scratch. And it's equally clear that there was no collision. Dr. LaPosada told you in probably the clearest voice in the entire trial. You remember her testimony. He didn't get hit by a car, in her words. He just didn't get hit by a car. You'll remember the question that was posed by Mr. Brennan, did you consider the speed of the vehicle? And she said, speed didn't matter, because he didn't get hit by a car. She repeated it 3 times because it's true, not just because she says so, but because the medical evidence proves it. The medical science proves it. There was no collision. Dr. Rentschler told you unequivocally and just as firmly he didn't get hit by a car. The Commonwealth has not met their burden. They cannot meet their burden. The Commonwealth hasn't called a single medical professional, not one, to testify that John's wounds came from being hit by a car. Not Dr. Scorti-Bello, not Dr. Isaac Wolf. Contrast that with the caliber and the quality of the experts who came in here to tell you what is obvious to anyone with common sense. Those wounds on his right arm are from a dog. This was not an oversight by the Commonwealth. It's just that there is no one out there. No matter how big a check you write, there's not a medical expert who's going to disagree with that. The fact is, this is the central fact in the case. The only fact that matters is literally uncontested by every medical expert. Uncontested, undisputed. There is no evidence that John was hit by a car. None. How much more reasonable doubt could there be? This case should be over right now. Done. Because there was no collision. So given all that, how did Karen Reed end up sitting here? Why is she even here? Why is she in that chair? Why is she in this courtroom? There is a reason for that. And it's a reason they don't want to tell you, and it's a reality they don't want to admit to. The reason we're here is because the system, the very system that was meant to protect her, that was meant to protect all of us, that system has failed badly. So now let's discuss the facts that were and were not presented by the Commonwealth in this case. Over the next few minutes, I want to talk about the utter failure of the police to investigate this properly and to investigate this fully. And what you're going to see is that Michael Proctor, the lead investigator for the Commonwealth, did nothing to actually and properly investigate this case. Let's start with the house. That's the most logical place to start. I think you'd agree. Brian Albert's house, where John's body was discovered lifeless in the lawn. A man, a police officer, is found dead on the front lawn, and no one secures the scene. No tape, no preservation of evidence, no crime scene log, no search warrants, no consent searches, no photographs of the house interior. They didn't treat the house as a crime scene, and shamefully, they didn't even treat the yard as a crime scene. The lame excuse offered by retired Lieutenant Gallagher, it was really cold and windy, and I didn't know if there was a crime that had been committed. What? You didn't know that a crime had potentially been committed? You have a man laying dead in the yard, and here are the undisputed facts that those officers were confronted with. Black eyes. Obviously, black eyes are consistent with a fight. Bloody nose, also consistent with a fight. Bleeding from the face, consistent with a physical altercation. A cut over the right eye, consistent with a punch. No coat in the freezing cold, not dressed for outside, dressed for inside, and one shoe on. I wonder where the other shoe could be. I don't know, maybe in the house 30 feet away. And then you find a broken and shattered drinking glass next to him, the type of glass that you might find, I don't know, let me think about this, in a kitchen, in a house, 30 feet away. And John's phone was tucked neatly under his back shoulder. Lieutenant Gallagher actually claimed he did not know it was a potential crime that needed investigating. The neighbor across the street, Detective Lieutenant Kelleher, had a ring camera that was pointed at the exact direction where John O'Keefe would have been hit, and nobody bothered to secure it. Nobody bothered to secure it. Nobody even bothered to look at it. Of course this was a potential crime scene. Of course it was. Let's not forget, this was Brian Albert's house, and that comes with privileges. Quote, is the homeowner going to catch any shit? Nope. He's a Boston cop too, end quote. That quote starts to make a little more sense now, doesn't it? Michael Proctor wrote those words just hours after John's body was found. He sent this in a private chat, in a private text he never, ever believed would ever be revealed. He sent that text in a series of messages that now belong to you. You weren't given the opportunity to hear from Michael Proctor, but you can read his thoughts for yourself. And I urge you, go read them. They're in Exhibit 209, in case you're wondering. But here are the highlights. Proctor starts the conversation, quote, all the powers that be, one answers ASAP. He's getting pressure, obviously. Get this done. His friend then asks what Proctor's probably thinking at the time. Quote, I assume you guys are out to make it cut and dry since it involves cops. Something stinks. And Proctor responds, yeah, to the something stinks. And then he goes on, but there will be some serious charges brought on the girl. Think about that. Hours into this investigation, there will be some serious charges brought on the girl. She's a whack job cunt. Yeah, she's a babe. Weird Fall River accent, though. No ass. No ass bitch. She's got a leaky balloon knot. Leaks poo. 0 chance she skates. She's fucked. And up to this point, Michael Proctor had done 0 investigation. Nothing. Save talked to a grand total of 3 people, all of whom were named Albert or McCabe. That's it. And this was his mindset. This is the same lead investigator who sent the group chats that you heard about with Sergeant Buchnick. Late night, sitting at his office, rifling through Karen's phone, bragging about looking for naked pictures of her. That text wasn't sent to his buddies or his friends. That text was sent to his supervisors at the Massachusetts State Police, for God's sake. And what was their response? Sergeant Buchanan liked this conduct with a big old thumbs up. He encouraged it. Ladies and gentlemen, a lead investigator is every investigator is supposed to be objective, an objective fact finder. No bias, no agenda. Michael Proctor went far beyond just insulting Karen Reed. He dehumanized this woman. He betrayed her as a human being. He was fired for this blatant bias. If the Massachusetts State Police can't trust him, how can you trust him with this investigation and with your verdict? And with Karen Reed's life. The lead investigator in a murder trial was never called to testify. Think about that. That should stop you in your tracks. Wouldn't you want to hear from Michael Proctor? Wouldn't you want to hear from the lead investigator in the case? Don't you have questions? The Commonwealth did not present their own lead investigator to the jury, the very jury who is charged with judging the investigation. Michael Proctor clearly is radioactive, and the Commonwealth stayed away from it. Michael Proctor is no longer a Massachusetts State Police officer. He wasn't transferred. He didn't go on sabbatical. He didn't retire. He didn't resign. He was fired. He was terminated for cause. The Massachusetts State Police investigated him, found him guilty of dishonorable conduct, not just for those text messages, folks, for sharing confidential information with witnesses, and for bias. Not just any bias. Bias in this case. Fired. This is the man who touched every single piece of important evidence in this case. All the evidence that was brought before you in this trial went through his hands one way or another. The shirts, the shards. Remember that when Mr. Brennan gets up and gives his closing argument. The shirts, the shards, all in Michael Proctor's possession. Mr. Brennan and the Commonwealth, I think, have pinned their hopes on some microscopic pieces of, or close to microscopic pieces of plastic. that were claimed to have been scraped from the hoodie several months after the fact. What he failed to ask every single every single witness, is who had access to that shirt and who had access to those taillight fragments, and the answer is it was Michael Proctor. Not for days, not for weeks, for months on end, for months unaccounted for, before they were submitted to the crime lab, before they were ever scraped. Just go look at the chain of custody documents. You've got them. Why didn't Michael Proctor give those clothes to Maureen Hartnett with the crime lab when she was at Canton PD just days after the fact to receive those Solo cups? Remember that? Just a few days later, she was there. She drove up. She did the driving to take the Solo cups in the grocery bag, which has a ridiculous aspect to it in and of itself as well. Why not just give her the shirts as well? Give her the taillight fragments if any were found at that point. Why hold on to them? What could possibly be a reason? Why wait until March to book those into evidence? Now let's talk about some of the other problems with the Commonwealth's evidence. As I indicated, there was no blood, no skin, no tissue, no DNA found on a single piece or shard of the taillight that the Commonwealth claims cut and sliced into John O'Keefe's arm. Where is that trace evidence? Where is that biological evidence? The DNA. Where is it? They've got nothing. Not a single piece that the Commonwealth wants you to believe cut up John's arm. How is that possible? It's not possible. The only way it's possible is if those shards never touched his arm. Because it was a dog. Oh, and the one sample of DNA that they did find, by the way, was found on the outer, smooth part of the housing. Not any shard. It was the outer, smooth part of the housing. Nothing that they claim actually came in contact with John O'Keefe. Number two, that sample had DNA of two other men, two other unidentified males. That tells you that that DNA had nothing to do with a car strike. That DNA would be expected to be, John's DNA would be expected to be all over that car. Inside, outside, he had access to that car for months and months and months. He was in and out of it all the time. Show me some blood, then we'll talk. They can't, and they won't because it doesn't exist. That SUV never hit John. The hair found on the bumper. The Commonwealth really stretched its own credibility on this one. That magic little hair on the SUV supposedly survived a 37-mile drive in 47-mile-an-hour winds. But that little magic hair just clung there, just hung on. That same hair that moved in between photos in the Sallyport. Remember that? There were two photos taken, and it was either the breath of the photographer or just the movement of walking by the hair. It literally moved between the two photographs. But that hair is supposed to have hung on in a 37-mile drive in a blizzard? The only thing that hair proves that the Commonwealth is embarrassingly grasping at straws. That hair has nothing to do with anything. But it doesn't stop there. There was another revelation at trial, a big one, a huge one, and it came from a very unlikely source. Christina Hanley, the quiet, reserved criminalist who told you something the Commonwealth likely did not want revealed because it's devastating to their case. Absolutely devastating. And it's this. The glass on the bumper didn't match the cocktail glass. None of it. Remember, February 11th, Michael Proctor, without any other person with him, no witness, no supervisor, no other person with him, claims to have found a single piece of glass at the scene. February 11th, single piece of glass, Michael Proctor. Keep that in mind. Interestingly, the glass on the bumper that didn't match the cocktail glass, one piece did match one other thing. The Proctor glass. Those two go together. The only two things that go together from that bumper are the Proctor glass. We know that there's no glass in the taillight. We know that nothing else was shattered on the vehicle. Therefore, that glass had to be placed there. Didn't come from a crash. Didn't come from a cocktail glass. So how did it get sprinkled on the back of the bumper? Whose proverbial fingerprints are on that glass on the bumper? The only thing it matched was Michael Proctor. What about the Ford Edge and that snowplow driver, Brian Loughran? He observed that Ford Edge parked outside Brian Albert's house at 3:30 a.m. that vehicle was moved directly in front of where John's body was found sometime between 2:30 and 3:30 in the morning. The only person connected to a car of that make and model, Brian Albert. Michael Proctor did nothing to investigate that point. Did nothing to investigate whose Ford Edge was parked in a spot specifically to block the line of sight in the exact position where John's body would be later found by Karen Reed. No one, not Michael Proctor or anybody else, checked it for evidence. No one even asked any questions about it. That Ford Edge, Brian Albert's Ford Edge, completely ignored. Michael Proctor failed to interview obvious witnesses in this case. Why? Why didn't he want to speak to the snowplow driver, Brian Loughran? Why did he falsely claim that no one plowed the roadway that morning? When police dash cam video, you saw the dash cam, it shows plows going back and forth all morning. Why did he wait so long, years even, to interview Heather Maxson and Ryan Nagel, individuals who were literally outside 34 Fairview at the exact same time John and Karen arrived at Brian Albert's house that night? Brian Loughran, had he been investigated or interviewed, would have told Michael Proctor that he drove past the lawn multiple times on January 29th, and there was no body on the lawn. He would have had a perfect view. Remember, the weatherman told you there was only enough snow at that time. I think he said, in a very charming phrase, only enough snow to track a cat. I think that was it. There was no body there. Heather Maxson and Ryan Nagel would have told him that they arrived at 34 Fairview shortly after Karen and John pulled up behind them, and they would have told Michael Proctor, at least Heather would have told Michael Proctor, that when she left 10 minutes later, she drove past the SUV and observed Karen Reed in the driver's side, dome light on, passenger seat empty. So where was John? He wasn't outside, wasn't sitting down, wasn't laying down. There's only one place he could be. We could all say it together if you could talk with me. He was in the house. But Michael Proctor did not want to have those answers. He did not want to have to disclose those answers. He didn't want the truth. The Commonwealth hasn't presented a shred of evidence of when Karen Reed consumed her last drink that night. Think about that. It's critical information that the Commonwealth has to prove beyond a reasonable doubt and to a moral certainty. They have to prove when her last drink was that night. They have to prove it. We don't have to prove or disprove anything. Every single witness who was asked and who had an opportunity to observe Karen that night said the same thing. She wasn't drunk. She wasn't stumbling. She wasn't slurring her words. She was, in the words of Ms. Kolakithis, completely normal. Even Jennifer McCabe, grudgingly, had to admit that fact. It's on video. Instead, they used Yuri Buchanan to try to come into court and count sips of alcohol, which he admittedly got wrong. According to Ian Whiffen, the Commonwealth's own expert, the location data, using location data on John's phone, showed Karen driving lawfully. She was driving safely. She was under the speed limit. She was slowing and stopping at stop signs, slowing around corners. And Ryan Nagel corroborated that when he saw her make that left-hand turn onto Fairview. The Commonwealth has an incredibly high burden to prove that Karen was driving under the influence. They have failed to prove that beyond a reasonable doubt and to a moral certainty because it depends on when she had her last drink. What happened after she got home and she was upset with John for not coming back out of the house? That would answer that question. As you well know, no one searched the house for signs of a struggle. Not that night, not the next day. I'm talking about 34 Fairview. Not ever. Not once. Not with a warrant, not with consent. They never went into the basement, the stairwells. They didn't look at the walls. They didn't look in the garage. Nothing was ever examined. Nothing was checked for blood. Nothing was checked for DNA. They didn't look for a ledged or ridged surface. Zero. You'll remember how surprised Jennifer McCabe was to recall that there was a garage door even on the house. Except this was her sister's house. She's been going to that house since she was 5. She's seen that house. She's been in and out of that house hundreds of times, maybe thousands of times. She's been going to that house her entire life, and yet she acted surprised when I asked her about it. Remember Jennifer McCabe's answer when I asked her whether there was a door to the garage. I was asking her about the front door, the side door, and the garage door. And her answer was, oh, actually there is a garage door right there. Investigators never opened that door. Let's change the scenario. What if it wasn't the house of a Boston cop? What if it wasn't the house of Brian Albert? We can be certain that investigators would have torn that house apart to get answers about why a fellow police officer was laying dead on the homeowner's lawn. You can betcha. But because this was Brian Albert's house, a Boston cop, nope. And because he was a fellow cop, an insider, they didn't even open the door. That is not justice, folks. That's just pure favoritism. Each of these facts is more than a question mark. They're failures of duty. They're blank spots on a map where justice is supposed to live. And every single one is a reason why you cannot convict Karen Reed. Reasonable doubt abounds. If the Commonwealth failed to investigate every reasonable alternative, how dare they come in here and ask you for a verdict? They didn't investigate the case fully, and yet they're asking you to take the easy road and do their job for them. These facts do not represent reasonable doubt. Nothing does. Every one of these facts that you're seeing that we're talking about represents reasonable doubt. Every one. The police and the prosecution are in a position to take people's liberty. It's the most dire and consequential act a civilized government can take against one of its citizens. Their obligation is not just to try to get it right. They have to convince you to the highest degree of certainty known in human affairs. They have to do it all, every bit of it, beyond any and all reasonable doubt. And they have not done that here. And how about the homeowner himself? The host, the first responder, the Boston cop, Brian Albert, who was sparring and practice fighting with Brian Higgins just minutes before John O'Keefe appeared at his house, 34 Fairview. Brian Albert, who was watching Chloe that night, the German Shepherd. Brian Albert, whose phone and his wife's phone were never secured. Brian Albert, who never came out of the house. But that doesn't mean he wasn't awake. It doesn't mean that he wasn't on his phone. Think about this. Jennifer McCabe claimed that her sister and Brian Albert both slept through this complete chaos right outside their bedroom window. But Jennifer McCabe's phone records tell a different story, and they tell the truth. She spoke with them for the better part of a minute, 38 seconds to be detailed about it, at 5:07 a.m. And then she lied about that call. Remember that? What was the reason for that call at 5:07? Was it panic? Was it a warning? We know that conversation took place at the precise time Karen left her house to go search for John, 5:07. We could answer those questions if we just had access to their phones. Brian Albert, Brian Higgins. But Michael Proctor wasn't interested in their phones. Not only did he not secure their phones, he never even asked. And what about Brian Albert's dog, Chloe? A dog with a history. A dog that is, quote, not good with strangers. Dr. Russell confirmed that John's patterned injuries were from a dog, just like the dog Brian Albert owned. And then Chloe just disappeared. Not there the next morning. None of the officers that you heard from said that there was a dog in the house. They didn't see her. She was just gone. And then ultimately gotten rid of altogether. Who gets rid of their family pet? Unless they had something to hide. Michael Proctor wasn't interested in that either. And recall the group chat with the Alberts and the McCabes. They were getting their story straight. Matt McCabe, whom the Commonwealth did not call in this trial, instructed the group in that group chat, you'll recall, tell him to say the guy never came in the house. Think about that exact quote. Tell him to say the guy never came in the house. And Brian Albert, the patriarch of the family, exactly, exclamation point. He blessed it. With the truth, as we all know, you don't need to get your story straight. You don't need to tell someone what to say. It's just the truth. And what about the Google search? A Google search that Jennifer McCabe admitted having made. A Google search that was time-stamped by Celebrite at 2:27 a.m. A Google search that read, "Haas Long to die in cold." It is uncontested and undisputed that that search was deleted. If the 2:27 a.m. timestamp is not true, why does Jennifer McCabe have to lie about it? Why delete it? If the 2:27 a.m. timestamp is not true, why create a false story about Karen screaming Google hypothermia? That's just a fabrication. That's just a made-up fact. And by the way, if someone does tell you Google hypothermia, why would you Google how long it takes to die in cold? Wouldn't you just Google hypothermia? Jennifer McCabe enlisted Carrie Roberts to help shift the blame to Karen. Why go to that much effort unless you're trying to cover for something? Keep in mind the entire foundation,
Will the deliberating jurors remain standing? Defendant remains standing. All other parties may be seated.
Your Honor, may the record reflect that 12 deliberating jurors and 6 alternates are present.
Yes.
May I inquire?
Yes.
Mr. Foreman, members of the jury, have you agreed upon a verdict? Yes. Thank you. May I see the papers? Mr. Foreman, have the verdict slips been placed in this envelope and have they been in your presence ever since? Yes. Mr. Foreman, on docket number 2282CR117001, murder in the second degree, what say you? Is the defendant at the bar guilty or not guilty?
Not guilty.
So say you, Mr. Foreman? So say you? No. Do you agree?
Yes.
Do all of you agree?
Yes.
Thank you. 002, what say you? Is the defendant at the bar not guilty or guilty?
Not guilty.
Of?
Is not guilty or guilty of that charge or any lesser included charge? Thank you. Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with a blood alcohol level of 0.08 or greater. Correct?
Yes.
So say you, Mr. Foreman?
Guilty.
So say you all?
Yes. Guilty.
003, what say you? Is the defendant at the bar leaving the scene after accident resulting in death? Is the defendant not guilty or guilty?
Not guilty.
So say you, Mr. Foreman?
Yes.
So say you all? Jurors, hearken your verdict as the court records that you upon your oath say the defendant on 001 is not guilty, on 002 is guilty of operating under the influence of liquor, and 003 not guilty. Thank you.
All right, jurors, everybody please be seated. Jurors, we thank you for your service. We're going to send you back. Your service is complete. I'd like to come back and talk to you for a little bit afterwards. So thank you very much.
All rise. Jurors, follow me. Media, please exit the courtroom immediately.
Karen Reed?
Not
yet.
Tony,
Hold on,
not yet.
hold on,
Not
everyone.
yet.
Karen Reed. Ms. Reed, can I have your attention? As required by statute, I must inform you that the records regarding the charges that you have been found not guilty will be sealed by the Commissioner of Probation by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want these records sealed. To request that these records not be sealed, you may use the Request Not to Seal form, which is posted on the trial court's website on mass.gov. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. Please be aware that if the records regarding the charges which you have been found not guilty are sealed, You will be unable to access the sealed record of the not guilty dispositions or any other records regarding those charges. If you want copies of any documents regarding those charges before the records are sealed, you should request copies from the court within 10 days. Do you understand? Thank you.
All right, so we need a date for sentencing. Can we do it next week?
Ken, we would be prepared to go forward today.
Okay.
Perhaps we could approach sidebar briefly.
Okay. All right, so Ms. Giannetti, you're ready to go forward today as well?
Yes, please.
Okay, Mr. Brennan, what's the Commonwealth's recommendation?
Your Honor, the Commonwealth moves for sentencing. We recommend a probation, 1 year, 24D program.
So the standard that everybody else gets on their first time OUI?
Certainly.
Okay.
We ask that she be treated no differently, no better.
So I'm happy to do it. All right, thank you all.
1 year probation, 1 year probation on docket number 002, the lesser included offense of operating under the influence. 1 year probation. Thank you. The 24D program is. Thank you.
All right.
Goodbye.